Good morning, everyone. We're officially getting started. I'm going to make sure this is on. It is. Thank you to our media team. And thank you all again so much for being here. Today, we are holding a hearing on the use of artificial intelligence in the private sector, focusing on its use in high-risk contexts that we can have serious impacts on the lives of consumers here in New York. In today's hearing, we will be receiving testimony from representatives from labor, industry, academia, advocacy, and the community on their perspectives on these uses of AI. I expect that there will be a broad range of opinions on this technology. However, I believe that there is common ground between myself and every witness we will hear from today. We all agree that AI is dramatically transformative and holds immense potential. I believe AI can and should benefit our society, but that is not possible without clear partnership between industry and government to put the appropriate guardrails in place. That is why we introduced the New York AI Act. Over the last few years, we have seen a rise in reports of these tools being deployed in high-risk contexts. When they don't work as intended, real harms can materialize. Some recent examples include a lawsuit against Workday, an HR software company, for alleged discrimination in its resume screening tool. The lawsuit was recently certified as a class action with potentially millions of affected job applicants. The main plaintiff is a disabled Black applicant over the age of 40 who was consistently rejected from postings before a human could have ever reviewed his application. AI harms can be more than just job denials. They can be life or death. Other recent examples include AI-powered chatbots designed to maximize user engagement, forming intimate relationships with end users. Reports have shared conversations that have guided vulnerable users and minors towards engaging in self-harm, and in some cases, taking their own lives. Until we live in a society where we can all recognize that these are serious harms that must be addressed, AI will never reach its promise or potential as a beneficiary tool. These conversations will help us identify how we can address these risks and move this industry in a safer and more responsible direction. I want to thank my colleagues for joining us today. Today we're joined by the assembly sponsor of our New York AI Act, Assemblymember Szilagyi, alongside my incredible colleagues, starting from my right to my left, Senator Brisport, Senator Hinchey, Senator Liu. We'll also be joined by additional colleagues later in the day. And with that, I actually want to turn it over to our assembly member for some opening remarks on the bill, and then I'll go into some housekeeping. Thank you.
Let me start off by expressing my heartfelt appreciation to Chairwoman Gonzalez and the members of the Senate Committee for their partnership and leadership on this issue. I also want to thank all the witnesses today and the advocates gathered here for this robust conversation. We gather to discuss and answer a simple question. As artificial intelligence becomes more embedded in our everyday decision-making, how do we ensure that it works fairly for every New Yorker? AI is already shaping so many decisions, and these tools can improve efficiency and expand opportunity. But when left unchecked, they can replicate bias and scale discrimination faster than any human process could ever do. That is why New York must lead. Today's hearing is about getting it right. I look forward to hearing the testimony on how we can protect New Yorkers, support responsible innovation, and set a national standard for ethical use of AI. So again, thank you everyone, and thank you, Chairwoman.
Thank you so much, Assembly Member. Now, very quickly, we have a long day, so I'm going to do a quick round of housekeeping. We have 6 panels, so we're going to try to keep to time as much as possible. For each panel, we'll have oral testimony. I'll introduce the panelists, then turn it over to them for their testimony, for which you'll have 5 minutes, and then we'll open it up to questions. I will kick off questions, but then turn it to my colleagues for 3 to 5 minutes in the first round, depending on the panel, and then an additional 3 minutes for round 2 of questioning. I also want to flag that logistically, we've been warned that we do have a loud beep that happens when we're out of time. So just for everyone's awareness, don't be alarmed when you hear the beep. And then once all legislators have completed their questioning, the remainder of the time for each panel will be taken back if we do have some additional questions. But ultimately, I think we're going to just try to stick to the 2 rounds that we've agreed on, and then move through the panels one by one. So with that, I'm really excited to open up our first panel, which is labor. I do want to make a note that we intentionally chose labor to be the first panel because as I've chaired this committee over the course of the last few years, labor has been our closest partner. We passed 2 bills on public sector use of artificial intelligence and specifically protecting government workers from automation. We did that with the Public Employees Federation. We did that with the AFL-CIO because we understand that a positive vision for artificial intelligence comes from the workers and from unions defining that vision alongside us. So I want to give a deep and heartfelt thank you to our first panel and our panelists. We are joined today by DC 37, Odette Tineo, as well as Mia McDonald from the Communication Workers of America. I'm going to invite you to share your opening remarks, and we'll start with Mia and then move to Odette. But thank you so much. Thanks.
Great. Thanks, everyone. Is this on? Okay,
Yes.
great. Thank you so much, Chair Gonzalez and the whole committee for the opportunity to testify today. I'm Mia McDonald, Deputy Legislative Director at Communications Workers of America, District 1. We represent 145,000 workers in 200 CWA local unions in New York, New Jersey, New England, and Eastern Canada. Our members work in telecommunications, healthcare, higher education, manufacturing, broadcasting, cable television, commercial printing and newspapers, as well as state, local, and county government. So as you can imagine, AI is impacting our members in a lot of different ways, and we have a lot of concerns about that. And so we really thank the committee for hosting this hearing today, and especially for recognizing the importance of hearing directly from labor organizations on this issue. It is our strong belief that government policy should support collective bargaining and worker consultation in the adoption of AI and other emerging technologies, and aim to strengthen and complement workers' bargaining power with baseline policy protections for all workers. Workers are the experts on their jobs and workplaces and are really best positioned to identify those risks and guardrails needed. There are a few key areas where we're concerned about the increased use of AI in the workplace. That's monitoring, so audio and video surveillance, tracking keystrokes, mouse movements, managing, so coaching, job assessment, scheduling, hiring, for example, reviewing resumes, administering applications, and then performing complex tasks with little to no human oversight, which we've seen can create stressful conditions and has the risk of eliminating certain tasks and ultimately entire jobs. Our members across the district have shared with us anecdotal evidence of these risks. In call centers, AI is used to monitor and give feedback on call flow and tone, transcribe and summarize calls, man chatbots, and recruit and hire. Our outside technicians are under surveillance by GPS monitoring and metric tracking. In hospitals, our members have raised concerns around diagnosis, decision-making, and insurance coverage automation, uses that we know can have dire impacts both on healthcare workers and their patients. And lastly, our News Guild members are increasingly concerned about their job tasks being replaced by AI. Notably, recently after mass layoffs at Business Insider, they announced, right after they did these mass layoffs, they announced that they are fully embracing AI and launched an AI byline with the goal of drafting news stories to bring readers more information more quickly. So again, like I said, in addition to the bargaining we're doing on our contracts, we think legislation is critical in ensuring that there are these baseline protections against abusive use of these digital technologies. And in particular, we're focused on protections against harmful surveillance and automated management, which we believe should include policies that address a number of things. One, protecting workers from abuses under automated employment decision systems. Two, protecting workers from abuses under electronic surveillance and automated management. Include strong transparency requirements, which we think is a good starting point for accountability, job security for workers in specific sectors, requiring notice and retraining for displaced workers, and then lastly, protections against bias and discrimination tied to AI, which you mentioned in your opening. We know that there are a lot of different examples of legislation that have been introduced, including by the senators on this committee and assembly member on this committee. But a couple that we're paying close attention to are the BOT Act, which is Senate 185, which would establish comprehensive guidelines and guardrails for the use of AI in the workplace, as well as the Fair News Act, which would establish critical AI protections for both journalists and the broader public as consumers of media. So this technology is rapidly evolving. We're learning from our members every day about new ways that they're seeing this being used in the workplace. So we're continuing to have those conversations in the field, who are really experts, and as I mentioned, should be on the front lines of developing these protections. And we really look forward to working with the Senate to fighting for meaningful solutions this upcoming session. Thank you.
My go. Yes?
Yes.
There we go.
I think we're good.
Okay. Thank you so much for having me. Good afternoon, Chairwoman Kristen and all the other members of the committee. My name is not Henry Garrido. He is out sick today, but my name is Odette Tanay. I'm the political director at DC 37. I want to start off by thanking the committee and the chairwoman for the legislations that you guys have introduced and have passed that we've collaborated with that you mentioned earlier in your opening statements. But we are here to raise our concerns about the use of AI programs that pose fundamental challenges to the rights, security, and dignity of our 150,000 members and the public that we serve. At DC 37, we represent nonprofit sector in New York City, but we also have private sector as well as public, so we do a little bit of both. The implementation of AI in the public sector is something that we have also seen obviously being done in the private sector. Employers are deploying AI for purposes of algorithm management, surveillance, automated decision-making, replacement of human labor, and often without transparency, accountability, worker input, or regulation. You know, after hearing Maya's testimony, it's going to be very similar, and it only shows me that the issues that we are dealing with is something that is being seen across so many different sectors and industries. So bear with me, because it's very similar to the issues that our members are seeing and feeling. Managers and city agencies such as H&H and the Department of Social Services are aggressively introducing AI in work that deals directly with health and welfare of the public sector and of New Yorkers. A recent audit revealed that an AI tool that's being used at the Administration of Children's Services, ACS, was trained on data that's a decade old. They're using use factors that are clear proxies for race and socioeconomic status. The ACS algorithm does not empower social workers. It undermines their professional expertise with a biased system. The union has had the following concerns with AI use in both public and private sector. One is job displacement and automation. A lot of our members hold titles that are highly vulnerable to automation, such as data entry and customer service. The city's drive for efficiency will be targeting these roles, threatening the livelihood of thousands of our members. If you see behind me, I am rolling deep with DC 37 and our local 1549. 1549 represents a lot of clerical throughout the entire city, and that's why they're here, been very loud and public about their concern about it. There's also a de-skilling and deprofessionalizing of a lot of the work that we do. Our members are proud to be workers of the city and are proud to do the work that they do. They've gone to school, they've gone to training and certificates for it. On top of that, we've had locals and members that have had concerns about it being used to surveillance. An example that we have within H&H, and I know many of you guys have gone to the NISNA strikes picket line that's happening now. It's also happening in private hospitals where they have AI machines in some patient rooms to give medical advice and also to time when staff comes in and out and how fast they're doing it. And our biggest concern is going to be used to punish our members for the lack of staffing that we're seeing, for the healthcare crisis that we have right now, that they're there trying to do their best, and yet they're being managed not by a person that understands what the workflow of the day was, but by a machine that's being coded to do something. And again, like Mia mentioned, there's a lot of bias and discrimination that can lead, when it comes to hiring and promotions, unfairly disadvantaging our members. And more importantly, it's eliminating empathy in a lot of the work that we do, both public and private. When we talk about private sector for DC 37, it's nonprofit workers that are serving people, that are not getting paid a lot to do it. And when you remove that human component of it, it becomes very, very dangerous. We have some suggestions of what we would like to see legislation do as we think forward of how to live our lives with AI, because it's not going anywhere and it can be very useful for a lot of things. But we would love to see legislation that codifies bargaining rights, explicitly making the implementation and impact of AI a mandatory subject of collective bargaining. We've been dealing with AI being informed, and I know that CWA has been using it, and we're hearing it from our members because we're not hearing it from management. There isn't a conversation about how to best support the work that our members are doing. It must be. We must prevent the use of AI for surveillance. We must ensure that human oversight of all automated decisions are being used. We must protect against displacement of bargaining unit members. We've seen it. AI is being introduced as a surveillance for our park workers that drive the rangers that drive the park, the vehicles. They're being timed when they stopped, where they stopped, how long they stopped. That was aggressive.
Yeah. That's what I was trying to.
And I will stop there.
Well, thank you both so much. Truly incredible testimony. I want to shout out the DC 37 members who are here. Thank you for showing up. And thank you for the work that you do. And also solidarity with the NICENA workers who are on strike. I was out there on the picket line yesterday. One of the big issues we talked about with Mount Sinai was their $100 million investment in an AI center, and yet the question of why there are not funds to give adequate healthcare and staffing to the nurses who are on the front lines. So to your points, this is definitely throughout industries. I think one thing that I heard from both of you is the concerns around surveillance and an understanding that, or shared understanding that these tools can be used in positive ways, but they should be used as a tool by workers, not as an outright replacement. And that when they're making decisions or high-risk decisions, and this is what we have in the New York AI Act, right, that there should be a human in the loop. There should be verification of how those decisions are being made and that those are the correct decisions. And so, I wanted to dig in a little bit more into not only, of course, how this touches our bill, but to the surveillance piece and how it's really impacted unions. And this can be a question for both of you. Aside from making important decisions about who can be hired, AI can be used as a really powerful tool to monitor and control employees inside the workplace. For example, we are aware of software that monitors the activity and productivity of call center workers whose mistakes can translate into pay cuts or firings. A report showed that Amazon used various workplace devices in a warehouse to avoid workplace unionization. Communications sent to anti-union messages made captive audience presentations more intimidating and reminded employees of tracking tools. Around union votes, employees received better working conditions, and so that was powered by their analysis with AI to ease HR concerns. They monitored personal social media activity, and the NLRB ultimately found that Amazon had unlawfully influenced the unionization and called for a second election. So I was wondering if you could speak a little bit more both to what you're hearing from your members. You said you had some anecdotal evidence. Would love to hear more about that, how they've maybe been impacted about this technology, and where you really would like to see the state government step up to, protect our unions and really address these issues. So maybe, Mia, if you want to start.
Happy to start. Yeah, I think, we've heard about instances of surveillance in a few different areas. You mentioned call centers, so I can start there. We're definitely seeing surveillance technology being used to track kind of keystrokes and monitor call flow and tone. And I think what we've heard from members as well, there are some tools that could be used to, help make their jobs a little bit easier. This is not an example of that. I think they've found it really stressful to get constant feedback about the way that they're talking, the type of advice they're giving on these calls. And I think, our members and workers in all places have discretion for a reason and are able to make decisions that they know best because they have experience doing these jobs in a way that AI does not have the ability to give discretion. And so we have heard that, again, those tools used for surveillance is just an added point of stress for them. Another way we've seen it, and Odette talked about this with in the Parks Department with folks who drive the trucks, are outside broadband technicians. Also, drive trucks around, and these AI tools are used to surveil and track their GPS routes. And I think there's a version of that could be helpful, but the way that we've heard it being used is, these tools will determine the GPS route for them, and then it flags if they deviate from this at all. So if they decide, they need to go to the bathroom a block out of the route, the system gets flagged, and I've heard of instances of our members being disciplined because they did not follow that route exactly. And so again, these are, they might be trying to avoid traffic. They might need to use the bathroom. Like, they have discretion for a reason, and, they have these metrics they need to hit anyway. The additional surveillance for GPS is not necessary. And then I think the last concern I'll mention around surveillance is the fear is that a lot of these tools are being used to surveil workers and training their replacements. These tools are listening into these calls, they're doing the GPS routes, they're learning exactly how our members do their jobs, so that companies can ultimately replace these jobs entirely, and that is the concern. And I think our members have a lot of anxiety around layoffs the more and more they see these tools being used in the workplace.
Absolutely. Thank you.
Yeah.
Thanks.
I mean, very, very similar, right? I think one of the biggest workforce or locals that we see have concerns with AI is our clerical 1549. These are the folks that are also doing SNAP and Medicaid eligibility, and there's big concerns there, both federally as to how our government is collaborating or using third parties like Maximus, which I'm sure a lot of you guys have heard of, which in this state we have contracts with, and there's been concerns about what that means. We currently have, I believe, 1,500 vacancies when it comes to folks that do that work, and there's no rush to fill those because they have these third parties that are doing it for them, and they have the same concern when it comes to park rangers that we've been dealing with it. Even the folks that are like working in our forest and seeing what's happening, they want to introduce like drones to see if there's something going on, and then they send someone to do it. And those are the kind of things that we're looking at that concerns us. Again, is the displacement of so many workers that live, pay taxes here, spend money here. They're part of this ecosystem that we call New York, and we cannot just replace it with a coder.
Deeply agree. And I think it's looking at the use case, right? It's how these technologies are applied. And a lot of our bills, and certainly the New York AI Act, focuses on not getting in the way of innovation necessarily, but the high-risk use cases and scenarios and impacts on New Yorkers. So I really deeply appreciate both of you speaking more to that, representing your members. I'm actually going to hold for my next round of questioning and turn it over to my colleagues. I'm going to start by turning it over to Assemblymember Szilagyi for any questions, and then work our way down the line here.
And I appreciate the opportunity, and I thank you for your testimony. Something really resonated with me when you said there are 1,500 vacancies to be filled, and there's no rush to fill them because they're leaning on technology. And to me, that is not what New York is about. It's about making sure we empower New Yorkers and giving them economic opportunity, especially through local governments. And so have you seen any examples of workers being denied jobs or promotions, or can you speak to treatment that workers were given specifically because of this situation? I know that you talked about the driving, but is there any other specific examples, especially revolving around women or other individuals?
I'm gonna have to think. Is this yes? Let me. I'll circle back with you on that. I mean, I know a lot of it is being introduced as a way to make things easier, but then tasks are being removed from workers because they no longer need them. There's just a huge lack of transparency, right? If this is supposed to be useful, let's make it useful, right? Let's sit down at a table with workers, with you guys to figure out what it is. And I think, again, a lot of the work that Senator Gonzalez has done on the public side has been extremely useful, and there's a lot more to be done. But on the private sector, it's the wild, wild west, right? And we need, again, just a co-governance in making sure that what we're doing is accurate.
And what does that minimum standard look like to you? Notice, entailing that in contracts?
Well, for us, yeah, it's codifying it in our bargaining contract. It's saying that you're adding something for the workforce, and it needs to be bargained the same way that we do anything else. Right? We bargain working conditions for our members. We've done it proudly for 80 years. And this is something that a lot of our members want to learn and figure out how to make it useful. But when they see themselves being diminished, when they see their coworkers no longer working there because they were fired or they left, and that's, they choose to leave, but then they're not being replaced, that's when fear starts coming in. We in courts, we have folks that are doing the transcriptions, right? That can easily be replaced by AI. But we know that I've tried to do that, and there's always an error on how something is done, right? Even on the GPS, when I'm a big user of Google Maps, can't go to my own house without it. And sometimes the things that I'm on and over thing when I'm really actually under. So it's, again, the lack of kind of human communication and interaction.
Thank you. I also want want to acknowledge we've been joined by some of my colleagues, Senator Fernandez, as well as Senator Liu, Senator Gunardis, and Senator Rivera. Thank you all so much for joining. For a quick housekeeping, anyone who can't find a seat, there's some seats in the front. Feel free to kind of trickle in, grab them. We want to make sure you all are comfortable. And with that, I'm going to be turning it to for the next rounds of questioning, Senator Brisport, followed by Senator Hinchy. Thank you.
Thank you. Thank you, Senator Gonzalez, and thank you both for your testimony. Mr. Nayo, I was really, I guess, disturbed by when you flagged that ACS was using AI to target families for investigations, and took a second to read an article about it more from last year in May. I guess, have you heard any testimonies from any of workers and how they feel about getting sent out to investigate families based on who AI thinks is at risk of harming their child?
I mean, yeah, these are folks that, again, this kind of work is meaningful and emotional, right? You don't work in ACS for the glory. You work because you really have a true commitment to helping people. And when they've done this work for 10, 15 years, we have so many members that have been doing it for so long, and they see the shift of a checkbox, they start questioning, what is it that we're doing and where are we heading? Right? Like, are people actually getting the service that they need? Are we losing people in the midst of the AI coding that they decided they don't need anything, or actually this person is actually really bad and it's just like having a rough time and needing help, right? So it's removing that human component that they see a concern as to, I'm doing what I'm being told, I can't say no, but it doesn't feel like the work that we used to do.
Got it. And have you heard from any of the workers in some of the nonprofits that maybe offer supportive services for family that ACS is maybe also using their algorithm to send workers to connect families with supports, separately from using the algorithm to find more punitive measures or investigate them?
I'll have to look into that, and I
Okay.
can get back to you guys on that. I don't want to misquote.
That's okay. But as of now, we definitely know they're using it to identify and target families for investigations. Okay, thank you.
No problem.
Thank you.
Thank you both for. Do I know how to use a microphone? It's unclear. Sure.
There's an AI app for that.
One would hope. Thank you both for being here and for your testimony, but more broadly for all of the work you do for New Yorkers here and for your members and all the advocacy across the state. First question is, are your unions, or do you know of any of your sister and brother unions that are doing any data collection on the impact of AI in the sectors you work for outside of just anecdotally? Has that been formalized in any way?
I mean, we are trying to formalize it. It's difficult because, again, we are getting snips and pieces from our members. So we've done a lot of member education to let them know that just because AI is something that's new doesn't mean that you shouldn't question how it's being used. So even our own members just feel like, I'm doing my job, I guess I'm doing what they're being told. So we are at a very raw point of trying to collect that information and figure out a pattern. We've been trying to reach out to the employers to sit down to talk about it, which, again, if it's codified in a bargaining contract, it makes it a lot easier than to, tell them to sit at the table when they don't have to.
Yeah.
And I think a similar answer, we've started by getting this anecdotal evidence because we want to know how our members are impacted directly. But, our members only see their side of the tool. They obviously don't see the company side of the tool. So we are trying to, do information requests with the employers to understand, when and how they're rolling out these tools, what kind of data they're collecting and what they're using it for, and things like that. And so I think we're in the process of doing that across a lot of shops. And I think, we've are attempting to bargain over this in a lot of our different contracts. We have some examples of bargaining language that we've won, mostly around transparency, like requiring the employers to let the union know when they're going to introduce a new tool so that we have the opportunity to bargain over it. But I think, that kind of work is just getting started, and we need to go beyond that.
Yeah, would love to talk more with you both about that. We have a bill about requiring the private sector to report on their use of AI, especially as it relates to layoffs and kind of the broad strokes. And so it seems like even just the transparency and data sharing on that would be helpful. But I want to switch in my last minute, it's come to my attention actually very recently that in clinical sessions, especially social workers are now being told to use AI for note taking. Obviously, we know the impacts and the negative impacts that AI has had on people's mental health when they are fake therapists. And so the role to the future of that, looking to eliminate those jobs, is incredibly terrifying. But even in just the note-taking space, do you see concern for the patients from a privacy perspective? How do you see that unfold?
I can absolutely. I mean, these AI programs are not owned by us, right? They are collecting data, and we don't know how that's going to be used, right? Like, we are at the beginning of what this future is going to look like, and again, without any.
It was my fault. I set you up for
No, it's okay.
Go ahead and
Geez, it's AI. It's mad. Forgot what I was saying.
You don't own the
Oh
software.
yes, it's the collecting of notes, right? And there's also like privacy, and there's HIPAA, and those are the things that are being removed from the service that we do for the public. We don't collect that information. It's not ours. Like, notes from a therapist shouldn't be something that should be in a program. So those are the kind of things, and we represent social workers that work at from Rikers to H&H. We also have social workers that are in the private sector that are doing therapy sessions through these like remote jobs, and like the remote has made therapy accessible, right? AI isn't making it accessible; it's removing it and giving this like false idea of help. So
I'll follow up with you on that, Odedi.
I just similarly, I definitely want to talk to our healthcare members to understand if they're being asked to use those tools for that reason. But I think we share the same concerns. Even just internally on our team, we've adopted a rule that we don't allow, Otter or any versions of that on our, staff calls, because we're talking about sensitive information. We're talking about things that deal with our members. We're talking, and as Odedi said, we don't own these tools. We have no idea what they're being used for, and so I think those problems are even more exacerbated in a clinical setting. But I will get more details for you on that.
Thank you.
Yeah.
wanted to give one example from 1549. Like I mentioned, we represent the workers that do SNAP and Medicaid. The SNAP program, in order to function at its best, should have 900 workers. We are not there. Over the holiday, Maximus, which is a company that the state has had a contract with from former Governor Cuomo, they messed up how they did the approval process of SNAP, and over 30,000 cases were affected by the fact that they were using an AI program, and then our members had to do overtime to fix the error of AI. So again, it's this kind of lack of transparency, lack of communication with labor and workers and you guys at the table to figure out how can it be useful without fully taking over it, messing up, and then we're now paying overtime to have to do this. So even economically, it doesn't make any sense.
Thank you. All right, next we're going to go to Senator Fernandez, followed by Senator Granardis.
Thank you so much. AI concerns. Oh, cut me off now. Okay. Thank you so much, Senator Gonzalez, for this hearing, for your legislation and your leadership. I'm the proud person to say that AI scares me. It concerns me. And in your comments about AI making the medical decision for patients, how many times, because I believe we have probably seen moments where their suggestions and guidance have been bad for the patient, wrong for the patient. Have we seen any evidence of that being very harmful, life-threatening to a patient?
I will get back to you about specific examples in our hospitals, because I think these tools are still, being rolled out. But we definitely have a lot of concerns over that happening. And I think the other concern we have in that context is the idea of liability. If an AI tool makes a diagnosis that is wrong, who's held accountable for that? Is it our member who is technically overseeing that system, but is not the one who made the decision and was forced to make the decision? Or because there has to be a human held accountable. And so our biggest priority is, even as they're rolling out these tools, we know we can't stop it completely, but that there is human oversight over them and a human approver who is responsible. Sorry?
At all times, for every
Exactly.
instance?
I'll get back to you about the specifics. But yes, we want to make sure that, our members who, again, are experts, know what they're doing, are overseeing these tools as they're being used.
Okay, because one thing I like about this bill is that it gives patients the right to know when AI is being used. Because I know my family, every time they send me an Instagram reel, like, we have to know that this is not real, this is,
Yeah.
and what is real. For that reason, what kind of workplace decisions should clearly fall under these protections to make sure that patients, people, workers know when AI is being used?
I will get back to you about the specifics again, because our members do a variety of different tasks in the hospital, and I want to make sure that I'm representing their tasks and their needs accurately. So I will definitely get back to you about that. But I did, one other example that I've heard of being used in the example is certain hospitals have floated replacing sitters with AI, and sitters are the roles who sit with patients who just need supervision, not necessarily like direct medical care, but they do need to be watched. And I think if I were in the hospital and I needed to be supervised, I would want a person watching me,
And not one of those little bots that.
Exactly. Exactly. So, I think we're seeing it rolled out in a number of ways, in the governor's state of the state. I know she announced a big initiative to expand AI in the hospitals. And, I think we're not trying to stop it completely. That is unrealistic. And we know that there can be helpful tools that would be rolled out. But again, we want to make sure that it doesn't add any danger to patients, and also does not threaten the replacement of our staff.
Thank you.
Yeah.
Thank you. Senator Gennardis?
Thank you. There we go. Thank you. He who makes jokes. I can make jokes at my own expense too. Michelle. Thank you very much to you both for your testimony. I want to focus on the private sector for my questioning. So, Mia, you talked about anecdotally, members having their keystrokes analyzed, right, by their supervisors, by corporate. To your knowledge, do any of the supervisors for any of the private companies your members work for, or their corporate officers, have their keystrokes evaluated using AI technology in any way?
That's a good question. I don't know the answer to that, but I can definitely.
Do
check
you
and get
know
back
if
to you.
any of your members' supervisors or corporate officers have their compensation package tied to an analysis of their keystrokes that they put on their computers?
I would doubt it.
Do you know if any of your supervisors or corporate officers have ever had any accountability measures put on them because of an analysis done on their keystrokes on their computers or other similar types of evaluations?
I would also doubt it.
Do you think that if members or employers or employees are going to have their work evaluated based on how fast they type or what they type or where they click or how they hover, that it's only fair that their supervisors and corporate officers are subject to the same type of evaluative tools?
Yes.
Okay, thank you.
Thank you. I'm going to look to see if any additional colleagues have any questions or any second rounds. All right, seeing and hearing none. I do want to thank this panel. I will say you've given us an incredible amount to work off of. Again, we've done some work in this space as a state by protecting collective bargaining agreements for public sector workers, but I'm seeing that these issues extend far beyond, and that we need to do a lot more to protect each and every person that's in this room. So I look forward to working with you and seeing if we can get those same protections for our collective bargaining agreements across the board. And again, thank you for submitting testimony.
Thank you for having us.
Thank you so much.
Thank you. All right, with that, we're going to start transitioning to our second panel of the day. If you are on the second panel, please feel free to come on up, and we're going to give you a couple minutes just to settle in. Thank you. Thank you. Thank you. I asked if they could maybe turn off some of the lights. Are you guys? Stay. Imagine. I'll just get on stack. All right. Okay. Looks like we're settled in. Thank you. I'm going to kick off this second panel. We're joined today by representatives from industry. Thank you to the representatives of Tech NYC, Society for Human Resource Management, TechNet, and the Business Software Alliance for your appearance as witnesses at today's hearing. Your member organizations play a major role in this space, and we are looking forward to hearing from you. Collectively, you represent hundreds of companies in the US and around the world. I'd like to note that we've reached out to individual industry members to testify today, and they have each referred to you as their representatives. You have all weighed in on this and other AI legislation, so you are capable of speaking on these bills and on behalf of your members. I'm going to turn it to each of you for 5 minutes of testimony. We'll start on our right with Alex from Tech NYC, and then we'll make our way to the left. But again, thank you for being here. And Alex, with that, I'll turn it to you.
Can everyone hear me?
I think.
on?
Try it again.
Check?
Oh, I think you're on.
Okay.
I think you're
Mic
good.
check.
Yeah.
Okay. Cool. Good morning, Chair Gonzalez and members of the committee and Assemblywoman. Thank you for joining us today. Appreciate the opportunity to provide our perspective on this important topic. My name is Alex Baropoulos. I am here today on behalf of Tech NYC, which represents over 550 technology companies operating and growing across New York, from early stage startups to some of the world's largest technology firms. New York is currently home to hundreds of AI-specific companies and countless more across all industries that are leveraging the abilities that AI provides, both figures that increase daily. We lead the nation in applied AI across finance, healthcare, and logistics, sectors that drive our state's job creation and economic growth. As the committee itself recognized, the benefits of AI can be great, and the advancements in AI have the potential to transform industries. The continued success of not only New York's tech ecosystem, but also our broader statewide economy relies on preserving and expanding our state's role in developing and utilizing new innovative systems. We strongly believe that AI can be a powerful tool that helps level the playing field by allowing a 3-person startup in Brooklyn or a small nonprofit in Buffalo to punch above their weight, streamlining complex tasks and analyzing data with the same sophistication as a global corporation. But this vision only exists in New York if the regulatory environment that we establish matches that vision. And while we share this committee's laudable and important goal of protecting consumers from algorithmic bias and discrimination, we have some reservations and concerns with the current slate of proposed solutions that we feel will have important unintended consequences that would transform AI from a tool for all into a tool for a few. In crafting regulations, New York should avoid the pitfalls faced by Colorado, where 2024 legislation was delayed due to complex compliance and liability issues, many of which mirror New York's current proposal. In looking at the New York AI Act in particular, we have identified the following areas of concern. First, the burden of onerous audits, costs, and reporting. We're deeply concerned that the New York AI Act creates a regulatory bottleneck through its costs and aggressive audit and reporting schedule. The practical reality is that a robust ecosystem of qualified auditors simply does not exist yet. Without established, long-standing guidelines or a clear rubric for compliance, an unintended incentive may be established to work with the auditors who provide the most favorable results to ensure compliance. Furthermore, New York will essentially be setting a cost threshold for the use of AI by any entity by placing an unknown additional cost for audits and reports. By adding these required costs and the associated staffing to oversee these processes, small businesses and nonprofits are priced out of using the innovative lifelines that AI has created, leaving New Yorkers to suffer the consequences of a widening digital divide. Finally, New York must be cognizant of creating burdensome, expensive, or slow auditing mechanisms that could inadvertently push out small-scale innovators, open source maintainers, and researchers from the ecosystem. Second, dealing with the compliance and intellectual property aspects, the reporting mandates create a compliance treadmill. By requiring new reports for every substantial change, a term only vaguely defined in the bill, developers and deployers face near constant filing obligations that stifle iterative innovation. Furthermore, the bill lacks a clear statutory protections for trade secrets, forcing companies to wait and see how the Attorney General might protect their proprietary IP through future rulemaking is a risk no business should be asked to take. In dealing with the operational hurdles, the bill's human-in-the-loop and notification requirements are well-intentioned but practically flawed. The mandated notices for every AI interaction will simply cause notice fatigue in consumers with potentially endless alerts. While we agree that human overview is important, we must also recognize that humans do have ultimate decision-making power when it comes to offering a loan or a job, even if an AI system plays a role in that process. Most small entities simply do not have the staff to manually re-adjudicate every decision that contains some aspect of an AI system in its process. And finally, the legal and liability risks. The enforcement framework established in the New York AI Act invites a predatory litigation environment. By including a private right of action, this bill opens the door to a flood of settlement-seeking lawsuits. This risk is amplified by an unprecedented rebuttable presumption of liability, requiring a company to prove its innocence with clear and convincing evidence, shifts the legal burden so heavily that many small entities will simply choose not to develop or deploy AI at all. As we continue to evaluate which avenues can be explored to identify and limit the risk of discrimination, the Tech NYC would like to offer up several solutions, potential tools to help tackle this area of concern in lieu of what has been proposed thus far. First, I think we should have the Office of Attorney General examine the existing anti-discrimination law to identify any potential gaps in existing law that would not cover the use of artificial intelligence tools, and then have the AG's office submit recommendations to the legislature on specific language that could be used to fill those gaps. And second, we could consider bolstering existing anti-discrimination practices by expanding funding to the AG's Consumer Protection Division to create a fair AI testing program. This would provide grants to nonprofits similar to Secret Shoppers for housing and help audit certain high-impact area such as hiring and lending platforms. Thanks for the opportunity to testify today. Sorry I went a little bit over. But,
No worries. And for the others testifying, if it goes a little over, that's okay. You can finish your remarks. Yeah, go ahead. Yeah.
Good morning, Chair Gonzalez and members of the committee and the legislature.
That was fast, yeah.
I'll keep going as you suggested. My name is Megan Pencil, and I'm a policy director at the Business Software Alliance. BSA is the leading trade association for the global enterprise software industry. BSA members are at the forefront of developing business-to-business technologies, including AI, and their products are used by companies across every sector of the economy. I commend the committee for convening today's hearing, and I thank you for the opportunity to testify. Crafting AI legislation that promotes the responsible adoption of AI and protects against its misuse is crucial, and an issue we already see governments beginning to tackle, including in the European Union and across the states. The most effective way to address this issue is through a single national law, and we continue to work with Congress towards that goal. But just as we saw states take the lead in adopting consumer privacy laws, states are starting to lead again with AI. It's critical to get this right. States that most effectively promote secure AI adoption in the private and public sectors will see the greatest economic benefits, stimulate further innovation, and deliver substantial economic gains across every industry sector. We have 4 recommendations to help ensure the responsible adoption of AI technologies so that companies across every sector can benefit from enterprise AI. First, any high-risk AI legislation should focus on the uses of AI that have the greatest impact on consumers. When AI systems are used to decide whether consumers are granted or denied important benefits or services, like housing, healthcare, and employment opportunities, companies should be accountable for developing and deploying those AI tools responsibly. In these high-risk scenarios, new safeguards are important, and legislation can leverage tools that already exist to help companies identify and mitigate potential risks. BSA supports requiring companies to adopt risk management programs and conduct impact assessments if they deploy or develop AI for high-risk uses. This can help companies identify and mitigate risks when AI makes important decisions about consumers and increase trust that AI is developed and used responsibly. Second, AI legislation should reflect the different roles of different actors along the AI value chain and the different steps they can take to protect consumers. The AI supply chain is evolving, and AI legislation must reflect the different roles played by different companies to be workable in practice. For example, one company may develop an AI model, a second company may integrate that model into an application, and yet another company may use that application to make decisions about individual consumers. All companies that develop and use high-risk AI systems have responsibilities to manage risks, but obligations must reflect the role of each type of company, since each will know different information about an AI system and will be able to take different actions to identify and mitigate risks. It is critical that AI legislation reflect these differences to create obligations that work in practice to safeguard consumers. Third, AI legislation should have strong and centralized enforcement. Strong enforcement is needed in any AI legislation, but that enforcement must also be consistent so that companies know how to comply with the law's requirements. We recommend giving the Attorney General's office exclusive authority to enforce any AI law. That office can create clear guidance about what the bill requires and enforce it to consistently protect consumers. Fourth, AI legislation should promote interoperability. New York is home to global companies, and your legislation will be most effective when it is interoperable with other approaches to AI regulation. Global companies can better serve their customers when they build strong compliance programs that work across markets. We also encourage you to continue working with stakeholders as you develop your legislation to understand how your AI law will work in practice across a range of different industries and uses. I want to conclude by emphasizing that the economic and societal benefits of AI will be captured by states that adopt enterprise AI tools securely, responsibly, and at scale. In recent years, states have been at the forefront of enacting technology laws, and I commend you for your focus on AI. Thoughtful AI legislation can cultivate trust in AI technologies and help ensure that consumers and companies benefit as AI continues to evolve. Thank you for the opportunity to testify. I look forward to your questions.
Thank you.
Good morning.
Morning.
Chair Gonzalez, members of the committee, thank you for the opportunity to speak with you today about the risks, solutions, and best practices shared or related to the use of AI in high-risk and consequential settings. I am Dr. Alex Alonso, and I serve as the Chief Knowledge Officer at the Society for Human Resource Management, or SHRM. As the voice of workers and the workplace, SHRM is a leading convener and thought leader on issues shaping today's workforce. We represent more than 340,000 HR professionals globally, and 13,000 of those are in the state of New York as we speak today. SHRM agrees with the committee that AI must be governed responsibly in ways that are fair, transparent, accountable, and worthy of public trust. We also believe the greatest value comes from artificial intelligence when it is paired with human intelligence. As SHRM President and CEO Johnny C. Taylor Jr. has said, AI plus HI equals ROI. SHRM research shows that more than 40% of organizations use AI in a human resource capacity today, a significant increase over the last 2 years. Most often, these tools support recruiting, writing job descriptions, matching candidate skills, and improving administrative efficiency. Just as important, our data shows that AI is being used to support human judgment, not replace it. Nearly 9 in 10 HR professionals whose organizations use AI in recruiting, for example, say it saves time and improves efficiency, and more than 1/3 report lower hiring and recruitment costs and barriers. Workers share this view. 74% of U.S. workers believe AI should complement, not replace human talent, and 77% emphasize the need for human oversight. When AI is paired with clear governance, documentation, monitoring, and meaningful human oversight, it can reduce inconsistency, expand access to opportunity, and support fairer outcomes. At the same time, the risks are real. Poorly designed systems, weak accountability, and misuse of automated tools can cause harm. HR professionals understand this better than anyone, and they are working actively every day to identify and manage these risks in real workplaces. SHRM appreciates the intent behind Senate Bill 1169 and Assembly Bill 8884, and shares the goal of preventing algorithmic discrimination, but opposes this legislation as currently written because key provisions risk unintended consequences that could undermine the fairness and opportunity in the workplace. As drafted, the definition of high-risk AI is overly broad and unclear. The lack of precision risks pulling in widely used, lower-risk tools and creating uncertainty for employers that are making good faith efforts to use and leverage technology fairly. We are also concerned about the cumulative burden of compliance requirements. Repeated third-party audits, extensive reporting, and public disclosures may be manageable for large organizations, but for small and mid-sized employers, which make up the majority of New York workplaces, these costs could be prohibitive. The provisions related to advance notice, opt-out, and post-decision appeals raise similar concerns. While well-intended, they could slow hiring and advancement in ways that ultimately reduce access to opportunity, especially in a labor market where job seekers are facing serious barriers. Finally, the combination of substantial civil penalties, a private right of action, and a presumption of liability would significantly increase legal exposure, even for employers acting in good faith. When the cost of error becomes this high, employers hesitate to innovate. That hesitation ultimately harms both organizations and the workers seeking opportunity. As New York considers its next steps on AI in the workplace, SHRM stands ready to be a constructive partner in developing a framework that protects workers and works in real workplaces. And with that in mind, we offer the following recommendations. First, workplace AI standards should be grounded in clarity, consistency, and compliance. Clarity ensures everyone understands how AI is being used. Consistency helps avoid a confusing patchwork of rules and regulations across jurisdictions. And compliance means employers have a workable, aligned set of requirements they can realistically meet. Second, AI policy should protect workers without stifling innovation. If regulation becomes overly prescriptive or fragmented, employers will hesitate to adopt tools that improve hiring, efficiency, and access to opportunity. A balanced approach is essential so that New York safeguards workers while still allowing responsible innovation to move forward. Third, employers need clear guidance and realistic timelines. Education, implementation support, and a phased approach will help organizations, especially small and mid-sized employers. Finally, HR expertise should be part of or should help guide this work. As SHRM stands ready to be a partner, AI in the workplace is ultimately about people, and we know that better than anyone. And HR professionals are closest to how AI impacts real work and everyday lives. I welcome your questions, and thank you so much for this opportunity.
Thank you.
Thank you, Madam Chair, members of the committee. Appreciate the opportunity to testify before you today. My name is Chris Gilrain, representing the Northeast for TechNet. We are an industry association comprised of over 100 companies in the innovation economy. So given that my purview is New York and the New England states, I figured I'd take this opportunity to provide a little context in what I've seen in the rest of my region. In my role, I was honored to be able to work on both the Connecticut Artificial Intelligence Work Group as well as the Legal and Regulatory Subgroup of the Massachusetts AI Task Force. The final reports of both groups put the heaviest emphasis on workforce training and the development and building out of AI infrastructure. This is the point at which I say that both reports will be linked in my written testimony, which I sincerely apologize was not sent to you in advance, despite Elon's email being very explicit about that. So I apologize for that, but those reports will be included in my testimony when I submit it imminently. The Connecticut recommendations, more specifically, were reflected in the latter half of legislation that became Connecticut Senate Bill 2, the omnibus AI legislation that was filed in that state last year. The first half of that bill largely resembles much of the legislation that we're discussing today. But the latter sections more accurately reflected what the working group talked about, which was building out AI training into existing workforce development programs, including those working with folks who are on unemployment, creating an AI academy, directing higher ed system to develop industry-recognized training and credentials, improving tech transfer programs at state universities and colleges, which I think is a really important and underappreciated part of all of this, as well as creating a fund to attract AI talent. The Massachusetts report took notes from the state's significant investment in the biotech sector, and at least I would say not a little bit of inspiration from Empire AI here in New York, and encouraged major investment in AI infrastructure, R&D, and startups. The result of that report was the establishment of the Massachusetts AI Hub, which will sit at the center of a number of different initiatives seeking to expand the state's AI readiness, both in government and in the private sector. Those programs include publicly accessible hardware resources, much like Empire AI, recognizing that the data is an asset in itself, that the state sits on a whole bunch of data, and creating a de-identified, anonymized pool of data that individuals and researchers can use to train models, as well as investing in early-stage enterprises and building the talent pipeline. I emphasize talent again because I strongly believe that while all of our members are building models and systems here in New York because it is New York, and they will continue to do so, I believe that the real job growth is in applied AI, supercharging the industries that are already here and already proficient, and ensuring that the benefits of this transition are equally and equitably distributed is going to require a diverse and prepared workforce, and that is something that TechNet is very eager to work with you all on. On the regulatory front, the final report from the Massachusetts Task Force did not have specific recommendations for legislation. The Connecticut recommendations, which TechNet endorsed, focused on leveraging existing laws to ensure that individuals leveraging AI tools to cause harm would be held accountable. Specifically, the report called for legislation to crack down on AI-generated election misinformation, something that Governor Hochul referenced in her State of the State, and we are eager to continue to work on that front, as well as ensuring that digitally generated or altered images were included in obscene material laws, which again, we are happy to work with and provide our insight from other states. TechNet supports examining existing laws and making updates where they are demonstrably lacking in the ability to address this cutting-edge technology. New York and the U.S. have existing anti-discrimination laws, and we do not believe that they have proven inadequate to address the current moment, at least not to the extent that would require a remedy that is so broadly scoped and has impactful compliance requirements and such a unique regulatory structure. The Connecticut legislation I referenced had its scope scaled back significantly prior to passage in the Senate, but ultimately failed to overcome opposition from the governor and the House. Colorado, as you heard, is the only state to have passed broad-based algorithmic bias legislation and implementation, and that has been delayed as groups are working out the very real issues that remain in the details. I just want to take 1 second to mention that both of those states have interoperable, comprehensive data privacy legislation. And if I sound like a broken record, if you've heard me before, this is something that I really, really want to work with you all on. And I know that, Chair Gonzalez, you have this legislation and something that I really hope to work on together.
Thank you, and certainly agree on the New York Privacy Act being a priority and privacy being foundational for good AI policy. I want to say thank you again to all of our panelists for your testimony. I'm going to jump into first round of questions and then, of course, pass it over to my colleagues. But as I do that, I also would like to give a quick primer on the New York AI Act because I don't expect every single person to be an expert on our bill language. And for hopefully the many people watching this at home, also want to provide some context. So today, and certainly with our labor panel, we heard about multiple cases of AI-powered tools being imperfect. We heard that they certainly have instances of discriminatory bias, and we've heard some of those concerns also echoed in this current panel. What the New York AI Act does is it focuses on high-risk use cases of AI. How we define that, and first defining artificial intelligence, automated decision-making systems, so systems that are making decisions. And what we do is we actually exclude basic computerized processes or tools that are not high at that level. So spell check, certainly not covered under the New York AI Act. When we talk about a high-risk use case, though, what we mean is a tool that is making a consequential decision about someone's life. And we've talked a little bit about what those decisions have looked like. They've looked like hiring decisions. They've looked in like tools in healthcare. They've looked like tools even on surveillance, of course, whether or not someone should be fired based on productivity. Those are high-risk scenarios because they're consequential decisions. What this bill does not aim to cover is internal business tools. Things that are business to business necessarily or aren't consumer facing or making those types of decisions about consumers' lives. And I do want to add the important parts of this bill is that if a company who is using this, whether it is a small one or a big company, is making a high risk decision that can really materially impact someone's life, that they should have a risk management framework. The bill references a national standard for risk management that was created with the input of industry, the NIST risk framework, but does not codify it, because we understand, to the points that we heard today, that every business use case can look different, and a company knows best how to implement risk management frameworks. Once a business has a risk management framework, which we know is logical and that many businesses do, as someone who was a product manager on an internal data platform, we had risk management product managers because we understood the necessity of compliance, not only with existing laws, but certainly to mitigate risk even not, beyond what the law had said. We asked them to report on that, what those frameworks are, and then to continuously audit those tools so that we know that as these AI-powered tools continue to be deployed, that they are being used as intended, and that those impacts aren't, there aren't disparate impacts amongst groups. So I wanted to provide this because, again, there's more in the bill, whistleblower protections, there is a developer safe harbor, there is a ban on social scoring, but at its heart, it really is to protect New Yorkers from these cases of bias. So I wanted to start there and then open, on that note, my first question to Tech NYC. You gave us a lot of feedback on our bill in your testimony. There is quite a long history of AI making decisions that reflect discriminatory bias. We can go back to 2018 when Amazon, one of your organization's members, stopped using its resume sorting tool that excluded women from first-round interviews. Another Tech NYC member, Uber, used to run a live facial recognition system that caused drivers to be booted off of the platform when their faces did not match a recognition algorithm. Another member, Meta, was recently sued by the Equal Rights Center, led by Lawyers Committee for Civil Rights Under Law, alleging Meta's ad algorithms steer Black users towards lower quality, for-profit college ads, and white users towards better public college ads, violating civil rights laws in DC. The case challenges algorithmic discrimination by showing how Meta systems create digital redlining. So with these concrete examples of existing tools that have been deployed, I have a really simple question based on some of the solutions you propose in your testimony. Should AI systems be regulated to avoid those disparate impacts? And how would a secret shopper system or a now new process to review discrimination laws really address how any of these scenarios?
Yep. Is mic on?
Yeah.
Okay.
Yeah.
Thank you for the question, Madam Chair. First, I'd like to say, I think, as I mentioned in testimony, like discrimination, preventing discrimination, and algorithmic bias is something that we take very seriously, and I think all of our members take very seriously. As I mentioned in testimony, we have very robust anti-discrimination laws on the book in New York State. And we would suggest that the AG's office review them. We actually think they might be empowered to go after a lot of those practices already if they are able to investigate and use their resources and tools, as they do under current law, to investigate the use of algorithmic tools that, as you may have mentioned, right, have been brought up in previous instances. We've seen this in other states. Massachusetts, Oregon, New Jersey, California have already all looked at their existing anti-discrimination laws and said that actually those laws empower the Attorney General to go after discriminatory practices via the use of AI systems. I think that's a very robust first step, right, to go after those bad actors. We all recognize that perhaps this is an issue, right? We want to figure out solutions. I think this is the best way to go about doing that, and then using the AG's office expertise in consumer protection law and anti-discrimination law to build from there and understand where they are looking at certain practices and where they feel that there are gaps in existing law to help fill those gaps, and that's the role of the legislature, right? And we want to partner on those efforts. I think what we don't want to see is sort of a blanket requirement that says, regardless of what type of entity you are, whether you're a small nonprofit, a small developer, or a large company, you need to undertake certain practices to prove you're not being discriminatory in order to use the latest innovation. We work with a lot of organizations in New York City through our foundation work, Decoded Futures programming, where we're upskilling a lot of these AI nonprofits to help them to understand the tools that AI can provide for them and how they can integrate them into their workflows, because they are under-resourced, right? We all know the local nonprofit that wish it had more time to spend serving the community, but instead spend time doing data processing or figuring out how to conduct outreach to their community. And in turn, we're helping them understand the value that AI can bring and the tools that they can then develop and build their own compliance regimes.
Yeah, we're certainly aligned on the education piece,
Yeah.
and I have been so excited
Yes.
by the Decoded Futures program and certainly supportive of AI literacy. I know that was also referenced by TechNet. We have separate bills on workforce development, but again, want to uplift our AI literacy bill because I know
Yes.
you all have been great champions of that. But I think in the context of this bill, it's important to note that we do reference existing civil rights law. We do allow for AG enforcement, but what we're doing is allowing New Yorkers the right of action to, when they've been discriminated against, to have some transparency on when that's happening and be able to bring a case to court. I think the other piece that's really important to note is that in this bill, what we are saying is we're not necessarily going to wait until New Yorkers are harmed, because clearly our existing laws haven't prevented any of the scenarios that I have just listed and the real cases that have not only happened in the last few years, but that continue to happen and will continue to happen unless we apply real risk management frameworks. And so I just want to, to your point, we do have that existing law. It is in the bill. But what we're trying to do is have standard business practices for high risk use cases, which for the most part, I haven't seen a lot of nonprofits or smaller business use these tools to make consequential decisions about New Yorkers' lives. So I appreciate the feedback, but I certainly think it's important to make sure New Yorkers are not being harmed in the first place. I do, for the sake of time, want to transition a little bit into another note, and it's actually this for TechNet, could be a question for you. The AI industry is diverse, and for the most part, there's a division of labor between developers, those who develop the foundation models and software, and deployers, those who make smaller adjustments to the underlying architecture and deploy the software into a production environment. Our bill, the New York AI Act, requires developers to share necessary information with the deployer, whereas the deployer is required to report on the impact of the tool on affected groups. I'd love to hear from you just in this bill if there are developer-deployer distinctions that are still useful in dividing responsibility and accountability, because as you mentioned, you've represented both.
Yeah, thank you. Thank you for the question. And yes, to your point, I do represent both, and so this is a little tightrope for me.
Yeah.
So, and frankly, this is, a big part of why we are in the scenario we are in Colorado, because it is so important to get this delineation right? And again, not to keep on beating the privacy horse, but it's the same thing that we go through when it comes to kind of the entities that are engaging directly with the consumer, and then the people who are in the background, right? Short answer, yes, there are very important distinctions that are in the bill. Also, some very important distinctions that we would like to see in future edits of the bill. But that is kind of a moving target at this point as we kind of continue that negotiation in Colorado. What information needs to be shared by the developer to the deployer? At which point does liability shift to the deployer for, after substantial modifications have been made? What is the definition of a substantial modification? And so ensuring that the liability falls on the appropriate partner in this instance, and that the information that is necessary is shared without divulging trade secrets, is a big part of the balancing act here, and is a big part of, again, why the process in Colorado has continued to go on and will continue to go on. And as someone who doesn't represent TechNet or Colorado, but I have colleagues there, like that's something that TechNet is happy to provide for you, is kind of a real-time update as how those negotiations are playing out, and hopefully we can apply some learnings there.
Yeah, thank you for that. And I again, we've had these conversations before, so of course this is ongoing. With all of you who are on this panel, I think we've offered a potential solution in our bill, and I think what's been challenging, and we heard this from the labor panel, is that both developers and deployers want to shift liability, but in this bill we actually have a distribution of burden across the board. And a lot of that comes with the auditing and the reporting requirements separately for each, right? So I think we are really trying to get to the heart of that issue so that there is a recognition that, tools need to be developed responsibly. And when they're deployed, the use case and how they're deployed is really what we're getting at in this bill. I know I'm coming up in a couple of minutes. For our additional panelists, I know for the Human Resources Association, I said hundreds of organizations, but thousands really that you represent.
1.3 million.
Okay, well now I can say we have millions in the room. That's incredible. I know you talked a little bit about human oversight. We've heard a lot of questions on how that can be implemented. You also talked about definitions and raised the issue of transparency, which again was actually voiced in the last panel as one of the biggest concerns. How have your member organizations looked at human in the loop when using it in a human resources context? And then certainly, has there been any transparency with folks in your organization on how these tools are being used?
So we actually have a significant amount of data that speaks to how it is being used and specific use cases. The number one thing that we see when we look at use cases related to HR functions is actually in the acquisition space and in the talent acquisition space, but for creating efficiencies. In other words, broadening the funnel and identifying more applicants in the pool. That is the number one source that we see or activity that we see currently, with more than 48% of employers saying if they're using AI in HR, that is how they're using it. They're trying to access different pools of applicants, newer pools of applicants, traditional pools of applicants that they typically would not have been able to access. Now, what we do see, though, is there is a significant hesitancy, if you will, when it comes to CHROs as well as heads of talent acquisition or recruitment, when it comes to allowing decisions, employment decisions, to be made by AI. And what we see in particular is as the decision becomes more final in the talent acquisition process, you start to see the human in the loop playing a key role as the only decider.
Thank you so much. And I will go back for a second round, but appreciate it.
Sorry.
With this, I'm going to turn to my colleagues. The first person on stack is Senator Liu, and then followed by Assemblymember Salages. Thank you.
Thank you, Madam Chair. By the way, I think our chairperson is killing it because this is an area that, quite frankly, well, you know what? I'll just speak for myself. I'm not well versed in it, and in the Senate, Chair Gonzalez has been really pushing the need for us to take action, and she's put together what I think is an incredible piece of legislation, which I'm proud to be a co-sponsor of. But in your testimony, I hear a lot of naysaying, and it doesn't actually make sense to me. Mr. Spiropoulos, you talk about the potential dangers or stifling of innovation. The bill, I think, mainly asks for transparency and disclosure. What's wrong with transparency and disclosure? Is it that difficult to be transparent? I think we're trying to protect workers. We're trying to protect consumers. You say that's your goal also. How do you do so if you're not transparent?
Yep. Thank you for the question, Senator. Again, agree with you, right? Preventing algorithmic bias and discrimination is very important. I think the concerns with the bill as currently drafted stem from some of the onerous auditing and reporting requirements that are in there. There currently exists no third-party infrastructure for auditing of AI systems that are out there, right? So this applies to any entity, right, or that's either developing an AI system or deploying an AI system for a consequential decision. So it could be a small coffee shop, or it could be a large multinational corporation. It could be a nonprofit organization as well. And so we're saying to those organizations, in order to use the latest in innovation, you have to do these audits and reporting requirements.
All right. It's only limited to high-risk cases, high-risk use cases, right?
I would say
and that's consequential for the consumer and the worker, no matter how large the entity is. So, I think it's important that we're focusing on high-risk use cases. With Dr. Alonso,
yes.
Your testimony sounds awesome. It really does. I mean, this is a work of art. I don't know what it means, though. I really don't, because your conclusion, you believe AI policy must protect workers while remaining grounded in how employment decisions are made. And yet, you want protection without stifling innovation. I mean, we hear that all the time. This kind of approach encourages us to do nothing, and we're not going to do nothing. So, your 4 recommendations, Dr. Alonso, if you could follow up, we're running out of time here, and that buzzer's going to go off.
I'd be happy to follow up.
Give us
Senator.
some examples for each of these 4 recommendations, because they all seem contradictory, honestly.
Well, I appreciate the feedback, Senator. However, what I would like to just provide as an example is limiting innovation specifically when it relates to creating greater access to opportunity. And there are a variety of examples, if you were to look at a variety of different approaches, that limit opportunity for a variety of individuals if using AI. I'll provide one example. There's a group out there called Opportunity for Work that leverages an AI-based tool to make opportunity available through employers to 70 million individuals who do not have a traditional degree.
Yeah, but I think...
allow me to finish, sir. Thank you. One of the things that speaks to is those individuals, if we were to provide an onerous component, and that is a group that actually does do its own audits, does provide transparency into its own tools, but if you are not allowing for proper innovation, consistent innovation in those types of tools to access those types of talent, you may actually hurt the worker who is seeking opportunity. That is the crux of what we are arguing for.
How does transparency and disclosure stifle this kind of innovation? And part of your testimony, you talked about how you can reach a much larger pool of applicants, but you still have to weed those things that pool of applicants down, presumably through the use of AI, before you get to the human decision that's made in the final decision, right? So, how do you prevent the situations where you clearly have bias in race, in gender, and in age?
I am happy to provide you with specific examples, Senator.
Thank you. Thank you, Madam Chair.
Thank you, Senator Liu. We're going to turn it down to Assemblymember Salages. Thank you.
I definitely have to plus one the fact that the Senator is doing an excellent job really disclosing this conversation. And I just want to piggyback, Doctor, on some of the questions that Senator Liu was presenting you. The New York AI Act requires risk assessment, bias testing, and documentation for high-risk AI systems. And SHRM has noted that many HR departments lack the technical capacity to independently audit proprietary AI tools. So under this framework, what specific information must vendors be provided so that employers can actually comply with these requirements?
So candidly, thank you so much for the question, Assemblywoman Salages, first and foremost. Candidly, what we would like to do is help build a framework that looks specifically at what are those criteria that should be included, right? Mm-hmm. We would like to see an example that provides significant education to employers so that they get the implementation support that they need. That is the key component of what we are looking for.
Okay. And what do you mean by education? What are some of the components of that education?
Candidly, it is actually understanding what the audit and regulatory requirements would be. Mm-hmm. It is providing workers and specifically HR tech professionals. Now you're looking at a specific component that is HR tech or subset of the HR profession and providing them with the tools necessary to ensure that they are being compliant across the board while still meeting the demands of a regulatory process.
And I guess this is for the panel. Of course, it would be ideal to have a federal framework. I 100% agree with that. But we see what's happening in D.C. It's complete dysfunction. They're more focused on tackling New York than actually working for consumers and people. So are you saying now that we should do nothing? Or we should just sit back? What can we do to remedy and help this situation?
I'm happy to jump in on that point. I think as I mentioned, we have long called for a national approach to AI policy, not only for consistent obligations for businesses, but also for consumers. Their rights and remedies shouldn't change just because they cross state lines. And so we're actively working with Congress as they consider legislation, but we understand that states have longstanding jurisdiction when it comes to consumer protection, and they absolutely have a role to play as well.
But what happens to the individual who's being denied today? We just say, oh, sorry, I got to wait for Congress? I don't think that's an acceptable answer.
No, I agree.
Yeah, I would just to build off what Mike was saying. I think we can empower the AG's office to go after those bad actors currently, right? Through the anti-discrimination laws on the books. Discrimination is discrimination, whether it's done by human or a human with the assistance of an AI system. And we have those strong anti-discrimination laws on the books, and we're very lucky to have that in New York, to have the protection against the federal government. I would also say that something that goes back to what Chris was saying earlier, we don't have a comprehensive data privacy law on the books in New York State. And so New Yorkers don't have the ability to right to access or delete their data, and all of those things are what AI systems are trained on. And so I think we continue to want to work on a comprehensive data privacy solution for New York that bring us up to par with the 20 other states that will help give New Yorkers more rights when it comes to data and how their online experience is sort of being used.
I'm going to turn it to Senator Hinchy now. Thank you, Assembly Member.
Thank you so much. I'm going to jump right in because there's a lot to cover. Help me understand. On the one hand, I'm hearing the AG is empowered to do the work right now, so we don't need this bill. On the other hand, I'm hearing we need a national solution, so it's one size fits all across the board. Those two things do not square because we're also admitting collectively here from your own testimony that there are problems as they exist today. So help me understand how both of those things can be true at one time.
Yeah, I'll go ahead. And so I agree that, I think the existence, excuse me, sorry, of the lawsuits that the chair referenced, right, indicate that there are laws that are currently working, right? I think what TechNet is saying is that through these experiences in other states, we've been able to identify places where there might be gaps, right? Particularly in the elections front and the non-consensual images front. So rather than layering on an additional, an additional broad-based anti-discrimination law over our existing laws, what we are suggesting is some more targeted approaches where we identify risk and we mitigate that risk with new laws, or our preference, leveraging existing laws and just making sure that they apply to current cutting-edge technology.
So hearing, Alex, I think you mentioned both in your written and oral testimony that we don't have enough regulators to handle whether it's the New York AI Act or the other pieces of legislation that we're looking at in the state. But there's an acknowledgement that there needs to be more work done, and I'm here. I would disagree that the rest of the private sector doesn't have other challenges, and it's just election or these small pieces here and there. I think there's a lot coming down the pike, which I'll get to. If we were to hire more regulators, I think there are auditors and regulators out there that are doing this work, but is the answer that we, as a state, should be investing in more regulators? Because I think the important thing is protecting people and our residents, the folks that are sitting here. Our responsibility is to protect our constituents and to protect the residents of New York. So it sounds like we need more regulators and auditors to be able to help implement the work that will then help people. Are you saying we don't need more regulators and auditors?
So I'd say that we should empower the AG's Consumer Protection Division, similar to how we've done in the past with other sectors when there are suspicions or concerns around discriminatory practices. Housing, for example, I think the state legislature in the budget, right, allocated, I think it might have been a couple $1 million additional funding for the AG's office to conduct more sort of secret shopper efforts around housing efforts in upstate New York. So I think there are ways in which we can empower the AG's unit to also go after those practices. I think we're also very encouraged. The governor announced in the State of the State speech the creation of the new DIGIT office, the Digital Innovation, Governance, and I forget, I'm going to blank on the last two, but there's clearly a concerted effort, right, within state government to understand the tools that are out there, right? How do we, the governance for them, and get a better understanding and collaboration to create some of these frameworks, because there are no auditing standards, right, or rubric that exists currently when it comes to looking at high-risk AI systems, right? And so by establishing, we're essentially saying we're going to create this new system sort of out of the blue, but we want to have some consultation with regulators and understanding how we can come about a rubric that can be a national standard, right? Bringing it back to the national, but also thinking about New York. How can we collaborate with all the ongoing work that New York is doing in so many different ways, while also empowering the AG's office to do the job that they are able to do right now, which is enforce anti-discrimination law.
Thank you. I look forward to coming back for a second round.
Yeah, I have more to say. I think there's some clarifications on what the bill does and does not do that are needed. I'm going to pass it to Senator Granardis. Thank you, Senator. Oh, and acknowledge that we've been joined by the Chair of Energy, Senator Parker. Thank you.
Thank you. Good morning, everyone. Again, so you've all broadly talked about we should use our existing laws and then also strengthen those existing laws and add new protections to the existing laws without passing the AI Act. Have any of you or your associations done analysis to identify what specific areas of law in New York is currently lacking to provide the level of coverage and protection that you are testifying we should have here in the state?
Well, I'm happy to jump in on that question. No, and I just want to be clear about our position. It might be a little bit different than some of my panelists. A national standard is preferable for all the reasons I listed in response to the Assembly member's question. But in terms of Chair Gonzalez's legislation, I think we believe that when companies are developing or using high-risk AI systems, they should be required to conduct conduct impact assessments and implement risk management frameworks for those uses. So. Just wanted to clarify that point.
Thank you. Nothing?
Just the election section that I've already referenced. There is legislation out there that we have supported, and I'm not entirely sure if New York is already taking care of the non-consensual intimate images piece, or if there is pending legislation on that front. But I will get back to you on that.
We've done a lot.
Yeah,
Senator Henchy has.
that's it's beginning a session, got to reset everything.
So I want to keep using the time here. I think we keep hearing over and over again this argument that if we do anything in the AI space, it's going to stifle innovation, and that sounds like really bad, but I think it's a lot of bull. Last year when we passed the RAISE Act, we heard from tech that if you regulate frontier models, it's going to impact startups. And tech associations brought up startups to meet with us, and those startups were using AI to make solar panels, not create catastrophic harms that could end the financial markets as we know it. They were using AI to create commercial lease agreements, not the ability to recreate biological or chemical weapons in a lab somewhere, right? So we hear this argument, and it sounds like a boogeyman argument because, God forbid, none of us want to affect startups or innovation, but you guys keep coming, and you guys, the industry keeps coming at us with this argument and is never able to really back it up with real-life examples of how a proposed disclosure requirement or an audit requirement is going to devastate the innovation economy. And so it's very frustrating to hear this argument over and over and over again when it's just lies. And so it makes it hard for me, certainly I'll speak for myself, to take all of this testimony at face value and say, well, you guys have some good points here because it's the same points we heard on RAISE last year, and frankly, it's the same points we heard 2 years ago when we went after social media companies to protect kids who are killing themselves because of technology that many of your member organizations are putting out into the world, knowing that it's dangerous. So I think you guys have to try a little bit harder to actually come up with real answers and real ideas and real commentary to inform this debate and not just hide behind the illusion of any regulation is going to harm innovation, therefore do nothing or do the bare minimum.
And I'll just say in response to that point, Senator, we agree with you completely. Good regulation in this space can actually promote the adoption of responsible AI, and we look forward to working with you as you craft your legislation.
I appreciate. I just want to check in with my panelists if there are any other first round questions. I see Senator Rivera.
Thank you, Madam Chair. Good morning. Good. Yeah, thanks. Good
morning.
Still good morning. Yeah, for 60 more minutes. So I'll echo a couple of things that have been said before, starting with Senator Liu, that this is one of the reasons that I'm here more than anything else is to educate myself on this issue. I'm the chair of the Health Committee, and certainly we're going to talk about how AI impacts health-related decisions later, but just overall, this is more of an education for me than anything else. And I have to agree with a lot of what my colleagues have said so far, certainly a national standard would be good, would be preferable on a whole host of things. And certainly this would be one of them. Reality, however, tells us that the likelihood of something happening at the national level is basically an impossibility right now. So there's a reason why we have a federal system, and now states can and should act, and certainly some of you have argued that should be the case. However, what I hear from some folks is that the laws currently on the books are sufficient. They just need to be enforced differently, that we require and as a corollary that we require more folks to actually do the oversight. And the question the question I'll ask, and there have some of your members when challenged at some point in the last couple of years or what have you, either in the state of New York or other states, have used the fact that laws currently on the books do not apply to your companies. Meaning, have there been arguments made in court, and I figure maybe they have, that oh no, you can't regulate us. Your attempt to bring some action against us as a company doesn't apply because the law doesn't cover what our technology. Has there been such an argument made at some point the last couple of years? I figure that might be the case.
I can't speak to any of the existing court cases that are out there or any specific member, but I think what we're sort of asking for here is to have the AG's office review the existing anti-discrimination law, right? And they're the enforcement authority that's for everything that's already on the books, and say, do they believe that the use of an AI system to be discriminatory in a housing decision or employment decision or an educational decision is already covered by existing law, and then enforce it, right? And if there are gaps, right, we should work together to help fill those gaps. But we do have very robust anti-discrimination laws on the books in New York. We mentioned before, we're very lucky to do so, right, knowing that the federal government is not going to be active in that space. And how can we help fill in those gaps as opposed to sort of putting a blanket protection down that is going to impact the broader adoption and utilization for smaller entities?
So
Yeah,
go ahead.
I was just gonna. I do not have an answer for you. It's a very I fully understand the question, and I think it's a very strong question. I do not have a specific answer for you, but I can look at it.
Because it seems, and this again, as I said, this is kind of an educational thing for me, because it seems that if the argument at all has been made at some point, we as a company, that action that you're trying to get us on is not something that you have, the current legislation doesn't cover us. Then obviously we need legislation. I'm just going to finish real quick, Madam Chair, and I might have a second round. But it is clear that there's a general argument for basically self-policing, and I would say that for us in this case, whether it's arguing for on behalf of consumers or on behalf of vulnerable communities, the way that certainly I only speak for myself, I would err on the side of protecting those folks. And because it seems to me that as far as the idea, and I'll actually echo something that Senator Ignardi said, the idea that anything like this is going to stifle innovation, there is so much money to be made in this field that innovation will continue to happen regardless of the regulations. It seems to me that that's clear. And I would personally, at least at this moment, certainly err on the side of protecting both consumers and vulnerable populations as opposed to this concept of innovation, when I know that this thing is going to continue to happen. And if we don't pass something that's a blanket, if we don't pass this bill, for example, the innovation will continue to happen. It happens every single day, like constantly moving forward, while we're kind of figuring out, like, what are the parameters. I would certainly, at least at this point, err on the side of consumers and vulnerable populations and say, like, this is a bill that we should be supportive of. But that's just me. Thank you, Madam Chairwoman.
Oh, thank you, Senator. With that, I'm going to go to Senator Parker for his first round.
Good morning. I don't know if anybody can hear me.
We have an aggressive ballot today, so
I
just
see.
warning
Yeah,
you.
I'm used to being, shushed in the legislature. Good morning. Sorry for my tardiness. I have a couple of questions. One of which just wanted to raise the issue around the Privacy Act, and this is really for my colleagues and the fact that, like, we really need. I think is one of the first steps that we need to get done as we look at some of this stuff. But my real question initially is that what are we doing about some of the implicit bias that we're seeing in AI, both towards women and as well Blacks, Latinos, Asians? What's the plan here, and how do we how are we addressing that?
I'm happy to kick things off. Thank you for the question, Senator. When it comes to high-risk AI legislation, companies should be responsible for mitigating against risks of bias. And it's important to note that both developers and deployers have responsibilities to mitigate against those risks. So when AI is used for high-risk scenarios like granting or denying a consumer employment or housing or healthcare, both developers and deployers should conduct impact assessments and implement risk management frameworks.
So if they don't do that, what's the penalty?
Well, then they would be in violation of the legislation.
Okay. Right. Okay. Anybody else have any?
Yeah, I would just say that as the chair recognized, many of our members were participants and signatories to the NIST international framework for risk management. So that is kind of where that lies right now.
Well, and so let me ask this follow-up question in terms of the diversity in the field and where are we seeing, kind of African Americans, Latinos, Asians, women, in terms of doing some of the programming and working on this stuff, which I think is important, despite what Trump thinks about what needs to happen in terms of implementing this stuff.
Yeah, I would say AI literacy and education is something that we as an organization fundamentally believe New York should be investing in. We're a supporter of the senator's two pieces of legislation that deal with funding both for community-based organizations to do AI literacy training, to upskill, and then also to build in an AI curriculum into the New York State public education system. On top of that, some of the work that we're investing in is around our Decoded Futures program, where we actually do upskilling trainings for nonprofits throughout the city. We've done over 100 so far, and basically teaching them, give them 0 to 1 from AI. How do you use these tools? What can they do? How can they help you better serve your communities, better serve your constituents? And have seen a lot of really great products. We work, from Brooklyn Library, Bronx Children's Museum. Across the board, you're seeing a diverse representation of community-based organizations that are understanding the value that AI can bring and wanting to invest in that more to help deliver. And I think that's going to build a foundation which we're going to see increased diversity in the tech sector.
Thank you.
Thank you, Senator Parker. I think we are through our first round of questions. We're going to transition to second rounds. To kick us off, I'm going to turn it to Senator Hinchey for our second round.
Thank you so much, Chair. Switching gears a little bit, we've heard a lot in the testimony today about cost and efficiency and saving time. What we haven't heard much about is people and human talent and our workforce. In an article from May 6, 2025, the IBM chief executive said that they are using artificial intelligence, specifically AI agents, to replace the work of a couple hundred human resource workers and instead hiring more programmers, presumably to fill those agents or to code those agents, and salespeople to make the company more money. In an article from October 10th, 2025, the Klarna CEO admitted that their aggressive move towards AI of replacing hundreds of jobs with artificial intelligence actually diminished service quality for people, and they are now doing an about-face to hire more people, real people, back into their company. And in an article from September 2nd, 2025, it's reported from Salesforce that AI is doing about 50% of the work at Salesforce, and that they have laid off a tremendous amount of people. I'm also hearing that there's no other regulatory needs in this space thus far. We have a bill that would, at the bare minimum, require private companies to report the amount of layoffs that they're doing as it pertains to AI. Because if left unchecked, we are about to see a massive amount of layoffs, and the human toll, not just for the state, but for the country, is immeasurable. Not to mention unemployment from the state. It could bankrupt our states. So what's the plan, right? What's the plan for the people that you and your members employ, that people have been trusted to be part of our economy? We talk a lot about money, innovation, driving the economy. It's the people who do that. So what's the plan to actually protect these jobs? And the answer cannot be there are more jobs in AI, because they're not here yet at the scale of the layoffs that we are seeing today. So what's the plan?
So I just want to address something, and thank you for the question, Senator Hinchey. It is actually measurable, or at least estimatable, right? It is possible to identify how much it is. In fact, our own research through the federal government, as well as our partnership with a variety of different economic firms, actually points to the fact that we're likely to see somewhere between 21 to 22 million jobs lost in the U.S. due to AI in the next 5 to 10 years. However,
I would say that's an undercount, but yes.
Well, let me be clear. However, let me explain why it is that we feel even more confident that that might be accurate. First and foremost, what we're seeing is that is actually mitigated and brought down over the next 5 years to about 8.8 million jobs. And the reason for that is because of 3 key barriers that many employers encounter. First and foremost, it is customer preference. Customers still prefer humans in many cases. Second is cost effectiveness of having and or implementing the kind of technology needed. And third is regulatory and licensure requirements in many cases. Whether we like it or not, many of us still want a prescription to be provided to us by a provider. We still want to board an aircraft and look to our left and see a human in the cockpit, whether we like it or not. Now, that is putting parameters on what we expect to see as what that displacement is. But I will offer one other note of caution here, just as a note of information, let me say, not caution. The number of individuals being displaced and most likely displaced today, the largest occupational group being displaced, is computational and mathematical jobs. That's coders. Coders, to some degree, currently are putting themselves out of business. And that's the funny thing. It's not the jobs that we keep hearing about or thinking about immediately. I appreciate the notions of what you read out there, but even HR professionals, we still expect to see a 5 to 6% growth in the occupation over the next 5 to 10 years.
Did you have one? I'll allow it.
Go for it.
I think there's a lot more to discuss on this topic. I hope someone picks it up in the second round. But you have CEOs that are quoted as saying, as recently as just 3 months ago, I need less heads, right? And so, yes, there may be some places where there's going to be some continued hiring in sectors we have, but on the whole, it's the industry itself is saying cost efficiency is also by less human capital. And so there has to be more to do here. And even when we're looking at 5 to 10 years down the road, we have constituents and residents who are being laid off today. And so the impact of those layoffs today are problematic for a host of reasons, and we have a responsibility to make sure people are protected. We can't look down the road 10 years and say, well, it's gonna work itself out, it's gonna be fine, so don't worry about your issue with unemployment or SNAP benefits or any other social services that the federal government is currently cutting, right? That can't be the answer. So I hope to hear more from you all on how we tackle that.
If I may just respond to that one point. We actually collect data from CEOs as well as chief human resource officers, people who are leading the talent functions within organizations. 84% of CHROs say their top priority for this coming year, 2026, speaking about the priorities that they're engaged in, is actually skilling people to leverage AI to do their jobs, not to replace those people.
I'm out of time.
Thank you, Senator. I'm going to now turn it to Senator Gennardis for a second round of questions.
Thank you. This will be brief. I just want to pick up on the theme that Senator Hinchey was talking about. There's an article, headline dated October 21st, 2025 in the New York Times. Amazon plans to replace more than 500,000 jobs with robots. Those aren't coders. Those are warehouse workers. Those are drivers if we ever go autonomously. That's just right now what they're planning for. That's going to evolve to be even more significantly. Amazon employs 1 million people in this country, 1.2 million people in this country. That's 40% of their workforce they are planning to replace. These are not people sitting at a computer trying to make your Alexa assistant more efficient. These are people who are the backbone of that entire company. So I think we're all deeply concerned about all of this. And the job displacement that's to come is terrifying for many, many people. So I have to use this as a question. So I'll say, do you or your members believe that we should employ something like an automation tax to help displace workers? So if Amazon, one of the largest market capitalized companies in the world, worth trillions of dollars, is going to shed 40% of its workforce, should they be required to pay a tax to compensate those workers and others who are affected by their shift to automation? And it's not just Amazon employees, it's all their contractors who they refuse to classify as employees, and all of the secondary and tertiary people who are impacted in their ecosystem, as an example. Would you and your companies, member companies, support an automation tax to help displace workers?
I would actually reserve the right, thank you for the question, Senator Gennardis. I would reserve the right to bring back more information to you. We actually have explored and or are thinking about things like universal basic income and what the future looks like, as well as other proposals of that nature. I'd reserve the right to come back to you with more information.
Thank you. No one else?
All right.
Take a gander. Is that no? So like, good luck, warehouse worker. Good luck, delivery driver. Thanks for your hard work. Hope you don't get sick and die. Hope you can afford your groceries on a no pension. Is that what we're going to tell these people?
I don't have a specific view on the tax issue that you raised, but I'm happy to follow up with you after discussing with members. And I'll just say this is a very serious issue, and it'll take a concerted effort from government, industry, and labor to address the rapidly evolving workforce needs.
Yeah, just to echo what my co-panelists have said, I think I very much hear, right, this is a very serious issue, right? We face potential challenges in New York State and across the country, and it's going to take a very robust response in evaluating what we can do in terms of upskilling, literacy, preparing the next generation of New Yorkers for the jobs of tomorrow, but also recognizing some of the impacts that will be felt today, right? And want to continue.
What about this generation of New Yorkers who are going to lose those 40% of jobs? To echo Senator Hinchy's point, and I see my time's about to expire. We got to think about both, and I don't think we're thinking about both sufficiently.
Just, I know.
Yeah, I would say that there are a number of things that we've been working on and trying to encourage the state and the city to also partner with on some of these upskilling efforts, bringing in folks who may be formerly Amazon drivers, giving them AI trainings, and then finding them placements within the private sector, but also within city government, within state government, within nonprofit organizations and small businesses. We understand that there's a need to help upskill a lot of those entities, right, and modernization efforts across the board. And we think that there's actually a really strong avenue to leverage that workforce to then help serve and fill those needs. And we've been working on things like, degree requirements at the city level to be hired at OTI and at the state level, right? State has done some of that work already, but there are a lot of obstacles that we can work together on to remove so that we can get more people who are trained in the tech skills into the workforce and putting their talents to work if they are displaced from, say, a different job or different role.
All right, I'm going to pass it to Senator Parker for a second round.
Yes. As the author of the legislation in the state Senate around universal basic income, are you saying that you support universal basic income? Is that kind of where we go in the future of? Just want to hear your thoughts about where we should be going.
I appreciate the question, Senator Parker. I reserve the right to come back to you with information regarding it.
Okay, all right. I mean, it is something that I think we're going to need to get to. And like I said, as the author of the legislation, excited to hear anybody talking about it because it's something that we've been, kicking around for 5 or 6 years.
As an economist and as a psychologist, it's my job to forecast out into the future.
Right. So as you look to the future, the question is just where does this fit within that? So that's what we're just looking for the answer to.
It's a fair question.
But also still trying to, and I appreciate where my colleagues are coming from, right? Because on both ends, not only is there an implicit bias within AI that no one seems to be willing or able to, address in a real way. But a lot of these Amazon drivers and other people who we're talking about being unemployed are also from those same populations, right? And so they're getting hit on both ends, right? And that obviously coming from one of those groups, that's problematic for me, right? And so we need to figure it out. And so, I want everyone to be clear. I don't think that this public hearing is in a place where we're saying, stop everything. We just need to have some answers and some solutions and some of that AI brain power put towards some of these problems that are being caused by the AI and figuring out how do we address that as we go forward.
Yeah, I would say thank you, Senator. I appreciate your perspective and approach and thoughts on this issue area. I think there are a lot of things that we can collectively work on together with the legislature, state government, local government as well, bringing in workforce development organizations, bringing in higher education institutions, public education, community-based organizations. It's going to take everyone's full effort to try to tackle these issues, and I think we, at least at Tech NYC, and I imagine speaking for many of the folks on the panel, right, are very excited about the opportunity to partner with state government on a lot of those things, and so want to continue those conversations with you.
And just to pile on, I know Chair Gonzalez, Assemblymember Szilagyi, there are bills that we've worked together on. Our big focus is upskilling people who currently have a job and would like a better job, or those who are underemployed, as well as the legislation I referenced in Connecticut that we can kind of transpose over to make a more robust training system for those who are unemployed if and when that does happen. So.
Thank you, Senator. Certainly, so I think we are done with second round. I just want to double check with my panelists. Do you have? Oh, I'm going to turn it to Senator Rivera. Yes.
Just for the record. When you said whether you like it or not, I do. When I come to a plane, I want to look left and I want to see an actual pilot there.
Yeah.
I do like it. Just for the record. Just for the record. Just for the record. Thanks. That's it.
Thank you, Senator.
Like, if I want to see John. John is a pilot. I want to see John.
Specifically John
I feel
Liu.
good
Yeah, Senator Liu.
if I see John Liu on a plane.
Listen, I work for an airline. I promise you, I want to see several pilots in there.
We trust John with our lives, truly. But again, I just want to say thank you to my colleagues. I do have a second round of questions, but before I get into it, again, I want to thank the panelists for this robust discussion. I would like to clarify a couple of key things about the bill. One, we are not imposing a new blanket anti-discrimination law. What we do is reference civil rights law that is in existence, and we give users the understanding of when and how and where these tools are being used so they can understand if they have been impacted. Because as we heard, transparency is a key part of this process. Another thing I would like to add is, we've heard that existing law is enough. And yet, we've talked so much today about issues that have arisen in the last few years: Workday class action lawsuit for age discrimination, HireVue's AI-powered interviewing tool disadvantaging deaf candidates, EOC settlement of iTutor's age discriminating software. DC 37 brought the example of a tool improperly flagging SNAP. And having their members have to go back and fix thousands of decisions being made. Amazon's gender discriminating resume tool, and that is just in the hiring space. We have examples in housing. SafeRent settled for $2.3 million after allegations of racial discrimination in its tenant screening tool. In 2024, the Department of Justice sued RealPage for algorithmic pricing and discrimination there. I really actually can go on and on. Family planning, we talked about ACS today. Financial services has issues with mortgage underwriting. State Farm sued for racial discrimination in its fraud detection algorithm. It is so clear that the existing laws we have do not cover and are not adequate enough to protect people from the harm that is already happening. And earlier, I know TechNet, you had referenced that companies most of your members, right, member companies, have agreed that the NIST framework for risk management is a positive one, is a national standard. So I think I'm still struggling to understand, one, what we have is enough when all of these cases have happened, and two, how it is somehow offensive to have a bill that references a national standard that many of you have agreed with and simply asks for developers and deployers to take reasonable action, right? That can be determined by the courts to implement parts of that framework or others, because again, it's not a codification or a mandate to even use that specific framework. So I guess I share in my colleagues' frustration. I also want to reference Senator Parker asked a question about what your member companies are doing today, and we didn't hear a ton of answers. We heard, well, we like NIST. We heard, well, we take it seriously. We heard, well, we're going to fight it out in court, but really very little on the proactive piece of how we get to a future where we're seeing fewer of these cases. So I share in that frustration. I look forward to working with you on the language, but really with my remaining time, I want to talk about, I know I said I would get back to you at BSA. I want to give you the floor a little bit because you have been a very measured voice about the need for impact assessments and the need for developer and deployer accountability. So I'd love to hear a little bit more from you as a representative of these companies that may be using this today, that may be struggling with these existential questions, of course, as well. What are some of why that is important to your members, and certainly what are some of the positive, for example, outcomes when they're using impact assessments and risk assessment frameworks?
Yeah, absolutely. Thank you, Chair Gonzalez, for the question. you're absolutely right that high-risk AI legislation should require companies, both developers and deployers, to implement risk management frameworks and conduct impact assessments. And it's really important that both are required because impact assessments are a point-in-time analysis, whereas a risk management framework is an ongoing system at the organizational level to manage risks over time. And it's really important that both high-risk developers and high-risk deployers have those obligations because each type of company is going to have different information about the AI system and be in a different position to mitigate potential risks. And that's just because they sit at different points in the AI system's life cycle. And so it's really important that at both points we are doing things like conducting impact assessments because those impact assessments can surface potential risks of bias, and then companies are in a position to mitigate those risks. So they're both very powerful accountability tools in terms of mitigating against a lot of the risks that we've heard about today.
Thank you for that. I think what I'm hearing is it is productive for companies to be proactive in assessing risk in their tools and mitigating that as well, right? And I think in this bill, also want to call out that these reports, which there is a developer safe harbor, so we want to talk about protecting intellectual property. We don't want trade secrets to get out. But in this reporting, that is actually a defense of these companies. They are able to report that they are reasonably taking action to assess that risk, mitigate that risk, and then and be good stewards of those tools. So when there is a negative outcome, they actually have a record of how they've been working on this issue and a defense in court. So I think what I'm hearing is there is a business incentive to having these policies, and I guess I will allow you to speak because I know I referenced a comment you made, but I'm curious why your members have, in your words, signed on to the NISC framework.
Yeah, so first I want to reference that I do very much appreciate that, you reference NIST as an example, but do not codify it into law because obviously this is all changing and evolving. So the idea of having some sort of flexibility, right? Like NIST is an option. There may be something new coming down the pike, and we don't want to lock ourselves into one thing or another. So you did build in that flexibility, and that is very important, and I know you recognize that. Now I've lost my train of thought.
Just why members are supportive of NIST. And
Because, for all the reasons that we've talked about, ideally we'd love a national framework, but I'm not holding my breath on that front. The idea that NIST was a national blueprint that was developed in concert with industry, academia, and government, that we have something to point to as a North Star. And look, it is good for business, as you said, right? People aren't going to use tools that they don't trust. So it behooves us to develop trust with consumers. And so I think that for all of those reasons, the fact that it is predictable, established, it was developed with it, industry input, academic input, those are the reasons why we like NIST or something like it, and why we appreciate that it is referenced in the legislation.
Thank you. I appreciate it. And I think we're aligned on the fact that there are positive national standards, that we're not looking for a patchwork of legislation. I think we're aligned that discrimination exists and that we have to take action on it. Accountability and transparency as legislators is what's important to our constituents. And that's really what we're here today to have represented and voiced and advocated for. Because at the end of the day, we like to partner as industry and government, but without real accountability, we're not bringing back much in terms of protecting New Yorkers and giving them a regulatory framework to defend themselves when, as we've all seen, these tools sometimes don't work as intended. So I want to thank you all for being partners in this process. I look forward, I heard privacy mentioned a bunch, workforce development. I want to thank you already for your work in both. So I look forward to working on those issues as well. I know you've submitted testimony, so certainly for the members who are joining us today, encourage all of you to also look at the testimony, look at the links, because I have seen you all be very willing to also engage in conversations about that. So I appreciate that so much. I think we are done with questioning for this panel. Again, thank you to my colleagues. We're going to take a quick couple-minute break before the next panel, and then I know, for folks in the audience, feel free to come and talk if you have additional questions. But thank you.
Thank you, Madam Chair.
Madam Chair.
All right. Thank you, everyone, so much. I'm going to invite everyone to take a seat. We're going to get started with our third panel. I'm going to thank our panelists. We have representatives from the Greater New York Hospital Association, the Partnership for New York City, and Zillow testifying remotely at today's hearing. They offer different perspectives. We heard previously from tech. But all of your businesses obviously utilize artificial intelligence, and so it's really important to have your perspectives in the room as well. We're going to start with testimony. We're going to start on Zoom and then work our way from my right, your left, and down. So, with that, do we have you, Andre? I don't think we're able to hear you. Let's see if we can get our media services to up the volume.
Can you hear me well?
Now we can hear you.
Testing the sound.
Beautiful. Thank you.
Thank you.
All right. I invite you to give your testimony. Yep.
Thank you. I appreciate so much the opportunity to join you remotely. Very much. I've been watching the hearing and I would love to be there in person, but glad to have this opportunity. Good morning, Chair Gonzalez and members of the committee. My name is Andre Linda, and I serve as a Senior Director of Artificial Intelligence and Engineering at Zillow. I truly appreciate the opportunity to discuss how AI is being used today in consumer-facing applications and how Zillow is approaching the responsible deployment of these technologies. My perspective is informed by more than a decade of experience working directly with AI systems, alongside Zillow's over 20-year history of applying AI to housing. I oversee teams responsible for how these systems function in real-world products used by millions of Americans, and my remarks today reflect that practical experience. At Zillow, our mission is to help people navigate one of the most meaningful and complex decisions of their lives, finding a home. And trust is essential in that process. As a result, we approach AI not as an abstract technology, but as a set of tools that must be trustworthy, reliable, fair, and safe at a national scale. Although artificial intelligence has existed for decades, recent advances in the field, such as large language models, have shifted how the term AI is often understood. While those tools are important, promising, and they capture public attention, they do not fully reflect how AI is used across most consumer platforms today. We do not view AI as a new technology, but rather as an evolving and well-established one. At Zillow, AI has been central to our products since our founding, beginning with the launch of Zestimate, one of the earliest large-scale consumer applications of machine learning in real estate. Today, more than 250 million people use Zillow each month to dream, rent, buy, sell, and finance homes. AI helps us surface patterns in large data sets, summarize information, personalize search results, and present information more clearly to customers. These tools are designed to support decision-making, not to replace human judgment. In practice, AI is not a single system. It consists of distinct, purpose-driven capabilities, each designed to perform specific functions. For example, Zillow's AI tools help to improve the quality of listing data, interpret natural language search queries, identify potential issues that warrant further review, and support compliance and fair housing safeguards. These uses differ meaningfully in complexity, function, and risk. Recognizing these differences is important for understanding how AI operates in consumer products. That is why we believe that risk-based regulation grounded in purpose, context, and impact is necessary to preserve pro-consumer innovation while ensuring safeguards are targeted where they matter most. Because our focus to support housing-related decisions, we place particular emphasis on fairness, transparency, privacy, and ongoing oversight. Starting with our culture, all Zillow employees receive training on fair housing and privacy obligations, and teams that work directly with AI systems receive additional responsible AI training. During the product design phase, before we launch an AI feature, cross-functional team conduct a structured model risk review assessing intended use, potential consumer impact, data sources, performance, and foreseeable risk. And finally, after product is shipped, its deployment is not the end of the process. AI systems are continuously monitored and periodically reviewed, and human oversight is maintained throughout the product lifecycle. Responsibility for outcomes remains with people, not algorithms. These principles also apply to our external partnerships. For example, consumers can now talk to Zillow directly inside ChatGPT's new in-app experience, asking natural language questions and receiving listings, photos, and maps from Zillow in conversational flow. We build this with a fair housing first design, inserting comprehensive fair housing guidelines into AI instructions and leveraging our fair housing classifier to help detect and prevent potential digital steering. We also believe that responsible innovation means increasing transparency and raising the floor for everyone. Zillow open sourced that same fair housing classifier and its training data, and it is now accessed by real estate platforms and researchers working to combat housing discrimination. This is a concrete example of how responsible innovation and compliance can work together. In closing, artificial intelligence has the potential to enhance consumer experiences, improve access to information, and help address systemic challenges in housing. Realizing that potential depends on responsible deployment and on policy frameworks that are clear, practicable, and informed by on-the-ground experience. Thank you, and I look forward to your questions.
Thank you. I'll turn it over to partnership. Yeah.
Okay, can you hear me?
Let's see if we got this mic going. Try again.
Great. Can you hear me now?
Yes.
Better. Thank you. Chair Gonzalez and members of the committee, thank you for taking the opportunity to provide us today with the ability to testify on regulation of high-risk uses of artificial intelligence in the private sector. My name is Alex Pena, and I serve as Executive Vice President of the Partnership for New York City. We are a nonprofit organization of more than 300 corporate investment and entrepreneurial firms whose members support nearly 1 million jobs in New York City and deliver approximately $263 billion in economic output. Our hopeful value added today is a cross-industry view of how the New York AI Act would operate in practice, not only for AI developers that build and install these systems, but also for a far larger set of deployers that use these systems inside real-world workflows. Unlawful discrimination is unacceptable, and whether it comes from people or technology, it must be eliminated. Our members support responsible AI governance that reduces discrimination in practice and preserves New York's ability to lead in innovation and job creation. New York has outsized stakes in getting this right. The Empire State ranks second for AI venture capital with more than $10 billion invested in 2025. And the New York metro area alone is the second largest AI hub in North America with more than 45,000 workers. New AI-driven infrastructure investment is also arriving in force, including major data centers in the Hudson Valley and Buffalo that could generate substantial long-term tax revenue and sustained job creation. Our concern is simple. As written, the New York AI Act could end up working against its own purpose. It casts too broad a net and then layers on requirements that many companies cannot reliably carry out across high-volume operations without standards being established. When regulations are that broad and that hard to implement, the inevitable happens. Attention shifts from fixing problems to managing process and preparing for lawsuits. And New Yorkers this bill is meant to protect do not end up better served. We see 4 structural issues. First, the bill authorizes private suits and then instructs courts at a motion to dismiss stage to automatically presume both bad behavior and causation, unless the defendant can fight back those presumptions with clear and convincing evidence. This means defendants are required to meet a higher evidentiary bar than the usual preponderance of the evidence standard and do it all at the very start of the case before facts have even made their way through discovery and been tested. Respectfully, this private right of action enforcement model will skyrocket settlement pressure and defensive compliance well before the bill's standards are clear, and it risks further intensifying New York's already challenging litigation climate. Second, on the bill's unclear standards, a system of high risk is high risk if it is a substantial factor in a consequential decision, and substantial factor includes any factor that is merely capable of altering an outcome. That reaches far into the larger universe of tools that assist, influence, or inform decisions across sectors, even when people remain meaningfully involved. It also makes compliance turn subjective after the fact assessments rather than clear lines that developers and deployers can plan around. For example, an organization using AI to help triage customer service tickets or flag fraud may not know in advance whether the tool will be treated as high risk, whether it will be a substantial factor in a particular decision, or what reasonable care requires when it supports staff judgment and humans are involved. That uncertainty invites inconsistent outcomes and extremely expensive guesswork. Third, the audit requirement is built on a foundation that does not yet exist. The New York AI Act mandates third-party audits on a fixed schedule, but it never clearly answers the basic question any operator will ask: what does it mean to pass an audit? Without clear objective criteria for what constitutes a satisfactory audit, the mandate becomes uncertain and, again, costly. And while the bill delays the effective date, it does not fix the core problem. Unless the state sets clear, consistent standards and the audit market organically develops in a structured way, we will see uneven outcomes, too few qualified auditors, and uncertainty for responsible businesses and the people that they serve. And that uncertainty is not abstract. Companies will have to build and rebuild compliance programs around a moving target. Fourth, the combined reporting public database and end-user opt-out package creates significant operational and disclosure risks. Reports and audits will be posted in the public database, and increasing exposure to sensitive operational details that can create security and competitive risks. In high volume environments, these obligations can also slow service and, of course, increase costs. Put simply, when requirements this consequential are paired with lingering uncertainty about what must be made public, what can be protected, and what actually helps the consumers, they can inadvertently create wrong incentives. Beyond these structural issues, the partnership believes there's a broader question about timing and unintended consequences. This legislation, while well-intended, could intentionally harm the very communities it aims to protect. Human decision-making is prone to well-documented biases that are often implicit, inconsistent, and unrecorded. Responsibly designed AI systems are not a perfect substitute for human judgment, but they can be a powerful supplement and force multiplier for our capabilities. By structuring analysis around defined relevant criteria, these tools can help make sounder, fairer, and more consistent decisions in high-stakes domains. For these reasons, we respectfully recommend that the committee consider whether this bill is drafted is the right vehicle at the moment and continue engaging stakeholders. We also recommend engaging with the Attorney General's Office for Attorney General-led review, and we look forward to being a continued part of this conversation. Thank you, and I look forward to the discussion.
Thank you, Alex. Go ahead.
Chair Gonzalez and members of the committee, good afternoon. I'm Dr. Erin Dupree, and really thank you for the opportunity to speak today on behalf of Greater New York Hospital Association, which represents more than 150 voluntary and public hospitals across New York State regarding the intersection of artificial intelligence and healthcare. My comments focus on the benefits to patient outcomes and healthcare costs and health insurers' use of artificial intelligence in the utilization review process, UR process. Since 2023, Greater New York Hospital Association has convened an AI advisory group comprised of experts from our member organizations to examine the potential benefits and challenges of integrating AI into healthcare. And what we've learned from them is that careful consideration has to be given prior to creating new policies and regulatory standards that could either accelerate or hamper adoption of important new tools, particularly in healthcare. It does have the potential to advance medicine and improve outcomes for millions of New Yorkers. Chief executive officers, chief information officers often play a direct role in decisions related to AI adoption within their organizations. Healthcare is a high-risk and consequential industry, right? And many institutions have established data governance committees, and within those committees, they have their heads of legal, risk management, ethics, clinicians, right? Very interdisciplinary work is going on at the organizations, which is great to see. In clinical applications, AI has the potential to literally revolutionize patient care. We're seeing through precision medicine, tailoring treatment based on the specific needs and genetic makeup of a patient, leading to earlier detection and enhanced care detection. AI can help radiologists identify subtle abnormalities and patterns in screening mammograms and other breast imaging techniques, potentially leading to earlier and more accurate cancer detection, while also reducing the workload and false positives. Several members have widely adopted ambient listening, which listens and then takes the notes, which the clinician, the human in the loop, then edits. It allows the clinician to focus on the patient and really improve and strengthen those bedside interactions and supports better outcomes. The use of AI in hospitals it crosses the boundaries. The myriad of examples go from the clinical examples to also information technology platforms, human resource operational support, project management, OR scheduling. It also helps to assist with medical coding and revenue cycle management and prior authorization, and in some cases it has seen significant return on investment. And this could be especially beneficial to safety net institutions that struggle to keep their doors open. AI is still in its infancy, and the potential for its usage in all aspects of our daily lives is ultimately inevitable, as you've been talking about here today. As a highly regulated industry, healthcare, hospitals, we urge the legislature to exercise caution on any new legislation that may ultimately hinder the usage of these emerging technological innovations. We also urge regulation of insurer use of AI in the claims review process. Insurers deny our member hospital claims at literal alarming rates. Over the past couple of years, they have denied approximately 25% of all inpatient hospital claims. There are two current bills that establish important guardrails for the claims review process. Greater New York is eager to work with the chairs, sponsors, and other members of the legislature to comprehensively address the growing use of AI in this space. First of all, denials should not be automated. It's imperative that each denial of healthcare service be made by an appropriately qualified clinician, right? And also, to that end, we urge that reviewing clinicians be required to document whether they reviewed the actual clinical record effort and the amount of time they spent doing that. Secondly, AI processes must comply with UR laws and requirements. It shouldn't be a tool to circumvent those requirements. CMS has explicitly cautioned Medicare Advantage plans that algorithms and AI must comply with all requirements for medical necessity determinations. And additionally, as these AI models evolve, right, AI can't be used to shift the coverage criteria over time. That coverage criteria should be static and publicly accessible. State insurance laws should hold all health plans to similar standards. Insurers should be required to certify to comply with UR laws, regulations, and guidance. Regulators also must have clear authority to audit AI in that use of utilization in UR, including outcomes. And the insurer use of AI has to be transparent. Insurers should be required to disclose to regulators, insurers, and providers how they're using AI in that claims review process to ensure that care is appropriate. Overall, greater transparency and disclosures are required to ensure that DFS, healthcare providers, and patients fully understand how these tools are being used. And third-party vendors should be held to the same standard. Greater New York strongly urges the New York State Senate to proceed cautiously with the regulations that encompass AI in healthcare, as hospitals are already highly regulated with multiple layers already in ways that already cover the use of AI. At the same time, we share your concerns that private vendors should disclose their data sharing practices to protect patients and consumers. Thank you.
Thank you so much. And again, I know we have an aggressive bell.
Sorry.
So,
I know, I was like,
I'm
I think
you can feel free to finish.
No, we're committed to working with you. I mean, that's, what we wanted to say.
Perfect. Thank you so much. Again, I want to thank all of the panelists for being here. We heard a lot about responsibilities in the last panel. And, I think what your either member organizations or companies represent is that there are some positive use cases, right? It's not all doom and gloom that, for example, in healthcare, there can be some really productive uses of artificial intelligence when used as a tool by medical professionals and those who are skilled to also make assessments in the room. So I appreciate your perspectives today. As deployers of this technology, though, I think my general question for all of you is, you're not necessarily, with the exception of the partnership, some of your orgs are both developers and deployers. But for the deployment piece, you're not necessarily developing the tools. So how do you go about assessing which tools to acquire, how to create third-party standards, and certainly how to monitor the deployment of the tool in a housing context, in a healthcare context, in a business context, et cetera? And what are you hearing from your members? So we can start maybe on your right, my left, and then work our way down to Zillow. Yeah.
Sure. I mean, healthcare and hospitals in particular, as I mentioned, are highly regulated, and by that, there's a fair amount of accountability from the licensing of the individual clinicians and professionals. Right? They don't want anything bad to happen to actually the hospitals. They're regulated at state, federal level. There's the reputational risk. There's reimbursement and patient experience that they're measured on and they're penalized for if they don't do well on those things. There's medical malpractice. There's accreditation. I mean, the list goes on. And I think importantly, too, is HIPAA, the privacy laws that they're already held to, but the vendors are not. Right? Yeah. And so they don't put anything in place until they're sure they're meeting those things. They're used to doing that with any technology they've done for years and years and years. That's just part of business in a hospital, right? So,
and to your point, the third parties aren't necessarily always under the same existing regulations, so it's important for them to have those standards as well.
Thank you.
Of privacy.
Yes.
But thank you. I appreciate that. Thanks. Yeah.
Thank you for that question, Chair. I would say, obviously, as this technology develops and as standards develop with it, what's currently being done, right, is a combination of obviously looking at national standards, whether it be NIST, but also looking at existing laws, right, and looking at outcomes. I think the reason why the partnership has taken a stance is taken both because we represent tech and non-tech companies, because we're looking at outcomes here. And so whether it's liability that we're very concerned about, unnecessary, not commensurate with the benefit through the bill, or whether it is the compliance costs that will also be equally on par as a concern for us. What companies are currently doing is they're looking at outcomes. So if the bill is asking to say, there should not be a discriminatory outcome, the companies are prepared for that underneath the existing law. And the reasonable care standard by itself is tort, right? It's the tort law, and so which they are, whether there are enough cases, but there are standards already, and so if that outcome leads to something that would trigger that, the companies know to protect against it, to have best practice, or to not allow it to happen, because that would be the outcome. And the concern that we have with this bill is that it doesn't focus on outcomes per se, as it focuses on preventing foreseeable risks through a standard that I think is still developing. But at the end of the day, if the question is about what are we doing about eliminating discrimination or preventing it to the best of the ability, it's looking at NIST, but also looking at existing case law and the laws in the books. Whether there are enforcement gaps is still an open question, and we encourage that we track down.
And I want to thank the partnership for hosting us earlier this year. We had a roundtable with about a dozen of your member organizations, ranging from media to law firms to other members of the private sector, financial services, et cetera. And I think what we learned was, to your point, there are a lot of these companies that are already supportive of the NIST framework and actually incorporating that risk management assessment, but certainly heard on some of the concerns as well. So appreciate the feedback. I'm going to turn it to you online if you want to speak a little bit more.
Yeah, thank you, Chair Gonzalez, for the question. As I said on the onset, we view AI as a technology that's used in many processes. And we really want to think from the customer standpoint and make sure that the technology does the right thing. Oftentimes, when you're developing systems like systems you can talk to, conversational systems, we ask ourselves, would it be okay for a human to say that or do that? And we really apply the same standard. And so kind of the human operator bar is the same bar we apply to technology. And to your early point, developers versus deployers, yes, we are not perhaps developer of the foundational models, but we very early on learned that these models are not ready to be deployed just as is in a domains like real estate. And we actually have to build another layer to make sure these tools can be used in a safe and compliant way. I mentioned specifically the fair housing classifier, which is a technology that allows the system to understand the nuances of real estate, and the developer can then make adjustments so that the conversation is done in a compliant way. So I wanted to add that to the conversation.
Thank you. That's incredibly helpful. And I think some of the themes I'm hearing are, obviously there is an incentive for all of your organizations to do this type of due diligence because of the reputational damage. I think Zillow, for example, you've been very vocal about being committed to vetting these tools because you understand, right? The housing contexts are some of those higher risks. Same thing in the healthcare industry. So certainly appreciate that. We're going to go into our first round of questioning from members here on the dais. I'm going to start with Senator Hinchey and then move to Senator Liu.
I thank you all so much for being here and for your leadership in your individual spaces. I think my question is best suited for the partnership, but anyone else feel free to answer. I would appreciate your thoughts as well. And it's not about specifically the New York AI Act, but it's following up on the questioning from the last panel, as I think everybody heard. A lot of your members utilize AI, right, and are scaling it out and rolling it out at different scales. How do you feel what do you feel the responsibility is for these businesses, specifically the private companies that are operating with layoffs based on usage of AI? What is their responsibility to make sure that the folks who are experiencing layoffs both have pathways back into employment, and if it's if that is going to be a cost, whether that's job retraining or even unemployment or digital literacy, who bears that cost? Is the cost for the taxpayers across New York State to take up to pay for the choices of companies that are impacting their neighbors? Or do the companies have a responsibility to step up and actually support the workforce and the economy as a whole?
Thank you, Senator Hitchie. And I will start by saying I'm happy to be a constructive partner in answering that question as we work through both discussions about this bill and any other potential legislation in this space. I will say that the companies are positioned similarly, but obviously different, but in a similar way in that they're also figuring this out. Obviously, as your responsibility as legislators of the state of New York are to try to figure out as well from the regulatory standpoint and whether things can be done immediately. At the same time, companies are also figuring that piece out. So that policy question about what burden to be had, or whether retraining is currently happening, and at what level is there a minimum threshold for that? Is it industry specific? Those are questions that we're exploring and looking at. But I think ultimately that is a policy call that we will be happy to participate in. In addition to this, into the conversation around this bill, with respect to what we're doing right now, the goal of this bill is to eliminate as possible as much of risk from algorithmic discrimination. And
I just want to jump in because I'm losing seconds, and I'm asking the broader question, not even specifically on the bill. I'm sure others may, and of course the sponsor can speak for it specifically. But to me, it sounds like it's a bit of a shoot first, ask later, right? If we are deploying these technologies that are in real time displacing jobs, and the answer is we're all figuring that out, shouldn't we figure it out before we roll it out so that we're not actually impacting the people without a real answer? And if not, how do we defend that?
So, and I appreciate that, Senator. Let me clarify by saying figuring out a piece of as we deploy, right, in terms of what are the standards around preventing foreseeable risk, and what are the standards by which to avoid to avoid discrimination via algorithms or other AI-assisted tools. In terms of the broader question, again, that question is something that was outside. I mean, for us, it is a question that's coming up across the board. But if you're asking about immediate harms, what we're looking at is that there might be perhaps existing laws in the books, there are standards, but right now, because everything is developing, imposing a regime too early could have multiple consequences across the board, in addition to the question about what is currently being done. And also, but in the previous panel as well, there was a question about whether or not displaced jobs, the actual number about how many would be replaced, in what sectors, and I think we're still we're going to be a part of that debate as well.
Yeah. I would encourage just personal privilege, sorry to close. I would encourage, I think, we appreciate the partnership. It's partnership on all of these things, and I would just encourage you all to really think about how the policies of many of your members are impacting the economy as it pertains to layoffs thus far, and what the scale up of that could be over just the next couple of years before we're really in a place to be able to put those people back into other jobs. And so I think we've got more work to do before we're scaling it out at this pace in which we are. So look forward to working with you on that.
I'll bring that question.
I'm gonna take liberty here and ask a follow-up to that, because I thought that was a really good question. I think in some of your memos you've urged a little bit of pause, and you've echoed that today on any regulation whatsoever because it's considered too early. But we know that the technology is going to continue to develop, right? We're always in an earlier stage of a more advanced technology, and what you've asked for in this pause is for more collaboration across civil rights groups, industry, government, advocates, academics, consumer groups. But we've been doing that, right, for years now, having roundtables, hearings, forums. So I'm just curious, when is there a time your members are looking for, right? When we will be at a point where we should be regulating, considering we've already articulated so many of the risks today, and to Senator Hinchy's point, well documented and data points around the workforce impacts, right? So do we wait for those to happen, or is there just like a constant collaboration until it happens, and then that's the time to act?
Thank you, Chair, for that question. I think, while extremely well-intentioned, I think the bill is, in its current form right now, is trying to solve for a couple problems that are outside, that are questions and policy debates that need to happen at the same time. But the actual bill itself, what solving for and trying to solve for foreseeable risk, that is what we're focused on at hand as our organization, and we see significant issues with it currently as drafted. In terms of the policy conversation about what are companies doing right now, as there are questions about displacement at what rate, human involvement in AI usage, what a replacement, what is the net value of AI jobs added versus what initially displaced. All that is happening, and I just think that solving it, we believe that solving it via this legislation is not the right approach, and it's not going to actually get to that piece, but that piece of the broader question. But we will be happy to have more conversation about that one outside of this bill, or depending on where the bill goes in it.
I'll hold for the rest of my second round. I'm going to pass to Senator Liu. Thank you.
Thank you, Madam Chair, and I want to thank the panelists for your time and effort to tell us that we don't need to do anything right now. right? That's basically what you're saying. Don't need to do anything. You're taking care of it all yourselves. Maybe give the Attorney General a very clear authority on enforcing. Mr. Pena, would the Attorney General inherently have all the expertise to examine the use, both the development and deployment of AI technology everywhere? Or could we help them with some basic transparency and reporting requirements? Is it too onerous to have transparency and reporting by developers and deployers?
Thank you, Senator Liu. I think when it comes, the question isn't about, whether or not the suggestion is to do nothing. That is not the suggestion. I think the question is about sequencing. And I think ultimately where we land is that in terms of sequencing, looking at existing authorities, right, measuring event vulnerabilities, then looking to the state for guidance and principles to begin addressing those vulnerabilities through real standards, through guidance, and at the same time, the auditor market is organically developing and paying attention to those standards and building around those standards, and companies are doing around that.
I don't claim to be an expert in this, but the bill sounds to me like we are starting to set some standards in the absence of other standards. So we got to start somewhere.
So
if you don't like the standards, maybe you can suggest some standards to us.
So, Senator, I respectfully disagree, at least on that more narrow aspect in terms of what the bill is asking to do, as opposed to what we're requesting. Ultimately, the bill is implying, is inferring or asserting rather a rather broad standard for reasonable care to prevent against foreseeable risk of algorithm discrimination. There are a number of things there that those standards have not been developed, and even though the bill says we'll also build out a risk management program, that kind of tips its hat towards NIST, which we largely support. Even NIST effectively acknowledges that the core problem here is that there isn't a standard yet settled. And further than this standard recognizes that, at the end of the day, reducing harmful bias is not the same as being fair. It even speaks on these pieces. It speaks on algorithm discrimination. It speaks about bias. Doesn't even get into algorithm discrimination, but it even says that even here there could be multiple outcomes depending on the sector, depending on where the development is, and so what we're calling for is
it's still more precise than saying something is unfair. So we're trying to set some standards here. Dr. Dupree, I thank you very much for your testimony, and I'm out of time here, so you can get that ringing. But I would like to, you can answer it now, or maybe we'll have a second round. We have had some really terrible consequences of AI use in the healthcare setting. And you're also basically saying it's going to be too much paperwork because you already have a lot of paperwork that your hospitals need to go through. But how do we prevent some of these really horrific cases where people have been denied medical care, needed medical care? There have been biases that have clearly manifested themselves through the use of AI. So what kind of measures are the hospitals already undertaking to ensure that none of those horrific examples happen at their hospitals?
Right. I think just to circle back to the denying of care, that goes back to the claims denial and the multiple, points there, and there's a lot of opportunity there.
Not just the insurance companies.
No. I was getting to your question. I just
sorry.
want to make sure. I just want to reiterate, the framing of that is really important and emphasize that. And I think in terms of the bias and things like that, look, it's new technology. And our hospitals are accustomed to getting new technology, whether it was the computers years ago, whether it's the electronic health record, now it's AI. It is a constant evolution in a hospital. And what our member hospitals do, what we've heard in terms of preventing bias and things like that is really running tests and testing these things before they deploy them in the background, in the sandboxes, simulating things, looking for those biases. And that's part of deployment. That's part of safe and responsible use of AI. And that's what they do.
All right, thank you. Madam Chair, I did have a very quick question for our person joining us virtually. You only mentioned one quick passing of the bill that we've proposed, And I'm not sure exactly. I'm not sure if you're in favor or against it.
Thank you for this question, Senator. So in our written remarks, we go a little bit more detail.
Appreciate
in our
people thanking us for the questions.
I would say I'm proud to work for a company that I believe does more than what's currently required. And I really wanted to offer here our model for AI governance, which is very closely modeled by after the AI risk management framework, because it really goes to the point that Chair Gonzalez mentioned, to be proactive rather than reactive, and have the necessary documentation and process in place, and be intentional about any system we're deploying. And I wanted to certainly recommend it to others and work with you to share our experience and see how that might be potentially codified in a bill that might be impactful beyond the New York State borders, because we do need a consistent approach as a company who works on a national scale.
Okay, so you don't really have an opinion on the bill other than to say that Zillow should be considered a low-risk case.
I think that real estate
and therefore
is
not applicable.
Low-risk cases and high-risk cases. I think there's a whole spectrum of cases, and it should be a risk-based approach, such as what the NIST risk management framework is designed to do.
Thank you, Madam Chair, for the indulgence.
No, thank you. And again, yes, the NIST is certainly what we are referencing in the bill. So thank you. Next on stack, I'm going to take a quick audit. I think we have Senator Salazar, followed by Senator Rivera, and then we're going to go into our second round and start with Senator Hinchy for that. Thank you. Thanks. Senator Salazar, you have the floor.
Great. Thank you, Chair. Good afternoon to all of you. Thank you for your testimony. My question is for our witness on Zoom. Landlords or their agents often use third-party tools, for example, to assess the quality of a tenant or to conduct a background check. If such a third-party tool were found to be unlawfully discriminatory in its methods, do you think that the user of that tool, the landlord, for example, should be held responsible for that discrimination?
First of all, thank you for the question, and let me say that we don't currently use such a tools at Zillow in our rental marketplace. I do think that it comes down to the basis that you actually audit these things proactively before you deploy them, and you measure potential discrimination. So ideally, that should be known that the tool might have a potential disparate impact. And we, as I said in my testimony, we believe that the decision for using these tools and what decision they make lies with the humans. In this case, it would be the deployer of these tools, and they should be responsible for how these tools are being used.
Certainly, and I agree with that. Under current law, a user may be found to have violated anti-discrimination housing laws when the impact was discrimination, even if there is not a demonstrated intent to discriminate, right? If the impact is such, the intent is not necessarily legally relevant. What might the implications of that standard be for the use of black box AI algorithms?
Yeah, that's a great question. I want to say that while some algorithms, we can label them as a black box, or some systems, what goes into the system and what comes out of it should not be a black box, especially not to the company who uses them. We know what we're feeding in. We can audit that information for potential proxies, for any kind of bias, and we also have to know what goes out of them. What is the decision that's being impacted? What is the benefit to the customer? And that's really where we have been focused. So, and you're absolutely right, especially in real estate. It's not an option to think about disparities, because almost any data point is necessarily correlated with the past legacy of digital redlining, and we do work hard on auditing these systems for bias. And if we do find cases where there is a disparity, we try to root cause them and find less discriminative alternatives, which we then would deploy to the customer.
Thank you. Thank you, Chair.
Thank you, Senator. I'm going to pass it to Senator Rivera, Chair of the Health Committee. Thank you.
Thank you, Madam Chair. Dr. Dupree, a couple of questions for you. Thank you all for your testimony. First, is Bill 1169A has Greater New York Hospital Association taken a position on this bill?
We support the legislator's goal of promoting safe integration in healthcare, yet we oppose this bill as it stands right now.
Gotcha. No, that's
with the
fine.
language.
No,
Because
gotcha.
it-
I can read the memo. I just
Okay,
wanted to.
yeah, it is in the memo here,
Got it.
but we would like to partner on this.
Fine, but
Yeah.
I just didn't, your initial testimony, I wasn't clear,
Exactly,
so it just
right. I was
okay.
trying to, there was
No worries.
limited
Second.
time.
No, I got you, just like mine, right now.
Yeah.
So, could you repeat, there's one part of your testimony where you talked about standards as far as Medicare is concerned, as far as standards that CMS
Yeah.
has. Could you repeat that for a second? Just wanted to clarify a couple of things on it.
Okay. So basically, CMS, I mean, I'm reading from the
Yeah, no, that's
testimony
fine.
here, okay, has explicitly cautioned Medicare Advantage plans that the algorithms in AI have to comply with all the requirements applicable to the coverage determination process.
Gotcha. And the coverage determination process, that refers to something that is legislated at the national level?
It's essentially whether or not they're going to pay for something, a care, right? And that's how it's done with CMS as a payer.
Gotcha. And that actually leads me to, because we're talking about
Sure.
utilization review and denials. So
Yes.
because one of the things, I mean, there's a lot of things that, to reiterate something that Senator Gonzalez said, this is a field where I can certainly see the uses of AI as like, if there's, if there's technology that can be used to more quickly and more thoroughly go through a lot of data to be able to better make determinations about someone's medical condition or how treatments are more effective and more efficient, et cetera. All those things are certainly, there's places to see not as a doom and gloom, but as like very positive. I'm particularly concerned, as I've stated many, many times in many, many forums, insurance companies are my favorite. And the notion that they would further use potentially AI for utilization review, we already have many battles with that. You just pointed out that currently, somewhere in the neighborhood of 25% of what are deemed medically necessary procedures for patients on a regular basis are denied. So it seems to me that as far as a pitfall is concerned, that is a big one. That there could be a not only on two ends, it seems to me, and you could tell me whether you have any comment on this. On two ends, on number one, there are folks that, even though I don't necessarily like them, the individuals who are making the calls to the doctor's offices saying that is a denial. That person is a person and they have a job, so we can get rid of that person by having a computer not only make the decision, the determination, but then actually inform the physician. It just seems to me that there's a lot of places where this could be there's pitfalls there that could make it that could give them even a stronger hand on their already spectacular efforts of not paying out for medical procedures that have already been performed. So if you could tell me a little bit about how your concerns about in that regard.
Thank you, for your comments, Terry. And then the question really, I think it's a balance, right? I think in terms of there are certain things that AI is really good at. It's good at speed, data processing, automation, analyzing massive data sets. But there are things that humans are better at and critical to the future. With the discussion with workforce, et cetera. Creativity, ethical reasoning, abstract thinking, nuanced social understanding. It's vital for complex human interactions, like in nursing, like in physician decision-making. I mean, all of those things matter. Thank you.
Thank you, Dr. Dupree. Thank you, Madam Chair.
Hi, thank you. It's a good segue because my questions are for, Greater New York Hospital Association. Two questions. The first, I appreciate you in your first comment setting the stage saying, insurance companies are the one who are making some of these choices. Have you, as an association, used your pretty serious weight to tell insurance companies that you work with that their methods, the way that they've been moving, the way they're shifting their own industry are not okay for the patients in which you serve?
And I would want to get back to you on that with a colleague that works on that essentially all the time, right, in that group, to comment further on that.
Thank you. I think it would be helpful.
Yeah, absolutely. We'd be happy to do.
It would be helpful. I think you have a role to play for anyone else here from the association, right? I mean, you have a role to play to make sure that our healthcare systems are working. And you have a pretty big one to play. And so I think there's some work maybe to do there.
No, thank you for that. Thank you.
Absolutely. As it pertains to AI specifically for hospitals, when there is an error, like my colleague Senator Liu referenced, whether it's in billing or scheduling or something else that is the purview of the hospital itself, and it's driven by an AI error, who's responsible for it and what happens there?
Well, first of all, hospitals are under regulation to do adverse event reporting when bad things happen that shouldn't, quite frankly, right? That's part of New York state law. And they're under regulation to do that and to look through at the root causes of what led to that. And so many times you might unfold a communication issue that was people not talking to each other. So there's some of the risks of AI, but you might also discover that there was something on the developer side that was not disclosed, and so I think there aren't easy answers here. It depends on the situation and what you uncover. There's not one answer for every adverse event.
Of course.
Yeah.
But there is legality, right?
Yes.
And there has to be kind of a chain of command. So appreciate it. Are you seeing equal adaptation of AI use across your membership? Are there certain areas or certain hospitals that are using it more? Are there certain areas that are using it more? What does that landscape look like?
I would say that those, from our AI advisory group that we've been meeting with, it is a cross-section of our membership from academic medical centers to safety net institutions. And what we see is everybody's at a different place in their journey, quite frankly. There are some institutions that have invested in AI and some that don't have the resources at all because of where they're at, but are using, for instance, Epic has a lot of AI tools coming out, and so there's an opportunity for those institutions to, potentially use more of those coming out, if they've invested in Epic and have that on board.
The one thing I
instance.
would say is
Yeah.
to the answer of, sometimes you uncover a developer issue or a third-party issue. I think that's on the hospital networks to know kind of what you're coming into. And so as everyone is kind of in a different place in their adoption journey, I think there's probably a larger role to play as the association to vet that kind of technology to ensure that as few risks and liabilities happen as possible.
No, and can I follow up? Yeah, I mean, thank you so much. Sorry, thank you so much. One of the things that we are working on, we've looked at some of the members that have been working on this for longer, have more resources to do things like this, and have been sharing what they've done. And so we are in the process of developing resources for the broader membership to support them in their journeys.
Because healthcare is incredibly important, and there should be zero wiggle room for any issues coming from a third party or AI platform. It's kind of an unacceptable space.
Absolutely. There is a lot of caution that we hear from our members, and there is, because they're used to working in healthcare. It's a high risk field.
Thanks.
Thank you. No, that was wonderful. I appreciate it. And actually, just for the record, I want to say, these aren't theoretical. These are real things that have happened in insurance. We had United Healthcare using an AI algorithm in 2023 that it was on their Medicare Advantage plan and it was known to have a 90% error rate in 2023 as well. Cigna was sued for its use of an AI algorithm to reject 300,000 claims. 2022, there have been, and even before, examples of third parties that have been racially discriminatory. An Emory study showed that AI radiology models can infer a patient's race simply based on scans, but that it was discriminatory against people who were, of course, darker skin. Skin cancer data sets in 2022 also underrepresented darker skin types, so it's also how these models were trained. That was reported on in 2022 as part of a study. And then there were more on, radiology. In 2019, a tool predicting the success of vaginal birth after C-section was found to be racially discriminatory. And that, also used indicators like age and BMI, and the data sets there were skewed. So all of this to say, I really appreciate the questions and the discourse because we've already seen it. And for everyone who is in this room, I just want to be very clear that these are concrete things that have already happened, right? Like things that are well documented. But just for my last question and my second round, and I just want to check, I don't think I see additional second rounds from the members. Turning it back to the bill at hand, which is our New York AI Act, we've gotten a lot of feedback, I think, from you, Alex, and your members that the scope is overly broad. You referenced that earlier. And it is so clear, I think, that we need to do something in this space, at least to us as people who represent everyday New Yorkers who are at the other end of a lot of these cases. So I'm curious if there is a narrower scope that would be acceptable to you or your members, or how we may be more targeted in our approach so that we can find between industry and government a compromise that works for everyone.
Thank you, Madam Chair. I think, it should be, and to be clear, because it hasn't gotten enough attention today as well, we're suggesting that the scope is large, is broad, both because of the substantial factor piece, but also because of the material impact on state law, constitutional rights, liberties. That covers everything underneath the sun, right? And so when you arm that with a private right of action, it's endless, right? And it covers all industries, even though there are some enumerated ones for consequential decisions. You can make lots of arguments about liberties being impacted, and not necessarily, in a negative way, just impacted generally, and all of a sudden you're roped into a bill subject to the liability and cost compliance. So that is our position.
So it's on the private right of action piece. That makes sense, and that is helpful to know. And it's certainly feedback we've heard too. But does that extend to, and this I think we've heard both from Zillow today and the Hospital Association, extend to the idea that companies should be testing these tools before deployment to test for things like discrimination?
Yeah, I think the question for us, and in terms of like where do you land initially is, and I'll just, sorry to be a broken record, is about sequencing. I do believe that there's a question to be asked about, one, what exactly are we looking for in terms of reasonable care that isn't already covered underneath existing law, too, and in terms of testing itself, yes, by the way, Colorado has, assessments, but they're internal, right? And the assessments are internal, and they're, because of the fact that standards are still developing. NIST is a voluntary prescriptive standard. Why? Because standards are still developing, so it could be adapted to the user. So, to the broader question about like where can we narrow in on, I don't have the answer to that, and I think that would be the question that would ultimately be, for the auditor, what does it mean to pass? What does it mean to prevent foreseeable risk of algorithm discrimination? We don't know the answer to that other than to prevent against certain outcomes, which companies are already preparing for.
Thank you. That is a perfect segue to our next panel, where we have auditors to help answer that question. So I just want to say to this panel, thank you so much for your expertise today. Thank you for your testimony. And I will say, again, you have all been incredible partners to work with, and we look forward to continuing that partnership. So thank you so much. All right, I'm going to invite the next panel to come up. And then just for folks in the room, after this next panel, we will be doing a quick break for lunch and then coming back for our advocacy groups and community organization panels. Thank you. Great. Amazing. All right. Okay, I think we're going to get started. I invite everyone to take a seat. I just want to thank our panelists for joining us today. Next up, we're hearing from academia and a service provider. Thank you thank you to the representatives of Schnellman Center for Responsible AI at NYU, Humane Intelligence, and Haverford College for your appearance as witnesses at today's hearing. On a personal note, I will say the people who are sitting here today are actually some of, I think, my favorite partners, and you all have just, I know, been already present in Albany. So we look forward to hearing your testimony, but really just the experience that you bring to this panel and the history working with state government. So with that, I'm going to open it up for your testimony. You'll have 5 minutes. We're going to start to my left, your right, and then work our way down. And then we'll open it up for questions. So I'm going to go ahead and turn it over to you to invite you to give your testimony.
Yeah, I think that means I'm first. Hi, everybody. Thanks for having me here today. I'm Sorelle Friedler. I'm the Shibboleth Family Professor of Computer Science at Haverford College. I also chair U.S. Tech Policy for the Association of Career Computing Machinery, which is the main professional organization for computer scientists. I formerly served at the White House Office of Science and Technology Policy, where I co-authored the AI Bill of Rights and helped develop policy governing AI use across the federal government. Before becoming a professor, I was a software engineer at Google. I want to start by talking to you today about what we can and can't expect from AI. AI is not designed to work all the time. I mean that specifically. So guarantees that we make about AI as computer scientists are statistical. We might say, this system achieves 98% accuracy. That sounds pretty good. It also means it got it wrong 2% of the time. A lot of AI governance is about making sure there are systems in place to handle that 2%, especially in the high-risk cases that you all are considering. Just as the AI system will sometimes fail, so too will any safeguard meant to fix these errors. Good AI governance approaches layer these safeguards to create an overlapping safety net so that as few people as possible will slip through the cracks. I'll motivate these layers with a few examples. In my own work and work of colleagues, we found that predictive policing systems are regularly incorrect in discriminatory ways. Instead of identifying locations where crime will take place in the future, they repeatedly send police back to the same neighborhoods where they've made arrests in the past. If historical policing and arrests were more likely to occur in predominantly black neighborhoods, this means future policing and arrests match that bias pattern, regardless of the actual locations of high crime areas. We need safeguards to help protect the public against those errors. Those include an audit and transparency into the safety and efficacy of the system and into its algorithmic discrimination. Consider another example, this time in the healthcare space. A woman in serious pain was in the hospital. Her doctor prescribed opioids, but after a few days, she was cut off from this pain medication, discharged from the hospital, and her doctor terminated their relationship, referencing a report from the NARCS Care database. That's a database and AI system that's supposed to flag patients at high risk of opioid addiction or overdose, but the woman and her doctors didn't understand why it was flagging her. Health policy experts have raised concerns about the efficacy of that system and other overdose risk algorithms. We should know whether these systems work, but investigating such systems without direct access to them is quite hard. Many patients don't even know those systems are being used or what data they're basing decisions on. In the case of this woman, it turns out her dog's medications had been entered into the database under her name. In addition to testing for safety and efficacy, it would have helped to have the following safeguards. A process for human intervention to manually identify and fix system problems, including human review and appeal processes. Transparency into the AI system and audits for efficacy and discrimination. Notice and explanation are needed for impacted individuals to exercise their rights and receive redress via human intervention. If you don't know an AI system has been used on you, how can you ask someone to fix its results? Finally, for all of these cases, a governance and risk mitigation plan is necessary, and enforcement is key in ensuring these important steps are actually followed. Because AI systems will fail on some inputs, there are times when the right answer will be to prohibit AI use. In cases where errors would be damaging or hard to catch, AI can't be the answer. For example, we should be cautious about AI tutors in our classrooms. They may confidently assert falsehoods, spreading lies in our schools. In other cases, even systems working perfectly may be damaging to society. In the bill, you prohibit social scoring systems. Such systems have the potential to degrade societal trust, limit opportunities, and limit the freedom of speech. I encourage you to consider whether other AI systems should also be prohibited. For example, some states have limited facial recognition use by law enforcement in investigations to specific crimes and required a warrant and notice. Others have argued that the use of affective computing by law enforcement, especially the purported ability to determine emotions and lies from a photo or video of someone's face, should be banned entirely. It doesn't work, is unlikely to ever work, and even if it did work, would be damaging to freedom of expression. I want to close by emphasizing the similarity of the AI governance required in this bill to existing federal requirements. I know that there's been a lot of discussion today about the lack of a federal framework, and that is certainly true in terms of legislation, but it is not true in terms of the executive branch. Both the Biden and Trump administrations issued federal requirements for the use of AI, whether developed in-house or procured. I was involved in the Biden administration effort. And so I wanted to emphasize, I guess very quickly, that both of the administrations have a lot of similarities in those requirements. They include scoping the AI systems based on high impact use cases, requiring an AI impact assessment, an independent review of the system, human oversight and intervention, human review and appeals processes, consultation with impacted users, and public transparency into AI use cases, findings of the AI impact assessment, and governance processes. The Biden administration additionally required assessment and mitigation of algorithmic discrimination. There are companies who are already serving the federal government who are already required to meet those requirements. Thanks.
Thank you. Thanks.
Chairwoman Gonzalez and members of the committee, thank you for the opportunity to testify today. My name is Danny Menimbo. I'm a managing principal at Shellman and lead our ISO and AI services. I'm here today as a subject matter expert on AI governance standards, specifically ISO 42001, the world's first international management system standard dedicated specifically to AI. My remarks are intended to be educational and nonpartisan. I will cover topics today of what ISO 42000 is and why it exists, the types of organizations it was designed for, the issues it addresses and how it does so, and finally, the role of third-party auditors. First, background and purpose. ISO 42001 was published in late 2023 by the International Organization for Standardization, or ISO, and developed by Joint Technical Committee 1, Subcommittee 42, which focuses on AI-related standards. The framework does not regulate AI outputs or mandate specific technical approaches. Instead, it establishes an AI management system, or AIMS, which provides a structured governance framework for how AI systems are designed, deployed, monitored, and maintained. In that sense, it is comparable to long-standing ISO management system standards that exist for information security, privacy, and quality. ISO 42001 recognizes and addresses the fact that many AI failures stem not from algorithms alone, but from organizational weaknesses, such as unclear accountability, insufficient oversight, data governance gaps, and lack of ongoing monitoring. Second, the types of organizations it's geared towards. ISO 42001 is intentionally broad and sector agnostic. It applies to any organization that develops AI systems, deploys AI in business or operational processes, uses AI for decision support, or provides AI-enabled services. The standard is particularly relevant when AI is used in consequential or high-impact environments, including finance, healthcare, education, public services, or any setting where automated or semi-automated decisions can materially affect individuals. The standard is scalable and can be adapted to small and medium-sized organizations, not only large technology firms. Third, the problem it is intended to solve and the benefits it provides. ISO 42001 addresses recurring challenges organizations face when deploying AI at scale, including unclear accountability, inconsistent risk assessments, particularly around bias and unintended impacts, limited transparency and governance, and weak lifecycle management as systems evolve. The standard requires organizations to perform impact assessments, identify AI-related risks, define a risk acceptance criteria, assign clear ownership and oversight, implement controls, and continuously monitor performance and impacts. Critically, it emphasizes bias, fairness, and unintended consequences as ongoing governance concerns, not one-time technical checks, and requirements for review and corrective action as data, models, and use cases change. From a regulatory readiness perspective, ISO 42001 provides a structured way to demonstrate that AI risks are being systemically identified and managed. It serves as objective evidence of due diligence and reasonable care as regulatory frameworks continue to evolve. From a customer trust and transparency standpoint, the standard shifts discussions away from general claims about responsible AI toward verifiable and auditable governance practices. Fourth, relevance to emerging AI technologies, including LLMs. Large language models and other models introduce unique risks related to scale, transparency, downstream use, and unintended outputs. ISO 42001 requires organizations to define appropriate boundaries, maintain human oversight for higher risk applications, monitor real-world impacts, and establish escalation mechanisms. As a result, AI governance is beginning to resemble other mature risk domains like cybersecurity and privacy, where formal management systems, independent audits, and external assurance play a critical role. ISO 42001 supports this shift by enabling consistent and repeatable evaluation of AI governance practices across organizations. Finally, the role of independent auditors and the importance of accreditation. ISO 42001 can be independently audited and certified by third-party organizations. The credibility of this process depends on accreditation of those third-party auditors. Accredited certification bodies are overseen by recognized accreditation authorities to ensure competence, independence, consistency, and impartiality. Accreditation helps reduce conflicts of interest and ensures certifications represent meaningful governance maturity rather than symbolic compliance. In closing, ISO 42001 does not resolve every policy issue related to AI. However, it provides an internationally recognized framework for governing AI responsibly, classifying and managing risk, addressing bias, and enabling independent evaluation. For policymakers, understanding how such governance standards function may help inform discussions around accountability, transparency, oversight of high-risk AI use cases at the state level, and ultimately build public trust. Thank you, everyone on the committee, for the opportunity to contribute to today's conversation.
Thank you. I do want to recognize we've been joined by Assemblymember Otis, Chair of the Science and Technology Committee in the Assembly. Thank you, Assemblymember. Ruben, go ahead.
Senator Gonzalez and members of the committee, thank you for the opportunity to testify on the New York Artificial Intelligence Act. My name is Dr. Raman Chowdhury, and for nearly a decade, my work has focused on turning responsible AI principles into practice through independent evaluations, algorithmic audits, and public interest testing of high-risk AI systems. This bill recognizes that AI already mediates core life opportunities in New York. Employment, housing, healthcare, financial services, and law enforcement, often with little transparency or oversight. By classifying these as high-risk systems and requiring audits, risk management, and meaningful user rights, the bill locates AI governance where it belongs, in enforceable obligations, not voluntary ethics pledges. From my experience evaluating AI in settings like hiring, credit, content moderation, and public safety, certain evaluation practices consistently work and others consistently fail. What works are context-specific socio-technical evaluations, that is, tests that combine technical measurement with lived experience input from the communities affected, conducted continuously over the system lifecycle and aligned with frameworks like NIST's AI Risk Management Framework, with clear accountability for remediation when harms are identified. What does not work are one-off checkbox bias scans divorced from actual deployment condition. These typically test on sanitized data, they ignore how models are used in organizations, and rarely consider interaction effects with existing practices or downstream decision-making. In other words, they evaluate a model in a lab, not the system in the world, and they fail to surface the very forms of algorithmic discrimination this bill is designed to prevent. Critically, robust regulation of high-risk AI does not stifle innovation. It enables it. In safety engineering, there is a saying, brakes help you drive faster. The existence of reliable brakes does not slow cars down. Brakes create the conditions under which drivers can safely go further and faster with confidence. The same is true here. Clear guardrails, mandatory audits, and user rights give both companies and the public confidence that AI can be used in certain domains without becoming an uncontrolled experiment on people's lives. The bill's requirement for independent, periodic, third-party audits for high-risk AI systems is particularly important. The most meaningful improvements have come when evaluations are run by entities structurally independent of product and revenue teams, and when results are tied to concrete risk mitigation obligations. Provisions such as independent rules for auditors, regular audits for both developers and deployers, and a public database of redacted reports move New York towards a model of credible evaluation and public accountability. To make this work, New York should nurture an independent ecosystem of AI auditors, much like other sectors where outside evaluation is frankly now taken for granted. In financial services, independent accounting and audit firms review statements under recognized standards and markets rely on that external assurance. In pharmaceuticals and medical devices, independent clinical trials and post-market surveillance are prerequisites for access to the market. In all of these domains, independent evaluation did not kill innovation. It professionalized it, creating a skilled and trusted community whose job it is to ask hard questions, find flaws before they become disasters, and translate technical detail into risks that boards, regulators, and the public can understand. AI needs the same, a professionalized, diverse community of auditors, researchers, and civil society experts, including community-based organizations and public interest technologists with lived experience of the harms these systems can create. Safe harbor is an important mechanism to balance innovation and accountability. Developers who take reasonable documented steps to prevent high-risk use cases, such as contractual restrictions, technical safeguards, and clear disclosures, are shielded from some obligations when their systems are not actually deployed in high-risk contexts. At the same time, if New York wants a strong ecosystem of independent evaluators, it also must ensure legal protections for those who do the work of evaluation. Auditors, internal risk teams, and independent researchers must be able to speak candidly about risks without fear of retaliation or frivolous lawsuits. Protecting whistleblowers inside developer and deployer organizations is a crucial step, and extending that spirit of safe harbor to good faith evaluators will help avoid silencing those who seek the public good. High-risk AI systems are already shaping the lives of New Yorkers. The New York AI Act responds by setting a clear expectation. If you profit from deploying AI that affects people's fundamental rights, you must evaluate it, manage its risks, and be accountable when it discriminates. Done well, this framework will not only protect New Yorkers, but will also create a predictable environment when responsible companies can innovate with confidence, knowing the rules of the road and trusting that the brakes of independent evaluation will allow them to move towards beneficial uses of AI. Thank you for your attention and your work on this critical legislation.
Thank you so much.
Thank you. Okay. Yes. Thank you, Senator Gonzalez, and members of the committee for the opportunity to testify here today. My name is Julia Stoyanovich, and I am a New Yorker. I'm also a professor of computer science and data science at New York University and the founding director of the NYU Center for Responsible AI. My research focuses on AI and data engineering systems, with an emphasis on building legal requirements and ethical norms directly into their design and deployment. I teach responsible AI to students, practitioners, and the public, and I have been involved in AI governance and regulation in New York City, New York State, and nationally, as well as internationally, for about a decade. My main point today is simple. Regulation does not stifle innovation, okay? And my main goal is to give you all arguments, specific arguments, to support this claim. Finding a clear, enforceable, and forward-looking approach to regulating high-risk AI is not a drag on innovation, it is an economic development advantage. Regulatory clarity attracts responsible investment, protects businesses from unsafe systems, and positions New York as a leader in this modern-day Sputnik moment for AI. Waiting is not neutral. Acting now with urgency allows New York to shape incentives in ways that protect New Yorkers and strengthen competitiveness. I strongly support the goal of the proposed New York AI Act to protect New Yorkers from the adverse impacts of high-risk AI. The bill is timely and necessary, and it is best understood as complementary to the RAISE Act. While RAISE focuses on frontier models and catastrophic risks, this bill addresses the everyday high-risk uses of AI that already shape people's lives. Together, they form a layered governance framework. Without the AI Act, New York would lack tools to address the most common and economically significant failures of AI systems. In my remarks, I make 5 recommendations, and you can find details in the much longer written statement that I provided. My first recommendation is to maintain the bill's focus on high-risk uses of AI. The focus is exactly right. By targeting high-risk and consequential uses of AI, the bill protects New Yorkers while providing much-needed clarity for businesses. Risk-based regulation strengthens competitiveness. It tells developers and deployers when heightened obligations apply and that clarity is a competitive asset. Companies can innovate freely in low-risk settings while investing responsibly where the stakes are high. This predictability reduces compliance uncertainty and encourages investment. New York in particular has benefited when regulation has reduced ambiguity rather than eliminated risk. This approach is both legally defensible and practical. It aligns obligations with foreseeable harm and avoids over-regulating low-risk or experimental uses, while ensuring meaningful oversight in important domains, like hiring, healthcare, credit, education, etc. New York's experience in financial services and data protection shows that differentiating by risk does not slow innovation. It directs innovation towards trustworthy, durable products and reinforces New York's position as a place where regulated industries can grow with confidence. My second recommendation is to preserve and strengthen notice and opt-out requirements. These provisions are among the most important features of the bill. These protections preserve human agency in settings where AI systems increasingly act as gatekeepers. These requirements are often described as burdensome, but in practice, they are low cost for deployers and high value for markets. Transparency builds trust, and trust enables adoption, especially in high-stakes contexts like this bill is targeting. When people understand how AI is used and retain agency, they're more willing to engage with AI-enabled services. This stabilizes demand and reduces reputational and legal risk for responsible companies. Notice and opt-out is a practical way to address a basic failure mode of AI deployment, information asymmetry. Many people don't know that AI is being used to evaluate them and how decisions are made. This bill's approach does not require disclosure of trade secrets or of technical details. It only requires clear communication and a human alternative in high-risk settings. Similar approaches have worked before, including also in New York. I will not talk about this for lack of time. My remaining recommendations are to explicitly treat validity and reliability as economic, not merely ethical concerns, to treat data protection and data governance as preconditions for responsible AI markets, and finally, to pair the bill with investments in education, auditor expertise, and building government capacity. Happy to take your questions.
Thank you so much. Again, I want to thank the panel for your testimony. It is so exciting to have you in this moment in the day because we spent the entire morning talking about all of the documented examples of when AI-powered tools go wrong, but then hearing from, various stakeholders who believe that a regulation would get in the way of innovation, certainly that auditing is not a mature field and not possible, that there aren't standards that are agreed upon. And I think really through all of your testimony, what I'm hearing is another side of that story, and that's exactly the perspective we need. So just very quickly, a couple of things. I'm going to start with you, Danny, because I'd love to hear on the auditing piece, and for the rest of the panel, to the extent that you have heard this morning's testimony, feel free to jump in with also responses to what you've heard. But I also have specific questions for each of you on your testimony. But I'm going to start with you, Danny. So on the auditing piece, we have heard auditing is not a mature industry, that there are not auditors to do this work. We have heard it is too expensive and overburdensome for smaller companies. We have heard that there aren't agreed upon standards. I know we reference NIST, but you actually, which is a national framework, but you reference an internationally agreed upon framework, so would love to hear more about that. And we heard a variety of other concerns around, for example, even timeline, that doing periodic auditing isn't actually possible, that companies wouldn't be able to implement that reasonably. And then I already mentioned cost. So would love to hear your response as an auditor and an expert in this field to all of those criticisms that we heard.
Sure.
Yeah, and just a little bit of background. I mean, Shellman's an organization. We've been around for almost 25 years. We specialize only in security and privacy audits. So a lot of our clients are in SaaS service providers. So they have obviously naturally, matured towards putting AI within their solutions, whether they're developing themselves, where they be considered on the developer side, or providing it to their users, where they be considered on the provider side. So a very relevant standard and something that we were proud to be on the forefront of being accredited for. So, and then just as far as, I've heard a couple times there's not an auditable framework out there. Of course, we have NIST nationally. The benefit here of, ISO, of course, it's international regulation is not just happening here in the state of New York. I'm in Colorado. I believe we're the first state to put comprehensive AI regulation in place. We've seen what's happening with the EU, with the EU AI Act. So we're looking for a versatile standard that can be borderless, as that is the nature of operations with a lot of companies today. And I think the idea with auditor credentials, I know there's the audit requirement within the proposed New York AI Act. I mean, having provisions in place to where we are assuring that those auditors are vetted, they are independent, objective, et cetera. That's what I was alluding to within my testimony around the importance of accreditation. So all these things really do kind of bolster trust. I mean, that's the missing component with NIST AI RMF. It is a framework. It is a voluntary framework. There is not a tangible certification to come out of that. That's the benefit that you do get with ISO 42001, and I think what attracts a lot of the attention around it is because, again, not only is it international standard, there is a certification and kind of that shiny, deliverable to come out of it that you can showcase that, can, again, do more to build trust than just doing a voluntary framework.
And how much does it cost to do
Sure.
this? Is it, are we talking millions of dollars here
Yeah.
for an organization, hundreds of thousands? How
Mhm.
much would it cost?
Yeah, we found, and I can only answer this really from Shellman's perspective, but we found that in year one, which is the more robust of the years, it's a multi-phase audit. This costs anywhere from the 20s of thousands to up to about 50s thousands in year one, lowering down to the lower end of that range in years 2 and 3. You do have to do annual audits. It is a 3-year certification, but it is not a once every 3-year audit. It is an annual audit, and in years 2 and 3, we do what's called surveillance reviews, where we come in. It's not a full system audit. We would come in, review any material changes to the system, of course. These systems are, as you know, subject to change, and then we are reviewing the material components of the AI management system. Is the risk assessment still effective? The impact assessment, et cetera? Are there ongoing monitoring in place? Are the internal audits effective, et cetera?
So just to get that clear, 20,000 to 50,000, which I would argue, for companies that are deploying these technologies in the highest risk use cases that can seriously impact a consumer's life, that seems like a reasonable cost to do their due diligence. So I really wanted to highlight that, and I appreciate the expertise. For time's sake, I'm going to move through it. I'm happy to come back for the second round. I had asked if there were, for those of you who maybe heard earlier, had some big responses you wanted to share, and I see Julia already shaking her head, so I'm certainly happy to turn the floor over to you.
So just very quickly, I want to say that auditing is not only possible and feasible, it's not optional. We have to check whether the systems even work at all, right? I mean, there's just a lot of, and pardon me for saying this, a lot of bullshit AI out there, right? And it's not to anybody's benefit to have these systems proliferate. It's a very simple argument. If you don't know whether the thing works, why are you buying it? Why are you wasting energy on training these models and deploying them if you don't know what it's doing really? And it's very possible. It's not easy, but it's very doable to check whether the system works if you are upfront about what it is that you want it to do, right? And there are lots of methodologies for this. It's not optional. We should be auditing systems for validity and robustness.
Absolutely. Ramon, go ahead. Yeah.
I want to make a quick distinction between the concept of audit and assurance. An audit is often, this is why people are really going on about frameworks. It needs to be aligned to a very specific framework because you need to test against it. Assurance is actually the kind of work I do. And really assurance, very simply put, is this product operating as expected? And to Dr. Stoyanovic's point, every company should know this before they make claims in the market. I don't think we would question whether or not, car manufacturers should claim that their car can go from 0 to 60 in 3 seconds without actually testing that. And yet there are wild claims made about the performance of these AI models with very little assurance, and any of that assurance is not currently made public. The other thing that often frustrates me is sort of this facile argument that we don't know how to audit. We don't know, then don't roll out the products, right? So one of the things is that these companies don't stop building, and not understanding what AI was 5 years ago did not stop the investment into building hundreds of billions of dollars into building these immense models that can be quite impressive today. If a fraction of that investment were put into safe, secure, and responsible AI, we could indeed turn around every single thing on these people's checklists in a very short period of time.
Thank you. And I just, earlier we had actually heard from, I believe, Tech NYC that they wanted to implement a secret shopper program as if it was a new idea to test these tools. And I would call out the work that you've done specifically to build out frameworks that not only test these tools, but do so with a lens for marginalized groups according to race, gender, et cetera. And maybe we can dig in more to that a little bit later. But
I can briefly talk about that.
Yeah.
So the kind of work we do at Humane Intelligence, actually I started as a nonprofit, and now I'm running a public benefit corporation. The goal of the nonprofit was to say, if AI is impacting everyone's lives and everybody has a right to have a say in how it works, it should not be such a radical notion to say that. What the for-profit is working on is exactly some of the frustrations that were raised earlier today, which is building scalable technology towards assessment and auditing. But again, it is this is a startup, just like a lot of other companies, and there are plenty of people tackling this problem. But the kind of work I do embodies embracing the impacted communities, not as an aside, not as a secondary thought, but specifically as part of the assessment process. So we've run programs with scientists on mis and disinformation. We have run programs with architects on creative IP, with students and teachers on EdTech, and with UN delegations on gender bias and AI models. So not only is it feasible and it's doable, we're doing it today.
Yeah, I really want to uplift that we are doing it today because, again, it was remarkable to me that they shared this as a new concept, as if the work hasn't already been happening by companies that are established for decades, by organizations like Humane Intelligence, and that bills somehow that promote the work that you're doing are now an affront to their member organizations or businesses. So I want to also just give you the floor for the sake of time, too, because I know you had a lot of responses as well. Yes.
Yeah, so just quickly, I wanted to lift up what my colleague said about the way that innovation really doesn't stand opposed to these techniques, and that there is a whole ecosystem of responsible AI startups. They might not say be big enough yet to join large established tech industry groups, right? But they are doing real innovation in this space and really exciting work, right? And putting in place this type of regulation could allow actually more innovation from those types of groups. I also just wanted to say, as a former software engineer, that I find it actually almost offensive when people are so resistant to the idea of testing their software, because that really is a foundational tenet of software engineering that I now teach my students, right? You should test your tools. You should test them to see if they work. You should test them to see if they discriminate. This is just really very basic and should be understood by anyone deploying these things.
Yeah. No, yeah, please do.
Citizen to the country is not an engineer at all. This is really just discrediting to our profession.
Yeah. 100%. And just from experience, when I worked on internal tools, we still did user testing. In the context, our users were our colleagues, but user testing or user assurance testing, it's a common standard for most companies. And so I certainly agree with you in that sentiment. I know I am actually coming up right on time for my questioning. I'm going to turn it over to my colleagues for their first round, and then we'll get into a second. But thank you again for all of that insight. I'm going to go first to Assemblymember Otis for his questioning.
Thank you. I get it. The welcome and thank you. I'm sorry I came in a little late because I was at another event, but I thank Senator Gonzalez for inviting me to this hearing and for the good lineup the whole day. And these are the important topics of the time, probably the most important issues before the legislature, but maybe only the people on the science and technology committees of each house understand that. So in listening to your testimony and reading some of the things here, one question, you've touched on it in some of your comments already, the capability to actually evaluate AI tools is a very important topic, not just in terms of the firms are out there, but the ability of technology to monitor and evaluate the new technologies that are evolving in AI is a fascinating question. When I meet with tech company folks, not necessarily totally focused on AI, but companies that are using AI tools, I pose the question, regardless of whether we have regulations or not, when you bring on an AI tool, are you evaluating it for accuracy? Are you evaluating it for unintended consequences and bias and all those other sorts of things? Because the temptation is we're going to buy this tool, we just assume that it works, and you blindly go into the universe with an assurance that really isn't statistically there. So I guess more globally, my first question to any of you that want to feed in is, where do you think the audit and evaluation skill set is going, and is it going to be able to keep up? Because I feel that there's, in a sense, we should be humble about the ability to even evaluate this stuff accurately. Where do you think the state of the art is? Is it going to be able to keep up?
I can start, actually, since I'm literally building a startup in the space. What I'm focused on is context and scale, and those two things are really difficult to balance together. So the most common ways we assess Gen AI models are things like benchmarks and red teaming, right? So a benchmark is sort of like an automated test with right or wrong answers. You can imagine that works really well at scale, but it works terribly in context, right? So whatever the benchmark is that somebody wrote, if your context is different from that, then that's it, like you don't have an answer. Red teaming is the kind of work I was doing at the nonprofit. It can be time consuming, it can be lengthy, but people are now creating AI models called LLM as a judge, where you basically take the core data of human trainers and then create an AI model to continue that kind of training. Now, that's not perfect, but it is scalable.
Go over time.
Oh, okay.
That's okay. And then if there are any other responses.
Sorry, then just to continue a little bit on that, what I'm focused on is how do we provide companies with the tool to get both, right, to get the flexibility they need. And what I'm seeing, so most of my work is actually working with companies to help them build up their governance ecosystems. I just wrapped up a project with one of the biggest insurance companies in America on exactly this. What people are doing are sort of a mixed bag of tools, so using some automated tools, but then also retrofitting or backfilling with very specific use cases. Sometimes they're actually, like I'm working with a sciences company that actually tests with geneticists. So companies are being very creative.
Thank you.
I would just quickly add to that the federal government is moving forward with requirements that any AI used or procured by the federal government be tested in such a way. And so the specifics on the procurement side are starting to come out, and they do require this type of testing.
Yeah, go ahead. Right? So, there's this really frequently invoked tagline that these systems are so complex that we can't possibly know, do they work, how do they work, etc., right? And we don't really need to know how they work to be able to test whether they work.
Yeah.
And for that, we have a thing called the scientific method that has allowed us to figure out how the world works, why diseases happen, how to develop and test drugs, etc., right? So this is not a new thing at all. We have these protocols in place. We should be using them for AI also.
Thank you.
Yeah.
Thank you. And then we're going to go to Senator Liu, if you have a first round of questions.
Thank you, Madam Chair. I absolutely love Dr. Chowdhury's metaphor that once brakes were invented, the car could go much faster. That is, I think, the perfect analogy of what we're trying to do here and what we must do here. So thank you very much for that. Mr. Menimbo, thank you very much for reminding us that there are international standards as well. Have you looked at whether our proposed bill, the New York AI Act, conforms with ISO
42,001.
42001? Does it largely conform with that, or might we make some changes to fit more within the confines of that ISO?
Yeah, I think the nice thing about ISO 42001, which really has a lot of common themes with the New York AI Act, but all regulations that I've seen out there, like I said, whether Colorado, Texas, EU, is that it's intentionally broad, right? But the common themes that it surrounds itself with, the fact that it's role-based around deployers, around developers, the fact that it stresses risk analysis of your systems. Are you high risk, such as the focus of the New York AI Act, or are you negligible risk, or somewhere in between? That's an important aspect of ISO 42001. The fact that it stresses ongoing monitoring, awareness, AI literacy, non-discrimination, all of those things are key tenets of ISO 42001. So the broadness, I think, is a benefit because it allows you to take inputs such as, okay, I may be obligated to comply with the New York AI Act. I may be obligated to comply with EU. Those are all inputs that I can now, utilize when building out a management system.
And I'm wondering, has innovation come to a complete standstill in the EU? There's like no more innovation, right?
Not going to comment on that. Yeah.
No, obviously I'm being facetious. I would imagine that new ideas and applications are still being conceived in the EU, notwithstanding ISO 42001.
Correct.
Okay, thank you. Thank you, Madam Chair.
Thank you. Certainly appreciate the question because, to Senator Liu's point, I think that's so much of what we heard this morning on the innovation piece. So thank you. I want to look to my colleagues to see if we have a first round. We have a first round from Senator Hinchey. Thank you.
I'll jump in. Thank you all so much for being here, and I think your voices are really important in this moment. I think it's really clear, especially with how fast AI is moving and how fast it can move, that every day we don't do something to actually protect people, it gets closer and closer to a time where we won't be able to put the cat back in the bag. And we're seeing, thank you, and it's the same thing that we're seeing with social media algorithms and social media feeds, right? We are fighting now as a state with Senator Gennardis' leadership, who was here earlier, to try to make sure that fewer people die because of how fast technology went. And if we learned anything from that, it's that we need to look holistically at new innovations and technologies and make sure that we're actually putting the parameters in place to protect people while we use the benefits of things like AI. And so I appreciate all of your perspectives and your work. So if you've heard any of the other panels, I've been focused a lot on the implication of layoffs and how AI can and is vastly changing our job market. And so I'd be curious just to hear, it's a big question, but I'd be curious just to hear from anyone on the panel what you're seeing, what advice you have. We have a bill on reporting mechanisms to actually require private companies to disclose how many layoffs they have because of AI, and a whole host of other things. Be happy to send that over. But just would love your perspective on AI's impact in the workforce as it pertains to our economy and the human capital that we have.
I think that the provisions that you have in the bill to require human review and appeal are critical aspects of the AI governance framework and are critical to the safety of New Yorkers. I also think that those may serve to help mitigate some of the job impacts that you are concerned about, right? In an ideal scenario, what it would mean is that the sort of easy decisions were made quickly, right? And the decisions that really required nuance and human judgment actually got more of that type of care.
Thank you.
I think that we are actually experiencing a lost generation of young people entering the job market for the first time and finding that companies have decided that their jobs are better automated by AI, whether or not that statement holds true. So we can also exist in a world of two things that are conflicting. Number one, companies are claiming massive amounts of jobs being taken, being automated by AI. Yet every single CEO that has boldly said it, from Mark Benioff at Salesforce, CEO of Klarna, Duolingo, and more, have all quietly rolled back the extreme numbers that they were sharing. So that's number one. However, AI is what's often called an enthusiastic intern. I think that's a great way to think about it. So it's these early career jobs that are the ones that are automated, right? The first job that you may have had is like a staffer, or making someone's photocopies or doing their research. That's the kind of stuff people are using AI for now. I think we're often being distracted by Silicon Valley and their existential conversations about things like universal basic income. I don't know about you, but the last thing I want is a welfare check from Sam Altman. So, I think there are better and smarter ways to think about it by targeting where the impact actually is. And it's with, literally young people today struggling in the job market.
So thank you. I know I'm out of time, but I just want to say your comments are exactly where my head is in this situation, right? We have the elimination of many entry-level, mid-level, and some mid to senior level jobs, but primarily a lot of entry-level jobs. And so if you look not that far into the future, it seems that the only way you'll be able to get a job at one of the Fortune 500 companies or any good tech company or wherever it is that you're going to make enough money to survive and live is if you know someone or are related to someone who currently today is in the C-suite or on the board. And so we're talking a lot in America right now about oligarchies and how far we've come to that line. If this continues, in my view, and I'm curious the thoughts, maybe I can jump into my second round.
I think we're done with first round. Does anybody else have first round?
I was thinking I'll just finish my thought and then it can go to later. The answer can be later.
Go ahead for second round.
If the only way that we're going to have any of these people can go into those jobs is if you're related to or know someone who's currently in that sector, and so are in those positions. And so we're going to have this incredibly dystopian future where we really have a true oligarchical system across the United States. And when you have someone on a panel previously today talking about UBI, we're never going to pay enough money in UBI to match what these executives and AI companies are paying their executives. That is going to be a very disproportionate amount of money. And so, that to me looks like to where we're going. And I think there's a lot in there that we can unpack. But I'm curious, that's exactly where I'm thinking. And so I'd love your thoughts.
To react. And Sorel and I were both professors, right? So, and we have had several conversations about this over the years that education, investment in education and training and literacy has to be there, and it has to be done proactively, right? So, for example, the RAISE Act, E in RAISE stands for education, but I don't see anything actually meaningfully going from the state towards investing in developing new curricula, new ways to teach students or people on the job right now to be able to use AI productively rather than being replaced by AI. And these conversations cannot just be left to industry to handle, right? Of course, industry is going to offer you a training program because they want to sell their technology, right? So this really needs to involve academia in a very, very big way. And I encourage New York State to think very carefully about making education, training, and literacy a centerpiece of our investment. During the first Sputnik moment, the US government invested a lot into education and research and writing textbooks, and we're not doing that now.
And from your understanding, right, that education, that investment, that work takes dollars, right? That will take money.
Absolutely, right?
Do you think it would be reasonable to have the companies that are profiting from broad use of AI and are the ones who are actually driving a number of the layoffs, do you think it's reasonable to have them be paying into those systems to make sure people can be retrained?
Absolutely, and I think we have already a mechanism here. So we have Empire AI has been mentioned, right? Empire AI by New York State is thought of as just like a bunch of hardware, right? But it really should be thought of as an infrastructure for democratizing AI R&D, research, innovation, development. And so what it has to have along with the hardware is also a community of educators and support from companies that are profiting but with no strings attached, right? So the state can be a kind of a clearinghouse where we can then go and we apply for that funding, but companies shouldn't dictate what we work on or how we spend that money.
Thank you.
Yep.
We also have second round questioning from our Chair of Science and Technology, Assemblymember Otis. Go ahead. Go ahead. Well, we started the second round, so I think we're going to go Otis, and then I'll go for my second round. But go ahead. Yeah.
I had a question for Professor Friedler. In your testimony, you talk about some situations where AI should not be used, and gave some examples in your testimony. But is there, in another jurisdiction, anyone who has enacted a hard list, or do you have in your mind a hard list of uses that should be prohibited? And if you don't now, you can tell us your thoughts now, but if you don't now, we'd love you to share that with us post this hearing if that's something that is certainly a priority for you in your testimony. Thank you.
Yeah, thank you for that. So what we've seen in other jurisdictions, which I think is also in line with the approach you all have taken in this bill, is a sort of contextual view on what should be prohibited, right? So for example, and I mentioned this in my testimony, the prohibition of facial recognition use by law enforcement, right? So that's not the prohibition of facial recognition use for tagging your friends in photos, right? It's not a prohibition on that sort of type of technology. It's a prohibition based on a specific high-risk use case, right? It's saying, you shouldn't sort of let law enforcement go ahead and just sort of find leads based on running somewhat arbitrary facial recognition searches. It should be based on like a warrant. It should be based on particularly high burden crimes and so on, right? So they sort of lay out these types of contextual boundaries around that. The other one that I mentioned that I think would certainly go on my list to consider is use of affective computing, again, by law enforcement. So this is technology that purports to be able to take a video or an image of someone and detect if they're lying or detect how they're feeling. The technology doesn't work. Just sort of as a baseline, it just doesn't work. But there's also, reasonable research showing that there are reasons to believe that it will never work, right? That we as people cannot do this accurately enough to expect that we would be able to train an AI system to also be able to do this. But of course, law enforcement would love if they could take a picture or a video of someone and determine accurately if they're lying, right? And so you can see where the risk lies there, that the police departments will be sold essentially totally bogus technology, happily pay for it because it then allows them to claim, right, other things that they may want to be able to claim. And so I think that one is also a good one to consider really carefully.
Would enjoy continued conversation with you about that whole concept, and I'd only say, as to your sort of lie detector analogy, George Costanza claimed that he could beat a lie detector because he said, if you believe it's true, it's not a lie. No, that's okay. Thank you.
No, thank you. Also a big Seinfeld fan. I certainly appreciate it. I have a few follow-up questions for my second round, but again, I think that all of this highlights a lot of, quite frankly, the hypocrisy we heard in the first round of questioning, which is that, we acknowledge there are problems, but we don't have solutions. And if we try to regulate, then that's just not feasible for our companies, right? That I think you've very well articulated why that isn't true. I wanted to start again with you, Danny, because at the end of our last panel, I asked the Partnership for New York, which represents a number of business organizations, if they had any feedback on their memo of opposition to this bill that said that the scope of the audit was too large and what a narrower scope might be for both the audit and the bill. And they said they didn't have an answer because they weren't an auditor and they would leave it for the auditors to answer. I think it would be helpful then in that context for you to talk about what the normal scope is for an audit and really how they work. Yeah, thank you.
Yeah, sure. Our clients are actually free to scope their ISO certifications how they see fit. That said, what we do advise is when we know they are obligated to comply with regulation, that should be a major input into how they scope their certification, right? You would want consistency between, if you know you have to comply with New York's Eventual AI Act or the EU AI Act, and there's a specific use case that you have that falls within the purview of that act, you should just probably be scoping your ISO 42001 certification around that such that you are getting the most value out of the audit process, the disciplines that you implement within your organization around the impact assessment, around how you've assigned responsibility and accountabilities and authorities and the ongoing monitoring. That is all consistent with, basically where you reside from an ownership perspective with respect to regulatory compliance. So.
Thank you. Thank you for providing an answer that is concrete and doable. And I think again, another theme is that both in the bill, since we're not codifying any specific standard, and I think we are considering referencing ISO as well, right? There is flexibility to meet companies of all sizes.
Correct.
And to also be specific about what of course, what is a high-risk use case, but also what they're scoping in as a high-risk use case. So thank you for that. I wanted to also turn to the rest of the panel on this notion that the laws that we have in place are fine. That it's sufficient. That somehow all of the cases we've listed are outliers, and that what we have is fine, so we can litigate this through the courts, and that is enough to protect New Yorkers. I know that's not the case, and I think we just heard there may be certain technologies and use cases that will never be perfect. I'd love to hear a little bit more about your perspectives on the need for regulation, or certainly if you find that today's laws are sufficient to address these issues. And it can start in any order, or either end, and then work our way down. Thank you.
So I think one of the key reasons why I think the types of steps that you propose are different than the current remedies that exist is because they are proactive, right? Companies are supposed to do these things so that people won't be harmed, as opposed to waiting for someone to be harmed, right? And then forcing them to sue for redress. And I think that this has then the potential to actually limit the resulting harm in a way that those other systems just don't.
Thank you. I don't know, are there...
Maybe comment very quickly, right? So one of the cases that we surely all have heard about lately is the Grok non-consensual pornographic images debacle, right? And this is something that has happened in the current regulatory environment, right? And it is not an outlier. This situation is actually something that the current lack of regulation at the federal level incentivizes, right? Because for Grok, for X, it's beneficial to have a lot of attention attracted to them. It's a market differentiator, so it's a feature of the lack of regulation. And then the question is, do we in New York State want to be known for producing and supporting companies like that? Or do we want instead to support responsible innovation that's actually beneficial to people individually, to the market, etc., right?
Thank you. Yeah. And I don't know if there are any additional responses, but yes, please.
Yeah, I'll comment on that. We actually get something similar, ISO 42001, and a lot of AI standards that have come out have received similar oppositions. I've heard that existing security standards are sufficient. We don't need anything specific to AI, but I think it's important to understand that whether it's an ISO standard or another security framework, those weren't designed with the idea of accounting for these risks that are unique to AI. When we talk about fairness, bias, safety, ethics, responsible and ethical use, I mean, that's not why these standards were designed. So they're inherently not covering them within their scope of purview. So it's just an important perspective to take on that type of response.
And to meet this moment where we have, I mean, AI broadly has been around for a very long time,
Correct.
but with emerging technologies and generative AI, to meet the moment, we do need additional, I would argue, pieces of legislation. So thank you. I have a little time left, but ultimately, I never want to miss an opportunity to hear all of the wisdom and insight on this panel. So I'm going to leave it open to all of you if you have anything that you know would like to offer us, and certainly for the record. In this conversation, any final or closing thoughts? Yeah.
Actually, I would like to comment on sort of the nature of what is needed to conduct good evaluation. So one of the things I think everyone's been dancing around is that I call it vibes-based evaluations, where generative AI technology, and Dr. Friedler pointed this out, is fundamentally different from machine learning models. And just to get like slightly technical for a second, machine learning models are statistical models. They are centuries of mathematical work. Like, I have a degree in it, Dr. Stanovich, we all know how to do the kind of math needed to audit and evaluate machine learning. Generative AI is slightly different, mainly because the output's probabilistic. In other words, sometimes in machine learning world, 2 + 2 is 4. In generative AI world, 2 + 2 is somewhere between 3.8 and 4.3, and sometimes it's 99. And that, to be fair, does make it difficult to do assessments. But this is why we need things like repositories of common use cases. Companies need to learn from each other. We need to actually be able to test and develop further testing at scale, as I mentioned earlier. But we also need to make sure that a large volume of people are doing this work. So again, just want to emphasize the need to cultivate the community of auditors. If people are saying that there are not enough people doing this work, an act of God does not make this stuff happen. It happens because of investment, because of education, and also opportunities to do this work.
Yeah. I think one thing I wanted to add earlier was that, you know, they're saying there isn't a big enough industry for this work, and yet the private sector, the companies using these tools, aren't investing in doing this. And I feel like it would actually help build up. I mean, but the work's already happening, to your point, and it needs that type of consistent partnership.
The only thing I'll add is my global services status on United begs to differ. I have more work than I can actually do, and I truly wish there were more people I can collaborate with to do this work. We are a very, very small community, but I will add, we're also all very tired, and we would love for there to be more people to do this work with us.
I think that's the code of the day. We are tired. We want more people to do this work with. So thank you. I appreciate that. And certainly for the rest of the panel, I want to make sure we capture any closing thoughts or anything that we have not covered yet that you want to make sure. Julie, go ahead.
There's something to say. I apologize, but so if there was one terminological problem that I had with the bill, it's that it denotes people as users.
Mm-hmm.
I think we should go back to calling people people, because a user presupposes that you actually are somehow actively choosing to use a piece of software, which is not necessarily the case here, right? And the reason I think this is important is because our goal ultimately is to create a regime of distributed accountability, where people in different positions, different roles understand what it is that they can do to make sure that we use these technologies responsibly. And when we take that point of view, then I think it helps us understand that we need to pay closer attention, for example, to education and training, but also to individual data rights.
Mm-hmm.
And this is another component of the bill that I wish was stronger. I understand that there is also privacy regulation that you're thinking about, but I think it needs to really be integrated here, because people should be able to decide how their data is used.
Yeah,
So it's used to
certainly on the
treat
rights
them
based
and not to jack up their insurance premiums, for example.
Well, I definitely appreciate making the bill stronger. And when we've heard a lot of the opposite today, so thank you. And sorry, go ahead.
So I just wanted to sort of reflect on this question about sort of machine learning versus generative AI, right? And a lot of the high-risk use cases that the bill covers are really sort of operating under an older sense of AI. But I wanted to, I guess, close by emphasizing that this set of algorithmic discrimination problems that you highlight in the bill are not going to go away under the shift to generative AI, right? Even as these same types of decisions start to be built on top of generative AI systems, we are already seeing audits come out of the research community especially that demonstrate that these same types of discriminatory outcomes will continue to exist.
100%. And that is a perfect note to end on. Again, I want to thank these incredible panelists for joining us today. I want to make a quick announcement. We are breaking for lunch for 30 minutes. There is pizza in the other room for anyone who wants here. Looking forward to seeing you all back at about 2:50. But again, thank you so much, panelists. Thank you. Congregating again. I'm going to wave down. Yay, I got the thumbs up. All right, perfect. So I want to thank you all for coming back. I know this is the post-lunch panel, but I think that's a good thing because I feel like I have come back refreshed, ready to hear all of the incredible things you have to say. And I will, for my colleagues here, say that these are, again, are a panel of advocates, but really you all are some of our closest partners in this work as we've been talking about legislation, talking about broader industry issues. I deeply appreciate all of you for working so closely with our office. So it's good to see you again. It's good to see you in person. We are today joined by representatives of EPIC, the Consumer Federation of America, and the Center for Democracy and Technology. I'm going to turn it to each of you to give your testimony. You'll have 5 minutes to begin. Then we'll get into member questions and first round and then do a second round as well. So with that, I'm going to invite Kara, you to start first and then work down the line to give your opening testimony. Thank you.
Can you hear me? Yes. Okay, I heard it. Yeah. Thank you, Chair Gonzalez and members of the committee for inviting me to testify today and for your leadership in addressing AI harms. My name is Kara Williams, and I'm an attorney at the Electronic Privacy Information Center, or EPIC. EPIC is an independent nonprofit founded 30 years ago to secure the fundamental right to privacy in the digital age. EPIC has worked closely with state lawmakers across the country on tech issues like these for years, and I'm here today in support of S 1169A. This bill tackles an urgent problem. Companies across sectors use AI systems every day to make important decisions about our lives. Whether we get a job or admission into a university, if we qualify for a mortgage or a loan, how much we pay for rent or insurance, and whether we can access healthcare or legal services. Right now, New Yorkers have no way to know whether companies are using AI and making these decisions about them or how these AI systems work. And unfortunately, the truth is that these AI systems often do not work. Many widely used AI systems are known to produce inaccurate and discriminatory results. Fortunately, Senator Gonzalez has worked closely with numerous stakeholders to solve this problem and to craft a solution that is right for New York. Passing S 1169A would protect New Yorkers from the harms of unregulated, high-risk AI systems in 3 key ways. First, this bill will require real transparency from developers and deployers about the AI systems they build and use. This bill will also give important rights to New York residents who are subject to decisions made using these AI systems. Under this bill, companies would be required to inform individuals if they are going to use a high-risk AI system to help make a decision about them. New Yorkers would then have the right to decide for themselves whether to opt out of the use of AI or whether to appeal the decision. These disclosures will help narrow the huge information asymmetry that exists right now between companies that develop and use these high-risk AI systems and the individual people who are subject to them. Second, this bill places essential auditing and assessment requirements on companies creating and using AI systems. EPIC supports the independent auditing and risk assessment requirement because ongoing independent audits, as you just heard in the last panel, have long been an essential safety measure for new technologies. This testing will ensure that AI systems in use in New York will be safer, fairer, and more accurate than they are now. Companies, especially in the tech industry, often claim that these testing and transparency requirements are onerous, unnecessary, and will stifle innovation, some of which you also heard today. But I want to take a minute to debunk these claims. Testing requirements that increase the safety and accuracy of AI tools are broadly popular among the public, and research shows that the vast majority of Americans favor them. A recent Gallup poll found that 80% of U.S. adults believe that the government should maintain AI safety and data security rules, even if it means developing AI at a slower rate. The same poll found that 72% of adults believe that independent experts should be the ones testing these AI products before they are widely used. Requiring these assessments is a balanced approach to ensuring new technology is safe and equitable before it is adopted and used. And it will also help build public trust in these new technologies. Finally, the third way this bill will protect New Yorkers is through its robust enforcement mechanisms that will incentivize companies to comply with these obligations. Companies are required to submit information about their AI systems and practices to the Attorney General under this bill on a regular basis, and then some of this information will be made publicly accessible. Requiring some information to be posted publicly is particularly important, both as an incentive for compliance, but also as another measure that will help reduce this information gap. A public repository of high-risk AI reports will give researchers, journalists, advocates, and the public a window into the technology that companies are using to make consequential decisions about people's lives. Finally, EPIC commends the inclusion of a private right of action in this bill. Making this remedy available ensures that New Yorkers will be able to vindicate their rights in court if companies do use AI to discriminate against them. The risks of relying on AI systems to make important decisions about people's lives are real, and people are being harmed every day by the unregulated use of this technology. S 1169A would be a welcome step toward mitigating those risks and giving New Yorkers more autonomy over their important life decisions. Thank you for the opportunity to testify today, and I'm happy to answer any questions.
Thank you. Thanks.
Great. So thank you so much to Senator Gonzalez and to the committee for the opportunity to address the committee. I am Dr. Travis Hall. I am the Director for State Engagement at the Center for Democracy and Technology, a nonprofit, nonpartisan organization fighting to advance civil rights and civil liberties in the digital age. Prior to my time at CDT, I spent 10 years working on technology and telecommunications policy at the National Telecommunication Information Administration, where I actually got to overlap with Dr. Friedler, and we worked on the AI Bill of Rights together, an agency within the Department of Commerce. CDT works on many issues touching on various aspects of artificial intelligence and algorithmic systems and related technologies. It also has work streams specifically focused on digital rights in fields relevant to automated decisions, including workers' rights and disability rights. I'll be describing some of the risks from the use of artificial intelligence systems and the ways in which SB 1169A helps to mitigate some of these potential harms. First off, AI is rapidly reshaping how Americans learn, work, and are evaluated. If deployed responsibly, AI does have the potential to expand opportunity, improve access to services, and support consumers and workers in meaningful ways. Generative AI systems have allowed for the introduction of consumer-facing chatbots that perform leaps and bounds better than their predecessors from just a few years ago. AI is also showing promise in the area of scientific and medical research. But without clear guardrails, transparency, and accountability, AI systems risk reinforcing existing inequalities, eroding civil rights protections, and shifting power further away from students, workers, and families. Not all applications of AI are beneficial, especially when it comes to their impacts on vulnerable workers and consumers. Entities increasingly use AI systems when determining who to hire, mortgage rates for bank customers, and who can access public benefits like SNAP or Medicaid, and how we all pay for life's necessities like healthcare and rent. Unfortunately, there is considerable evidence that many such AI systems are biased or simply don't work, and that removing such bias is actually quite difficult. At the same time, the lack of transparency surrounding companies' AI practices means that workers, consumers, and regulators only rarely catch a glimpse of when, how, and on whom these tools are used. We do not have a clear picture of how, nor how many companies use these technologies because information disclosure about AI systems is use is sporadic and inconsistent. And if there is disclosure of the AI system use at all. That said, considerable anecdotal evidence suggests that the practice is already widespread. Surveys of companies indicate that anywhere from a third to the vast majority already use AI systems in recruitment and hiring alone. But we often don't know which companies are using these tools, nor which workers or consumers are being affected by them. Stories about harmful AI systems, uses of AI systems have come to light thanks to whistleblowers and investigative journalism. ProPublica has published a trio of reports on how healthcare giant Cigna secretly used an algorithm to mass reject policyholders' claims and then threatened to fire a physician who pushed back. The significant information asymmetry surrounding ADSs, or AI systems, automated decision systems, provides a strong reason for regulation because existing civil rights, labor, and consumer protections cannot be enforced effectively when the role of AI is hidden or obscured. In cases where consumers and workers have to interact with the systems, as is the case with many automated employment assessments, the systems are often inaccessible and offer people with disabilities few or no options for accommodations or alternative assessment methods. CDT have found extensive discriminatory impacts caused by AI systems. The 2020 CDT report highlighted how algorithmic hiring tools can discriminate against disabled job candidates, noting that as these algorithms have spread in adoption, so too has the risk of discrimination written invisibly in their code. Other CDT publications have highlighted how electronic surveillance and algorithmic management, or bossware systems, are used in ways that can violate rights and threaten health and safety of disabled workers, how surveillance technologies discriminate against disabled people, and how tenant screening algorithms can disproportionately exclude disabled people, among other marginalized groups. These biases and barriers to accessibility cannot be addressed without basic transparency regarding when and how automated decision systems, or AI systems, are being used, and what those systems measure, assess, and how they measure and assess it. Systems that are unreliable, inaccurate, or biased against individuals with disabilities or other people from marginalized communities likewise will not be detected unless companies conduct impact assessments to identify potential sources of inaccessibility, bias, and invalidity. SB 1169 would put in place a number of necessary provisions providing transparency and accountability to developers and deployers who use systems in high-risk consequential decisions. The focus of the bill is solely on systems that are a substantial factor in consequential decision or will have a material impact on statutory constitutional rights, civil liberties, safety, or welfare of the individual or state. This is narrow tailoring scope of the bill, focusing on only the systems that affect individuals' lives, livelihoods, or fundamental rights. I have a little bit more to say, but I'm just going to close with thank you so much for the opportunity. I really look forward to your questions.
Thank you so much. Thank you. Go ahead.
Chair Gonzalez, members of the committee, thank you so much for inviting me to testify today, and thank you so much for your continued work on this issue. My name is Ben Winters. I'm the Director of AI and Privacy at the Consumer Federation of America, or CFA. CFA is an association of over 200 nonprofit consumer organizations at the state and federal level that was established in 1968 to advance a consumer interest through research, advocacy, and education. CFA is based in DC, but I grew up and spent a vast majority of my life here in New York State, so I'm always thrilled to be able to testify in here. So CFA is supportive of the New York AI Act and urges you to advance the bill. New York has done well to address future-looking problems with frontier AI systems through something like the RAISE Act, but we can't move past the desperate need to regulate the way so many important decisions about people's lives are mediated through AI decision-making tools. The status quo is that you wouldn't know if an AI is being used to make an important decision about you, and if you wanted to investigate details about that decision, you would be out of luck and reliant on corporate goodwill. The New York AI Act addresses the persistent and opaque algorithmic discrimination found in hiring, housing, healthcare, consumer goods pricing, insurance, finance, and lending, and it fills the confounding gaps that remain in the simple knowledge, let alone by simple knowledge that a key decision in your life is being made with AI at all, let alone by what company and whether they tested it for accuracy or tailored it appropriately. This bill provides clear roadmaps for trust to be earned, which is essential both for the public and for companies. Well before people heard about and saw ChatGPT in November 2022, there were countless documented examples of algorithmic bias being surfaced in all of these issues, and those continue to remain today. Use of some of these tools continue, and I detail those in my written testimony. I invite you to look at those as well. And now there are even less reliable systems also being used that use large language models as part of the decision-making process. It's plain and simple. Untested, broken, opaque, and discriminatory automated decision systems have no place making important life decisions for New Yorkers. Beyond achieving just this, the law creates necessary whistleblower protections and draws a clear line banning social scoring, a common sense consensus measure that is as urgent as ever with an increasingly authoritarian regime at the federal level. This approach specifically is smart and addresses common industry criticisms. There are frequent concerns about overbroad definitions, lack of exceptions, and an untenable sort of standard for liability. Here, the definition of ADS is clear and targeted and has common sense, explicit sort of exemptions for things like spam filters or Google Maps, which is often something that industry pulls up for you. The standard here is that they have to take reasonable care to prevent foreseeable risk of discrimination, not that they could be sued for any potential discrimination that occurs in the use of their system that could not have been foreseen. This bill also creates a safe harbor for developers that are acting in good faith. That protects innovation, not damages it. It also addresses the deficiencies in other existing AI hiring laws, like Local Law 144 right here in New York City, and it goes beyond the data-driven pricing law, but just focus on transparency here in the state. Transparency alone only gets us so far, and New Yorkers all throughout the state should be able to enjoy similar protections. One recommended change I'd make is to include the content from Section 88, which focuses on the high-risk AI system reporting requirements, and putting those in the location where you would have to make a decision to opt out of a decision, because it really helps you make a more informed decision about whether you actually want to be subject to that automated system. It's not necessarily the presence of a system that causes problems. It's one that is discriminatory or otherwise unacceptable. So life in the digital age is increasingly unfair and deceptive. Algorithms mediate critical determinations for New Yorkers. Again, housing eligibility, hiring decisions, credit rate determinations, what content they're shown on social media, and more. This is often done with no transparency and no choice for consumers, to the detriment of us all. The New York AI Act would benefit New Yorkers by establishing strong protections against harmful biases and discrimination in AI systems without levying significant burdens onto businesses. Urgent action is needed, and I urge you to advance this bill. Since I have a few seconds left, I just want to flag on a few things that we've heard throughout the day. So I think there's, the implication that because there's a highly regulated industry already, like banking or healthcare or fill in the blank, that just because they are regulated in some ways means they cannot be regulated in any other way. I think that is nonsense, and just want to make sure that's clear. They have the compliance teams in place, and they understand that they have to do it. This bill would not stifle innovation. I want to say that as many times as possible. The suggestion that they could not adopt AI systems with this bill's recommendations and requirements should be a massive red flag that they have no idea what they're doing. So, thank you so much. Happy to take any questions, and again, appreciate your work.
Thank you so much to the panel. And that is a perfect segue to my first question for the full panel, which is really in response to the many, pieces of feedback we heard earlier that the existing civil rights laws or laws on the book are enough. I think I'm hearing from you, Ben, that is not the case. So I'd love to hear from the full panel on if you agree with that, and if not, why.
So why don't I go ahead and
Yeah,
I'll just
go
start
ahead.
off, since I kind of touched on it in my testimony. Why is AI different? What is different about AI systems? And one of the primary things that is different about AI systems is that it does obfuscate. And it obfuscates a number of different things. It obfuscates how decisions are being made, what information is being used or pulled to make a decision, because it's not just simply the input information, but also the training data. But then it also, really importantly, obfuscates responsibility. And so in as much as we have laws on the books about employment, about housing, about civil rights, all of these different things, the problem is this obfuscation of responsibility. And in as much as we're hearing, oh, it's so hard to decide who's responsible, the developer, the deployer, well, that's what we're talking about. If you're a regulator or if you're an individual and you need to figure out, oh, I have been discriminated against, how did this happen? Why did it happen? Was it because of something I did or said? Or is it because of who I am or my protected class or because I am disabled? That type of transparency is desperately necessary for people to actually enact their own rights and for regulators as well. So in as much as you're hearing that it's difficult for these companies to decide who's responsible for something, that's why the transparency that this bill provides is desperately needed for regulators and individuals to actually enact and enforce the laws that are already on the books. So in as much as there's a call for study about what the gaps are, that obfuscation is the gap, and the remedies that are being presented are those remedies.
Yeah, I'll echo everything that my colleague just said, and I'll also add 2 additional points onto that. First, I would love for us to back up a step. In order for you to exercise any of the rights that might exist right now, you have to know that an AI was used against you. And without this bill, New Yorkers have no way to know that. So that's step 1, or step 0 even. So secondly, I got too mad about step 0. It'll come to me. Ben, did you want to jump in?
I think the only thing to just add, and to add to Travis's point, the transparency does not just mean an AI is being used here, right? The whole accountability, the high-risk reporting requirements, key parts throughout the bill is what actual transparency means, right? We have seen several things, including Local Law 144, and some of the reasons why it is troubling is because the requirements are not specific enough and are not communicated to the consumer well enough. So I think I just wanted to flag and make clear that transparency is not just the presence of a system, but everything that's in this bill and more.
I remembered number 2. You've heard this a couple of times earlier, but I wanted to put a finer point on the fact that existing laws, existing civil rights laws, and anything that Travis outlined is only going to help you after a harm has happened. This bill has a series of important requirements for independent audits, risk assessments, risk management programs that will help mitigate the harms in the first place so that we won't even have to get to the existing laws on the books.
Thank you. I certainly agree with everything said. And I also get mad about point zero, so don't worry. We heard a number of other claims kind of in rapid fire. Would love to get your thoughts on these. That regulation and certainly the New York AI Act would interfere with innovation. Is that something that you find accurate or not? Yeah. And feel free, we can start in any order. Yeah.
I'll just start again first. I mean, the last panel put it very well in terms of, that you need to have, at the end of the day, we all, actually, let me take a slightly different tact on it. Businesses need to know that the systems that they are procuring from other businesses to do their hiring and to do their assessments, that they actually work and that they are not going to put them in legal jeopardy, right? Right now, the requirements for actual transparency and documentation upstream do not exist, such that the mom and pop stores can actually know that, oh, I'm using this system. It says it's going to do it so efficiently and so accurately, and everything's going to be great. There's no way to actually verify those claims to actually know that what they're saying is right. And so in terms of innovation, in terms of actually empowering the smaller businesses to actually utilize the benefits of these systems, they also need to minimize their liability, right? In as much as, you're a taco vendor, you need to know that the tortillas that you're buying and the cheese that you're buying is not poisoned, right? And right now we have an FDA that allows for that. We have transparency that allows for that kind of thing for the downstream folks to actually be able to understand that. We need that kind of transparency here as well.
No, it's not an accurate claim. Be my answer.
Sorry, go ahead.
I'll just add one small point. In addition to the point I made in my earlier testimony that Americans in general, by and large, don't want unsafe products. They don't want AI that has been innovated just for the sake of innovation. Innovation needs to center the human values that that are prioritized in this bill. And yeah, there's no truth to the claim that this bill or any bill like it stifles innovation.
Certainly. And to the point, I think trust is at the heart of everything we do. I think our constituents deserve to trust that we have a government that's responsive to those needs and willing to be proactive with our legislation and take on big tech in order to represent their, and by their, I mean our constituents' interests and not just corporate interests. And certainly they need to trust that the tools that they are using have quality assurance, right? Another piece of feedback we consistently hear is that regulation will benefit our global rivals. I also wanted to connect that a little bit to taking a step back and not just looking at New York State, because I know you all work across the country, but we hear a lot about New York. Not only that regulation will benefit our global rivals, but New York will somehow not be attractive for business. And we also know we have an executive order and administration on the federal level that has actively push back against state regulation. So I'd love to hear your thoughts and responses to that, having been folks who have worked on this internationally, but certainly across the country. Anyone who wants to start? Yeah.
Oh, yeah, go ahead. I've started the last few times, so you start and then I'll go in.
Okay, so I think in response especially to the point about the federal efforts to tie states' hands from regulating on these technologies, I'd like to draw the comparison to a lot of things that you heard this morning in the tech industry panels that were urging you to wait, not to do anything. You don't need to worry about it. They'll do it by themselves. That's kind of the same message we're hearing from the federal government right now in terms of preemption on AI. Don't worry about it. We have it. But we've seen very little federal action on anything, to be quite frank. And I'm not holding my breath for them to be the ones putting safeguards around these technologies. So I think it's very prudent and incumbent upon states, including New York, to do something to protect their own constituents instead of just sitting in the face of the proof that we have of these harms continuing to happen day in and day out.
So 2 quick points. One, just to be absolutely clear, the executive order is a threat and bluster. It doesn't actually preempt anything. They do not have the power to do that without an act of Congress, and Congress so far rightly has chosen not to preempt twice. And so, so I think that you should. I'm heartened by the fact that you are continuing in the face of that. The second, and I will also just simply say that folks who come and argue for not just caution, but to slow things down, while also going and arguing for preemption at the federal level, it is somewhat disingenuous, right? The second point that I would make is that in terms of where the national security point is that at its core, models aren't really developing much further at this point in time. The difference between ChatGPT-2 and ChatGPT-4 is small marginal differences. What we are in a race for right now is adoption and absorption in a way that is responsible and doesn't break our economy. Right? And so in as much as we are actually in a race, these types of laws and regulations that allow our society to actually absorb these tools in ways that are responsible, that is how we are going to win. Right? Not in terms of actually building the next biggest model, because in terms of that type of development, that's actually slowed down significantly.
Thank you.
Running out of time,
I know we're running out of time,
the-
but if you would like to close us out.
Second on the benefiting global risks, the global rivals part, I think that's just plainly not true for the reasons Travis is saying. But what it does do is it benefits only the absolute biggest companies. Not having regulation only benefits the biggest companies that have the army of lawyers and people that are funding the people that are coming here and yelling about innovation. They don't want innovation for small businesses and medium businesses. They want it sort of all to theirself. What this regulation does is creates an even playing field for innovation to thrive.
100% agree. I am going to now open it up for first round questions. And to start us off, I'm going to turn it to Senator Hinchey. Thanks.
Hello. Thanks for sticking with us here. And thanks for your testimony. We had heard we heard a lot earlier today. One of the things was really this kind of mission of building the plane while flying it, right? We are innovating extremely. It's really, really good. Yes, there are challenges. We don't want to talk about it right now. We'll deal with it in 5 years. We're still figuring out how to deal with it. That space. Do you believe that if unregulated right now and AI development was left to where the industry would like to take it, do you believe that there is an imminent threat to our workforce across this country, but here in New York?
I'm happy to start. I think that
I have 3 questions,
Okay.
so just FYI.
So I think
It'll be quick.
5 minutes for first round, 3 minutes for second.
Okay. I think the way that AI development and deployment is happening right now creates the conditions for false claims of innovation and need for automation, which lead to a lot of firings, playing around with people's jobs and lives. Sometimes they rehire people, sometimes they don't. But I think that, what we have seen again and again is that the unregulated tech industry extracts as much as possible from people. So I think, yes, we are on that trajectory, but it's unclear. And I think anyone that says they have exact numbers on it is probably not sure.
For the panel, do you believe that what you just described, that kind of playing with people's lives, uncertainty, do you believe that's a threat to our economy overall?
Yeah, so absolutely, the unregulated AI is a threat to our economy.
And finally, with those pieces, do you believe overall, left unchecked, that AI would be a threat to our democracy?
Absolutely. And it's a threat to our democracy now in the unregulated state it's in. So it's only going to get worse if we allow it to continue unchecked and allow these companies that are developing artificial intelligence to continue making their own rules and grading their own homework. It hasn't worked for any technology in recent decades. We're still trying to clean up the mess from the development of the internet and social media and seeing all the harms that it has on everyone, especially kids and teenagers. And I see no reason to believe that artificial intelligence would be any different or better.
And really quick, just a super quick, and it's such a missed opportunity because it could be good for all of those things, right? But it needs the guardrails, it needs the trust, it needs to be built in a way that that is actually responsible, and it's so unfortunate that that's not where we're headed.
Yes, it threatens democracy.
Thank you. With that, I'm going to pass it to Assemblymember Otis.
Thank you all for coming and testifying, and thank you for what each of your groups does. I will plead guilty to downloading reports regularly over many years that you put out on these topics. Very valuable stuff, and also good contributions in other hearings that both houses of the legislature have had over a number of years. This is such a fast-paced, changing world with AI. And I'd like to ask you to tell us, just maybe in the last year, are there new developments in AI or ones that you see coming that haven't hit us yet that you're worried about that maybe legislatures have not really got a hook into yet but need to be thinking about?
I can start briefly. Thank you for the question. I think there are new things, but the thing that the legislatures have not dealt with enough yet are all of these things we're talking about that have been around for the last 10 years and have just increased in use. And so the new things we're talking about are just the new versions of it, right? Constantly changing pricing for consumer goods or your insurance based off of your personal characteristics or browsing history. All of these little things that are extracted, we are seeing the crisis that is currently unfolding at X and Grok, right, with the non-consensual intimate imagery. There are these sort of continued uses of the same systems from these last years, and that's what I'm most worried about right now.
I hate to be too much of a prognosticator, but I would say that the one thing that really worries me that we are starting to see is commercialization, right? In terms of being like, so you have a chatbot that becomes your best friend, and all of a sudden it starts telling you about certain products, right? In as much as like we are seeing AI being the gatekeeper for information, where more information is being produced because of AI, and you can't really necessarily trust it all. It is at the same time the solution to the problem in being a gatekeeper, and then it's being commercialized to specifically sell you a product, or conversely, to specifically sell you a political message. That is really concerning in ways that it's probably not going to be very visible or are easy to grasp.
I don't have a specific new technology to add because I want to echo what Ben said and go back to the point that we are still cleaning up messes and trying to figure out the best solutions to pieces of this technology, which are just being amplified with the use of artificial intelligence. And what Travis was just saying about commercialization is an amplification of the problems that have existed with targeted advertising on social media for years. So it's really the root cause that I would urge lawmakers across the country to focus on instead of jumping on every new technology, because that kind of results in playing whack-a-mole, which might not be the best way to get at this problem at the root cause.
I appreciate all your answers, and Travis's answer is sort of like the advertising nightmare of, a real threat. Should I ask another question now? Keep going?
Honestly, feel free to take your second round.
Okay, so my second question is, and again, something that is sort of obvious but needs to be talked about a little, is the overlap between AI, cybersecurity, and data privacy. And they are all interwoven. They are really not three separate things. They're all one thing. But any observations you want to make to legislators about the need to understand them as a whole?
I think to Kara's point about getting down to the system level of what AI is, it is data. I always say that privacy laws and cybersecurity laws are all AI policy. They're all laws. There is no AI without data. It's the whole thing. And so I think just to like really reiterate the fact that AI is just, one of the biggest and the latest ways that data is being sort of collected, used, abused, and to Travis's point, commercialized for private gain. And so I think that there is an absolute continued increased risk. And just to that, to put a finer point on it, especially the large language models, the big AI companies, their whole game right now is how can we get more data at any cost? They have scraped the internet. They have paid $20 billion to MGM to get all the scripts and the books and whatnot, and they want any more data that they can get. So they are going to get increasingly desperate. That is their incentive. And so the more data you get, the more likelihood that it's abused or just breached. You could do everything in your power to be responsible about it, but any data that you're holding that you don't need to use will just become a cybersecurity risk. So I think it is all happening at once, and they're exacerbating each other.
I'll just simply, refute a point that wasn't made today, which is just simply that, AI is regularly used, to build on what Ben said, regularly used as the reason why privacy restrictions should be so minimal, right? That data minimization is bad because we need the data for artificial intelligence, but we are actively seeing the harms that are coming from an unregulated data economy, right? And so in as much as artificial intelligence is being used as the excuse to hold back from data privacy regulation, that is deeply concerning. And the thing is you can move forward on both, right? We did hear today that we can't move forward on AI without data privacy legislation. That is not true, especially with the legislation that is here right now that is about transparency, about the use of these systems in high-risk situations. We should also have data privacy regulations, but we can move forward in terms of transparency about the use of these systems while we continue to work on the other.
Well, I thank you. I just make one other observation, which is that for the security of the testimony of this hearing, I've spoken to Senator Gonzalez, and we're exercising the committee's right to delete, that they can't scrape any of the testimony from the whole day. I think that will help protect at least the mission that we have here. Thank you.
Yeah, that's great. If you have any other, I know you can second round. Or else
The
if not, I'm going to.
Well, we'll go on and may come back.
I'm happy to jump in with some of my second round questions. And then again, if anybody else has additional questions, feel free to get on stack. I again, just so have loved the conversation up until this point, because I think you've really driven home some of the themes from the last panel. I want to keep on, though, getting to the common critiques of the bill, because it's something you have all heard across the board and across the country. We talked a little bit earlier about what it means to have an executive order, what it means to have lack of federal regulation, kind of like a more international level. But I guess across the country, the idea of a patchwork has been where industry has really honed in on as like their major gripe. And I'd love to hear from all of you, having worked across the country, how you often respond to that. I certainly think that we've done a lot of work to actually try to be in line with other states like Colorado and Connecticut, but would be open to hearing if there's more we can do there.
Yeah, thank you for that question. I think I'll start off by saying that I hate to even use the word patchwork because it has become this specter that advocates invoke in order to stop you and scare you from doing anything. But this is a situation in a ton of different sectors. First of all, 50 states, 50 tax laws, 50 zoning laws, 50 almost everything that industries across the board seem to comply with no problem. Nothing is breaking down. That aside, just because other states have chosen to do different, to take different approaches in terms of specific pieces of tech, like a lot of states you heard earlier have moved on deepfakes or in terms of intimate imagery or elections or bits of the AI problem that we're working on, does not mean that a state needs to settle for that bar. There's no reason that a state cannot go above and beyond what the first state did, maybe. We hear this a lot in privacy legislation hearings as well, that there's a patchwork, and so states should just settle for, insert your state here, standard. But states iterate on each other. There is no reason to settle for the first thing that happened as the best. States, especially in this space, are in collaboration with each other, as you were mentioning, frequently, and are learning from what worked, what didn't work, what could be drafted better, what needed a definition. Even the minutia of the bills are really just an iterative process.
I would also just simply say that it's a fascinating kind of argument about artificial intelligence, right? Because artificial intelligence is a service that, particularly generative AI, is a service that can be, that you can actually train specific models for specific use cases. And that's like kind of what they do. And so in as much as you're training specific models for specific use cases within particular states, like that's what we're talking about here. And in as much as we're talking about high risk use cases, that means employment, housing, right? Like these are all locally regulated things already. There are national laws, but they exist in conjunction with local laws, and people already have to do that in these sectors. In as much as you are offering a broad scale kind of like for everyone type of thing, or you're a developer producing a model that could be used elsewhere, you have a safe harbor built into this bill, right, that says that you can just simply decide not to engage in high-risk uses within the state of New York, right? So the arguments about the emergent patchwork and how difficult it is to comply, I find difficult to understand when it comes to artificial intelligence, specifically given how customizable those products and services are and can be, and how they're being sold as such.
100%. I think that's a great segue to my next question, which is on the difference between traditional types of automated decision-making systems and generative AI. We talked a little bit about how over time this new technologies, every time they've been introduced, the internet, for example, social media, it's brought our democracy to the brink. But now with generative AI, we're at a point we've never really been before, and that the impacts not only on our workforce, on individuals, the scale, the ability to produce content with natural or human-like language, just really in ways we've never seen before. So I'd love to hear just maybe the differences, and specifically as it pertains to chatbots, some of the risks we've been seeing and thinking about when it comes to legislation.
I'm happy to start. I think the one key thing that I want to make sure to talk about is the fact that in 99% of the ways, automated systems like the simple algorithm that scans a resume and compares it to whatever you're looking for in a job, and ChatGPT are pretty much the same, right? I think of it as like 4 stages. There's the training and teaching and learning stage where you set up how the model works. There's the input stage where you have, either someone's information or the little prompt you write into a ChatGPT. There's the sort of processing of that information, the logic of the system, and there's an output that gets spat out. Whether that output is a recommendation for to hire someone or not, a number from 0 to 100 about how trustworthy an individual is, or a paragraph from ChatGPT, that same basic concept is the same. And so when generative AI has come, the whole sort of ballgame for them is to make you feel like you could never possibly understand it. It's not that crazy. It's hard, it's impressive, it's cool, whatever it is, but it is understandable and it is, able to be regulated. So I think I just wanted to touch really briefly on that point. And then, the big differences, I think even more than the black boxes of the past and present, chatbots are even sort of less, quote unquote, accountable to anything. There is this sort of, ability and misleading nature of the fact that you think you're talking to a person, whether that's a decision maker or whether that's the sort of consumer itself. There is that sort of misleading nature to it. And then, as you mentioned, there is the just vast scale, the scale of data used to inform it, the lack of transparency or sort of any common sense about where that information is coming from, and the complete lack of transparency there.
So 2 things really quick. First off, fun fact: the AI Bill of Rights that came out of the Biden administration came out before ChatGPT, right? We were already dealing with some of these issues, already talking about, already concerned about that. So there's a lot of like Ben said, a lot of it like kind of just scales over. The other thing that I would say is that is actually the same. You're asking about differences, but another similarity is that both old school algorithmic systems and ChatGPT, no, not just ChatGPT, but generative AI systems produce the outputs that they do because of specific choices and design choices. And so, yes, some of it is less predictable in terms of what the generative AI systems will produce, but they are still the product of choices about the training data, choices about how it's trained, choices about the limitations or the safety functions that are put on top of it. These are all still choices to which people can be held accountable, even if the system itself produces things that are interesting or different or whatever else. Also, the problem with generative AI, the glory of generative AI systems is also their problem, in that they make things that are not necessarily predicted, right? That's kind of the older systems, is making predictive systems. This is making things that are like new, but that means that hallucinations are a feature, not a bug, right? And so in as much as these systems are being made in order to make consequential decisions about people's lives, those hallucinations, that making up facts, is a feature that cannot be removed from the system without removing it being like its fundamental nature.
I'm only going to add one small thing because they covered almost everything that I wanted to say. I just wanted to pick up on a thread that Travis mentioned, was that these systems, whether it's a chatbot or an automated decision system, are made up of choices made by individual humans that can and should be regulated, and that oftentimes those humans developing the technologies will try to get the public, lawmakers, journalists to focus on, okay, what are the technical differences between, a chatbot and the resume screening tool example. But it doesn't really matter for the heart of the legislation. The differences and the nuances between the technologies are not the thing to focus on, especially in legislation like S1169A. We need to focus on regulating the harms and focusing on the context in which the technologies are deployed, which is exactly what you have done, Senator Gonzalez, in this legislation, and why it will be a very impactful way to regulate the harms from automated decision systems.
Yeah, no, certainly a point well taken in that it may, obviously, the things that concern me, maybe the scale, certainly the amount of investment and the bubble it's created on which somehow our economy seems now dependent, the rush to market without regulation, but ultimately these tools just continue to amplify issues that have already existed for decades, like algorithmic bias, obviously an inability to have oversight and transparency. And I think this bill really tries to get at the heart of that with our definitions, which is where we've gotten a lot of pushback, right? And that's when it's overly broad, that somehow industry wants generative AI to be looked at differently than maybe traditional automated systems. And the argument you're making is maybe our definition is not too broad because we should be encompassing of both, because at its core, there are a lot of the same themes and same issues. So I appreciate this, and it actually really is part of the work that we're trying to do here. So thank you. I don't have any additional questions, but I do want to take a quick look at my panelists to just make sure we are set.
One observation, you touched on it, the issue of the variation in different states. I have a simple answer to that, which is I'm sure there's an AI tool for that.
Read our bills. All right, it looks like we are all set on questions. I want to thank the panelists again for their time and flexibility today, and look forward to working with you on this bill. Thank you. Thank you. Thank you. All right, I'm going to invite the next panel to come on up if you are, yeah, I see a few in the room. Thank you.
Thank you.
Thank you, guys. you all so much. Okay. All right. Well, thank you so much for joining us today. This is our final panel. Last but certainly not least, we are joined by a number of community organizations. I want to say thank you to the representatives of STOP, Just Futures, the NAACP, and the New Economy Project for your appearance as witnesses at today's hearing. I'm going to open it up to all of you for testimony. You'll have 5 minutes, and then we'll have questioning from the members. I'm going to start over with you, Ronald, and then we'll work our way down the panel.
All right, sounds good. Okay, thank you all for giving me the opportunity to speak here. My name is Ronald Thomas, or Rod Thomas. I serve as the Technology and Innovation Chair for the NAACP New York State Conference. I also am a Managing Director of a global technology consulting firm. I bring over 2 decades, 21 years of implementing data centers, cloud, technology, AI, automation for Fortune 500 companies. So I do that in my day job, in and out. I'm here on behalf of the NAACP New York State Conference to express our support for the proposed legislation. I think it really does highlight some of the key priorities that the NAACP is pushing forward. So interested in talking to you about some of those things. So I know you already have the written testimony. And what I'd like to do, if possible, is maybe when I'm talking to CIOs and CTOs, I try to simplify things a little bit and give examples on why these things matter. So one use case that I was implementing recently in the past 5 years was implementing a program targeting low-income communities and giving jobs to low-income folks in low-income communities. And in the first year, I looked at the data and I saw that about 90% of the population was Black and Latino. I was like, okay, that's representative. The applicants from the community were 90% and the output was 90%. That made sense. So a few years later, I then looked at the data and I saw that it completely changed and the applicants were now 60% Black and Latino. So I went back to the team and I said, wait, hey, what happened? And it was like, oh, actually, we automated everything, streamlined things, use AI now, and everything's sort of moving. And I was like, well, okay, but something changed. So we had to go back through the data set. We looked through the decision tree. We looked through all the model, and we saw that because somebody had said some of the applicants were being late to work, the AI inserted that it made sense to only hire people that were within 45 minutes from the office. And what that did, though, is it then started to cut off people from the Bronx, people from Queens that were in the low-income communities towards the outer boroughs. And then it changed the demographic of the people getting the jobs. So I say all of that because that transparency that you're talking through and the accountability is very important. We have all of that when we're implementing these systems in technology. And we're trying to do the right thing. I don't want you to feel like these big tech companies, I don't know if they're trying to do the wrong thing, but there's unconscious bias that gets laid into there. So that's a part. Lastly, I don't think the market's going to self-correct itself, and that's the whole reason for civil rights in the first place. So having these clear guidelines up front, believe it or not, helps us accelerate. Having this information now, as I'm building the models and building the LLMs, just makes it easier as opposed to going back and retrofitting and trying to figure out where the harm was and how to fix it. So having these things up front allows us to actually accelerate innovation. And then another point was really around when I'm talking to a lot of these CIOs, it's really around speed to value, it's around operational efficiencies, et cetera, and we're committing to 30%, 50% efficiencies in workforce. So taking all of that out, and we're also telling them, all right, you get all these efficiencies, you should reinvest a portion of that. I think it would be good from a governor's perspective to put some guidelines of what that reinvestment should look like. And making sure that we're saying reinvestment, it's reinvestment in upskilling in talent, it's reinvestment in upskilling in the community, but there's a whole pie to the workforce that we need to make sure we continue to push forward. And then, so lastly, I just wanted to say that, from an NAACP New York State Conference perspective, we support this. We feel like this bill is addressing some of the unconscious bias that could be harmful. It does talk about the transparency and the auditing. It does talk about how we need to reinvest in secure capital and making sure that we can invest in the community and build up those skills. So yeah, I just wanted to thank you for the opportunity and look forward to the questions. So.
Thank you. Thanks.
Good afternoon. My name is Corinne Worthington. I'm the Advocacy and Community Engagement Manager at the Surveillance Technology Oversight Project, otherwise known as STOP. STOP advocates and litigates for New Yorkers' privacy rights, fighting discriminatory surveillance in various contexts. Thank you to Chair Gonzalez and members of the committee for the opportunity to testify here today on the New York Privacy Act, or the New York AI Act, excuse me. Use of AI has expanded widely across sectors and industries, affecting the lives of New Yorkers daily, whether they know it or not. The speed with which this reliance on algorithmic decision-making has boomed means that laws have struggled to really keep up with the technology that we're seeing. And the necessary regulations and safeguards needed to protect New Yorkers from the harms that accompany these powerful tools. It's critical that the legislature takes steps towards addressing the discriminatory threat that surveillance and AI poses, and create mechanisms for unjustly impacted New Yorkers to seek remedy. I would like to commend the sponsors and bill drafters on this piece of legislation. We deem it to be one of the most comprehensive AI governance proposals, both in New York and nationally. And STOP would like to offer our support for the bill's passage with a few key amendments and clarifications. My goal in speaking here today is to outline the substance of these desired adjustments and obtain a few explanations for key provisions from the drafters. Some of the components that we view as being vital to effective AI regulation are the whistleblower protections and the codification of a clear and comprehensive definition of what constitutes unlawful discriminatory practices. Those included in this bill are some of the first in the nation included in legislation, and we really support the bill's holistic approach to regulating AI. One of the other key pieces that we view as making this bill so strong is that when it comes to AI development and deployment, there's a widespread lack of transparency regarding algorithmic processes, making it difficult to really assess risk and ensure safety from an external perspective. Requiring developers and deployers to conduct rigorous and independent audits of their systems and report on those findings is really the first step to cut down on this opacity surrounding the AI threats and offering effective paths to remedy. However, given the immaturity of the AI auditing industry, which I'll expand upon in full momentarily, these requirements are not sufficient guardrails. Perhaps more important than these is the fact that the legislation includes both a private right of action and an essential burden shifting mechanism. Because AI systems are largely black box systems, meaning that we don't truly know how they work from the outside, it's unjust to expect individuals suffering adverse outcomes to prove algorithmic discrimination when they seldom have access to these actual systems and algorithms. By shifting the burden of proof from plaintiffs if and when litigation becomes necessary to developers and deployers, creates a more effective way of addressing the actual harms of AI. Some of the changes I'd like to address are regarding the framework and standards for actual auditing. The bill cites the NIST risk management framework. And despite these standards' frequent use in an auditing capacity, they weren't actually developed as an auditing framework. And while they provide broad stroke aspirations for what AI should look like and how to address harms, they don't actually contain clear definitions on what is considered necessary for an assessment to be deemed independent, nor do they contain sufficient criteria for the actual grading and evaluation of AI systems. Rather than relying on inadequate standards, New York can cement its status as a national and international leader in AI accountability and transparency by charting a new path forward. To strengthen this legislation, we propose eliminating this application and taking the opportunity to develop a comprehensive set of consistent regulations in consultation with experts, privacy advocates, and impacted individuals. We suggest that a more robust auditing infrastructure be developed either by the Attorney General or by a legislative commission whose convening would be set forth in this piece of legislation. In addition to these changes to the auditing standards, we believe that I am so sorry, running out of time. We want to ask for one clear clarification, which is we believe it's the drafter's intention that the reliance on Section 89.3C apply to both developer and deployer if the developer chooses to use if the deployer chooses to use the developer's audit. We just want to ensure that this relationship would not get them off the hook for liability.
Thank you. Do you want to go ahead?
Good afternoon, and thank you for the opportunity to testify today. My name is Marin Hurley-Matz, and I am an Equal Justice Works Fellow with New Economy Project, an economic justice organization based in New York City. We are here today because AI decision-making systems are already impacting nearly every facet of New Yorkers' lives, from surveillance pricing at the grocery store to banking and insurance underwriting. Yet these systems are being deployed with virtually no transparency, oversight, or accountability. Without strong regulation and enforcement, AI threatens to supercharge discrimination in consumer lending, debt collection, insurance, and hiring, magnifying racial inequities while making it even harder for New Yorkers to vindicate their rights. Unregulated AI increasingly functions as a tool that automates, scales, and intensifies predatory business models that systematically extract wealth from low-wage workers and communities of color. In recent years, financial technology companies have flooded our state with illegal, predatory, app-based payday loans that deceptively market no-interest cash advances, while in reality charging triple-digit interest rates through hidden fees, even though payday lending is categorically illegal in New York. Here's how AI is making these payday loan debt traps even more harmful. First, the apps require users to grant broad access to their bank account and financial data. Workers' data is fed into the app's proprietary AI underwriting system to determine if the user will be offered a loan, and if so, at what amount. This data is then continuously monitored used to continuously monitor workers' finances, predicting when their next paycheck will arrive and automatically debiting their accounts. But these predictions are often inaccurate, leading to premature debits that result in overdraft fees and cascading financial harms to the account holder. According to lawsuits filed by the New York Attorney General, these companies also use AI to push workers into more frequent borrowing, surveilling payroll and account data to determine when a worker might be struggling, and sending targeted alerts to incentivize taking out another high-cost loan. We are also seeing this emerging pattern in the debt collection industry, with companies already outlining plans to use AI to more aggressively pursue debts. Through our New York City Financial Justice Hotline, we regularly help low-income New Yorkers facing unfair and abusive debt collection practices. Exploitative debt collectors already mislead and harass people to coerce payments regardless of their rights under state and federal law. New AI-driven debt collection tools threaten to exacerbate these harms by enabling collectors to indiscriminately scrape publicly available information, predict who is most susceptible to pressure, and target those individuals more aggressively and more frequently. Without clear liability for discriminatory AI-generated decisions, debt collectors are poised to exponentially increase surveillance and harassment of New Yorkers. The Trump administration's attack on consumer protections and state AI regulations underscores the urgent need for New York to act now. The New York AI Act establishes baseline protections by giving the right to opt out of AI decision-making, requiring companies to provide information necessary to understand and appeal adverse AI-driven decisions, and creating a private right of action. The bill's audit and reporting requirements are essential to ensure AI systems are tested for bias and reliability, and its prohibition on AI social scoring systems addresses some of the most dangerous uses of automated decision-making. At the same time, the bill should go further. The notice provisions should require mandatory disclosures informing users of the risks of AI, companies' liability for discriminatory outcomes, and individuals' rights under the law. In addition, the 45 to 90-day investigation period for appeals unfairly burdens people facing time-sensitive harms and should be shortened. We look forward to working with the committee to address these concerns and strengthen the New York AI Act. The stakes could not be higher for working New Yorkers and communities of color. Due to the enduring legacies of bank redlining and segregation, financial services data is inherently biased. AI systems trained on historical financial data continue to reproduce and deepen racial disparities in banking and financial services. I'll just finish this point. And strong regulation and vigorous enforcement is essential to preventing AI from further entrenching these inequities. Thank you again for the opportunity to testify today.
Thank you. Thanks. Hi.
Should I just jump into it, or am I going to get Okay. Good afternoon, Chair Gonzalez and members of the Senate Standing Committee. My name is Stephen Choi, and I currently direct the Artificial Intelligence Community Engagement, or ACE, initiative. I began my career organizing and supporting immigrant and working-class New Yorkers at the Minkwon Center for Community Action, where I saw firsthand how policy debates often happen about communities, not with them. And then later I helped build coalitions at the New York Immigration Coalition, working alongside nearly 200 community-based organizations across the state. In recent years, as a consultant, I focused on building diverse coalitions that ensure that our most marginalized community members are represented in public policy decisions. And I'm here today to share a core message that AI legislation and the direction that New York State chooses, whether it's focused on innovation, regulation, civil rights protections, economic development, the most important value this body can affirm is that impacted communities must have a voice in shaping what comes next. Artificial intelligence is already influencing so many decisions that matter to New Yorkers: access to jobs, housing, education supports, and the list goes on. But many New Yorkers, particularly Black, Latino, API, Indigenous, immigrant, LGBTQ+ communities, people with disabilities, and low-income New Yorkers are often the first to experience new systems as subjects, not as partners. And that is why I urge the Senate to make a baseline commitment. AI policy must be built with communities, not merely presented to them after the fact. There's a challenge, though, and that is that many of the communities most impacted by AI are not familiar with it. People cannot shape policy on systems they have not had a fair chance to understand. And technological debates are often inaccessible by design, full of jargon and English-only information, and so that has to be remedied. If New York wants legitimate democratic governance of AI, we must invest in the capacity of communities to participate, and that is precisely what the Council's Artificial Intelligence Community Engagement ACE initiative is designed to do. We partner with 22 trusted community-based organizations across neighborhoods, languages, and cultures to deliver accessible AI literacy training and structured opportunities for community members to actually participate. So, what am I here to urge the Senate to do? I'm here to urge the Senate to embed community power as a non-negotiable element of whatever AI framework New York builds. And that means a couple things. One, make impacted community participation a foundational requirement of AI policymaking. That means engaging early and often, demanding that AI actors include community participation as a core part of their AI-related work, and ensure that engagement is designed for true inclusion. Number two, to invest in grassroots AI literacy statewide. If New York wants meaningful public engagement, it must fund community-based AI education delivered through trusted CBOs, like some of the organizations on this panel, so that marginalized communities can participate. ACE is one model that can be replicated and adapted, and we would welcome the opportunity to share our lessons learned. Third, ensure that marginalized communities are not only protected but positioned to benefit. AI policy should not only prevent harm, it should ensure that historically excluded communities have access to workforce pathways, support for small businesses, and deployment standards that prevent exclusion. New York has a chance to ensure that the AI companies that is trying to attract are also committed to providing real community benefit as well. And lastly, to build accountability, transparency and accountability mechanisms must be understandable and accessible. The state should prioritize systems where communities can know when AI is used, understand the basis for outcomes, and seek recourse when systems cause harm, and the New York AI Act is a critical step in this direction. New York has an opportunity to lead, and so I urge you to anchor your work in a simple proposition that communities most affected by AI must help shape the rules, safeguards, and opportunities that define its role in our state. And so I thank you for the opportunity to testify, and I welcome any questions.
Thank you so much, Steve. Again, appreciate all of the panelists hanging in there with us. Certainly appreciate the testimony. I'm going to jump into my first round, then open it up to my colleagues. I did want to start with Ronald and Steve, since you both represent the very New Yorkers that I also represent, but that we're really seeking to center in these conversations. We're talking about Black and Brown communities, lower income communities, immigrant communities that are particularly vulnerable. And so my question is just very simple. What is the impact on these communities if we fail to regulate at this time? Yeah.
Well, I would say the impacts are already being felt right now. When you look at the deployment of AI, it's impacting jobs, but it's also impacting housing, it's impacting education, and in so many ways it's being used by technologically sophisticated actors for their particular private benefit. And so I've built coalitions and I've engaged communities on many different issues, but I think one of the threshold problems with AI is that communities just don't understand. There's so much about AI that is a black box. And so before we are able to actually engage these communities in actual policy making, which I think is absolutely critical, we need to demystify AI. We need to have them understand exactly how AI works, what it can be used for, how it's being used right now. And so what I'm finding is that that threshold question of how communities understand AI, that's not being answered right now. And that is what ACE is trying to do on the city level. But I really recommend members of this committee think about how you can actually ensure that that engagement is happening. You've got to make sure that communities know about AI first and have a working knowledge, and then we've got to engage them.
Yeah, 100%. Mm-hmm.
I think I'll start with saying that historically, communities of color don't trust the system. We're struggling with the trust across the board. And I think it's hitting us in a lot of different ways because there's an educational component. And right now, even when we go into the schools, they're like, AI's bad. I'm like, wait, we need to do it responsibly. So it really sort of hones to the part of transparency and education. We need to embrace it, especially in these communities, because it is going to be a differentiator, because all it really does is accelerate your ability to do something. And if you have bad intent, it's going to accelerate that bad intent. So it's important to have a level of transparency and extend the same civil rights and transparency around those civil rights and extend that to AI to make sure that people aren't being hurt.
Civil rights law sufficiently covers the issues that come and risks that come with artificial intelligence. Do you agree with that? Do you disagree with that?
Unfortunately, I disagree with that. I think that it has to be, in that very example that I did in my use case of the testimony, I mean, the person literally just said, well, AI did it, right? And it's like, well, no, we have to consciously think about, I'm deploying something for a large utility, and if they allocate power to a certain space without recognizing that somebody with disabilities might have needed the power before. So it might do it equally, but it might not do it equitably, and we need to make sure that it's captured appropriately.
And then, not to keep you in the hot
Please.
seat, Ronald, you mentioned training data earlier, I believe, and I think that is one issue that a lot of companies are, not willing to take accountability for. Is that data sets are also inherently biased. Data can be biased, and so when you're training on biased data sets, then obviously the output is also going to replicate that bias. I'm curious, what your thoughts are there in terms of liability, if there needs to be action also on transparency and training data.
Yeah, absolutely. So believe it or not, the transparency is there internally. I think the transparency that we're requesting is making sure that that same transparency that the senior executives are wanting to see from the AI, I think also gets extended to the customer and the population. So I think that's probably sort of the biggest thing there.
Absolutely.
Cool.
All right, I do want to ask about workforce development and education because that came up earlier as well. We know that this is going to change the landscape of our workforce and the job opportunities that exist. Senator Hinchy, I appreciated the questions earlier on this. AI literacy is one tool in our toolbox. It is certainly not the only tool. We have some bills on this, but I don't think they're obviously exhaustive of all the options. So curious what your organizations might want to see in this space. Yeah.
Sure, I'm happy to start on that. As you said, Chair Gonzalez, AI literacy is important, and as my colleagues have already noted, there are many communities that are distrustful of AI, and with good reason. But AI literacy is not enough when right now people are not even aware that AI is being used. As a colleague on our prior panel said, that is step 0. We need the transparency, but also people should not be forced to engage with AI. You can be AI literate and choose not to engage with it. Many people do so, and that is why it's also essential for users to have the opportunity to opt out and the notice to do that. And then last, it is not enough for people who are AI literate to trust each and every decision without being able to verify what information was used to make that decision. We've already touched a little bit today on the many challenges with data that is used to train and the biases that are hidden within the data. And so it's essential that New Yorkers still have the ability to verify these decisions and use the private right of action to hold irresponsible actors accountable.
Accountability is a theme. I do want to turn it to stop. You mentioned joint and several liability is appropriate for artificial intelligence. We had a robust conversation around developer and deployer responsibilities earlier in the day, and would love to hear more about why that's the case and why that's your position.
We want joint and several liability between the developer and the deployer, basically because both parties ultimately are responsible for the AI systems that are in use. And we don't want to have either party shielded by the fact that it's a joint venture. And we think that when you are choosing to use, especially in the context of an audit, if you're a deployer choosing to rely on a developer's audit, we don't want that to shield deployers from the fact that the developer's audit may not be rigorous enough to actually remediate harms and bias that are embedded within the systems they're using. Does that answer your question?
Yes, that's great. I think those are, the major themes I wanted to hit on. Certainly there is a lot more I think the state can do, not only through the New York AI Act to hold the private sector accountable and shift the burden away from consumers, but on these developers, deployers, but really tech companies to do justice in our communities, but there's more we could be doing to invest in our communities. And so I just want to uplift the work that you all have already done as community-based organizations on the ground. And I know it's a priority for me in this committee to make sure you are funded to continue doing this work, because you are on the front lines, and we can have these conversations all day, but if we're not reaching everyday New Yorkers, it certainly will not go as far as we need to. So I want to thank you for your work. I'm going to turn it now to Assemblymember Otis for his first round of questions, and then open it up to the rest. Yeah.
So thank you. Thank you. I have questions for each of you. I'm going to start with NAACP, Mr. Thomas. What kind of confidence do you have, or have you looked at the issue of the ability of some of these auditing tools to actually properly analyze and call out bias in AI systems? I mean, it's a goal, but do we have the right tools to be able to really call that out?
Yeah, so I do believe that we have the right tools to call it out. I think that's why it's important to make sure that they're embedded and they're being used, and folks are accountable for using them, so that audit process being in play. Because they don't have to necessarily use that audit tool, and that's what sort of the problem starts to go. So it's really around intent and making sure that people are accountable for using them. But I do have full confidence in the tools.
Okay, very good. Now, to STOP, and thank you for all your great work. We love STOP. And a little more detail in terms of the auditing infrastructures out there, and in a sense, STOP's latest perspective on how you see the quality of auditing and the ability to do that.
So unfortunately, we don't really see there being a consistent and effective auditing framework that can really truly grade these algorithmic systems. As I said, with the NIST standards, many of the existing frameworks provide broad stroke aspirations, but they don't actually provide information on who counts as an auditor, how an audit must be conducted, or what constitutes an adequate finding. So there's no way of looking at these frameworks and seeing if an algorithm would pass or fail. You could run an algorithm through the framework from two different auditors and come out with different results. So we are advocating for a more rigorous and developed auditing framework that would really address what the criteria of passage versus failure would be in these contexts.
Does it exist out outside of New York? I mean, does it exist somewhere else in the country or in
Not
Europe?
consistently.
Yeah. Okay.
We think New York has the opportunity to really be at the forefront of the development of a framework in this field.
Great, thank you. Maren, for you, we had a hearing maybe a year and a half ago on fintech and technology, and really enjoyed hearing the horror stories in your testimony. So my question is, are there some areas in financial transactions where we should have either a bar or a moratorium on the use of AI to protect people?
I think that is a really important conversation to have. And yes, in areas like banking and financial services, but when we look at AI, it is spreading so quickly, and that is why the New York AI Act is important. In terms of a complete ban, that would be beneficial. We have heard so much from industry about how regulators should wait and see what will happen, but a wait and see approach is just waiting for harm to accumulate in order to take action. So in spaces like consumer lending, housing, tenant screening, other financial services, we do need a ban on AI in order to comprehensively address these concerns and develop these frameworks like Ms. Washington addressed to actually verify, audit, and address the great likelihood of harm that is obscured by these systems.
Very good, thank you. And now, Steve, to your things, I loved your testimony because something else, and Senator Gonzalez also, we have a relationship with a group called the New York State Digital Equity Network. And, sort of if you go back a few years ago, what they do is they train people, give them a device, give them broadband access, and train them on how to do all this stuff. But it sort of used to be those three legs. But in the last few years, the digital divide also includes ignorance about cybersecurity and ignorance about AI. And so those programs nationally are adding components to deal with exactly what you're talking about. So one of the things we'd love to do is to hook you up with that. It's a statewide group. They, I think, would enjoy having you involved with them. But your testimony is right on target, and in a sense, these, with the quick advance of AI, the gap for individuals that don't have these skills is getting larger with great speed. It's very concerning. So any additional comments on that?
Yeah, thank you for flagging that, Assemblymember Otis. And I've had some conversations with Senator Gonzalez, and I think what you all are pushing in terms of making sure that network is supported, I think is really admirable. One thing I would say is that AI is developing so quickly, and the usage of these by communities and many of the grassroots CBOs that work with them, we're just trying to catch up. We had a convening at the Robin Hood Summit around AI during the summer, and we brought 25 different nonprofit organizations that work with grassroots communities, including the NAACP together. And we asked a simple question. We said, how are your communities actually using AI right now? And so many of these organizations, whether they're settlement houses or local organizations, workforce development groups, community organizing groups, youth organizations, they had no idea. And so, you're facing a situation where so many of the trusted messengers are trying to figure out how they use AI internally, and then also have very little grasp about how their communities are using AI, and it's very uneven. There are some individuals who are using it probably for uses they probably shouldn't be using it for, but the lack of knowledge and the lack of understanding is such a key barrier on this particular policy issue in a way that I haven't seen for other issues because this is developing so fast. So I think absolutely the kind of the increase in AI literacy that your initiative is trying to do and some of these other organizations is really laudable and something I think needs to be supported in this year's budget.
Let's find ways we can work together on that. So thank you.
If I can add something?
Yeah.
So I just want to say that we are very behind, to say the least, and it is very easy to offshore these jobs for a lower price point, higher value, all across the board. So we have to be very specific and intentional in building the skills locally here, specifically in New York, to make sure that we can compete and the next generation can compete.
Thank you all.
Thank you. Seeing and hearing no additional questions, again, I want to thank this panel. This was the final panel of the day, so truly rounding us off on a really important note. I just, before we close out, I just want to say we heard a lot today from industry. We heard a lot of companies wanting to see inaction. And when we think about inaction and not passing any real regulation in artificial intelligence, the only people that benefit are oligarchs and big tech companies who get to continue to maximize their profit at the expense of all of our constituents and the people that you all represent. And all the while that they're asking for inaction, we are seeing our workforce and jobs get automated. We are seeing insurance claims get denied, instances of algorithmic bias. We are seeing IP stolen, artists, writers, reporters, their intellectual property literally being stolen and used to train models. And we are seeing our climate continue to be devastated with the rise of data centers. So we have to ask ourselves, and certainly ending here with the community, what our responsibility as a state is and what our ability is to act. Because not only do we have that responsibility, but we have the opportunity to pass real regulation. And we know that one bill isn't going to be enough. That this is just the start of what will have to be years and years of us working together. And that always starts on the ground. That always starts with our community. So I want to say an extra special thank you to our community partners and advocates for being here today. And I want to say a big thank you to my colleagues who have made it till the end, Senator Parker, Senator Hintry, Assemblymember Otis. To the staff, I want to say thank you to Senate staff and media, to my own team, Elon Silver, my chief, Katie, and everyone who made this happen. And truly, again, thank you to everyone in the room with us today who have made it to the end. I look forward to working with all of you on these issues. So with that, this meeting is officially adjourned. Thank you for participating.